ನಮ್ದು ಸ್ಟ್ರೀಮಿಂಗ್ ಆಗಿದೆ.
ಲೈನ್ ಇದೆ, ಅದೇನಾಗುತ್ತೆ ಅಲ್ಲಿಗೆ ನಂದು ಯಾರೋ ಫೋಟೋ ತೆಗೆದು ಕಳ್ಸಿದ್ವಿ ಹೆಸರು ಬರೋದು 20ನೇ ಕೋರ್ಟಲ್ಲಿ.
ಫೋಟೋ ಸರ್
ಸರ್
ಲಾಯರ್ಗಳಿಗೆಲ್ಲ ಜಸ್ಟಿಸ್ ಮಾಡಕ್ ಕೊಟ್ಟಿರಲಿಲ್ಲ.
ಆನರಲ್ಲಿ ಕೊಟ್ಟು ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅಡ್ವಾನ್ಸ್ ಆಗಿ ಎಲಿವೇಶನ್ ಮಾಡಕ್.
ಅದು ಹೇಳಿ ಮೂವ್ ಮಾಡಿ ಸರ್ 2ನೇ ತಾರೀಕು.
ಜಗದೀಶ್ ಇರೋ ಕೆ ಜಗದೀಶ್ ಅಂತ ಕೆ ಜಗದೀಶ್ ರೈಟ್ ಸಂತೋಷ್ ಹೆಗ್ಡೆ ಕೆ ಜಗದೀಶ್ ಅಂತ ಇದ್ದ ನೋಡಿದ್ದೆ. ಸಂತೋಷ್ ಹೆಗ್ಡೆ ಆಫೀಸಲ್ಲಿ ನೋಡಿರ್ತೀನಿ. ಕೆಮ್ಮಟ ಆಗ್ತದೆ. ಲೋಕನಾಥ್ ಇವರು ಬಂದ ಹಚ್ಚಿದ್ದೆ ಅವನು ಆಗ್ತದೆ. ಮಗನ ಮದುವೆ ಇಡ್ತಾರೆ ಇನ್ವಿಟೇಷನ್ ಕೊಟ್ಟು ಹೋಗೋಣ ಸಂಜೆ ಗಂಟೆಗೆ. ಸಂಜೆ ಹೋಗಿ ಮನೆಯಲ್ಲಿ ಫುಲ್ ಸ್ಲಿಮ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ಫುಲ್ ಸ್ಲಿಮ್ ಆಗುತ್ತೆ.
ನಮಗೂ ಸ್ಟೆಂಟ್ ಎಲ್ಲ ಅದ್ ತಿನ್ಬೇಡ ಇದು ತಿನ್ಬೇಡ ಅಂತಾರೆ, ಎಲ್ಲ ತಿಂತಾನೆ ಆರಾಮಾಗಿದೆ. ಇದನ್ನ ತಿನ್ಬೇಡ ಅದನ್ನ ತಿನ್ಬೇಡ ಅದು ಮಾಡ್ಬೇಡ ಇದು ಮಾಡ್ಬೇಡ.
WP Fresh Matter RSA.
Yes, 23rd. Pension. Yes, 18. Yes, 24th. Yes, 19th. Fresh matter. First time. Tomorrow.
Submission, my lord. ಇದು ಫೈಲ್ ಮಾಡಿ 10 days ಆಗಿದೆ. ನಮ್ಮ ಆಫೀಸರ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಕೂಡ ಆಗಿದೆ. ಬಟ್ ಸ್ಟಿಲ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡಲ್ಲ. ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇದೆ. ಕೇಸ್ ಕೊಡ್ತಾರನ್ನ ಕೇಳಿದ್ರೆ they are getting absurd reasons. So ದಯವಿಟ್ಟು
You go and give a complaint to that register. Yes, that will. Yes. Regularization. Which year matter?
21, my lord.
Yes, 23rd. Yes.
23rd.
What is that matter, madam? All is service only. Yes, 24th. Yes. Yes, 24th.
24th. Sorry, Girish. 24th.
Yeah. Yes, 11th. Yes.
11th.
Huh? Yes, 19th. No, it will not reach, Mr. Therefore, I am giving him yes. What is that matter, Mr.? Yes, 11th. Graduating, yes, 23rd, yes.
Submit ಮಾಡಿ sir, submit ಮಾಡಿ. ಎರಡು ಒಂದೇ.
Let us see if that identical matter is allowed, then you can. Yes, 23rd, yes.
My petition, my lord, notice has been issued. It's a matter of promotion. They are holding interviews tomorrow, my lord. Ultimately, I have to.
No, yes, 4th.
My lord, the interview is tomorrow, my lord.
Let it be go. Yes, third, let us see. Huh?
My lord, the interview is tomorrow. my
No,
lord.
interview for what?
For the promotion.
Let him give. If you succeed, you will get it from the.
He's not in the list, my lord. That is the problem.
No, if you succeed, you will get it all benefit from the date your junior has been promoted. Why do you worry?
Oh, my lord, there is a matter in the list where the the qualifying service has not been taken into consideration.
I saw all that will be seen in the merit on 4th, yes. If you succeed, you will get it back all benefit, Mr. Yes. Departmental inquiry, 24th, yes. Yes, 24th.
Selection matter of the year 22.
In which post?
Lecture.
Lecturer. Yes, 16th.
Case of termination, my lord, without inquiry. That was heard for some time.
Which year?
2023.
Yes, 18th.
The matter is pertaining to judicial observance. Argument is over. My senior Counsel P.S. Rajgopal argued the matter in this entirety. Only reply to the other side. The 2nd of February. It's a judicial observance.
Then nobody is argued on. No, he has not argued.
Earlier bench ಅಲ್ಲಿ ಇದ್ದಾಗ ಮಾಡಿದ್ದಾರೆ ಸರ್. Second of February. Only reply to the other side clarification.
Yes,
Everything is over.
10th.
Second ಅವರು insist ಮಾಡಿದ್ದಾರೆ senior counsel.
Second, you
Just
have fixed.
5 minutes ಅಷ್ಟೇ ಇದೆ.
Second, you have fixed so many other matters.
Take a chance or otherwise urgent matters.
Second, it will not reach. If you want 4th,
Please.
4th, yes.
The retirement benefits.
Pensionary matter, yes, 16th.
ರಿಟೈರ್ಮೆಂಟ್ ಬೆನಿಫಿಟ್ಸ್ ಇದರಲ್ಲಿ ಅವ್ರು ಸತ್ತೋದ್ರೆ ಅವ್ರ ಹೆಂಡತಿಗಾರು ಬರ್ಲಿ ಅಂತ ಕೇಳ್ತಾರೆ.
Retirement
ದಯವಿಟ್ಟು
benefits.
madam ಅಂತ ಕೇಳ್ತಾರೆ.
Yes, 3rd.
Pending matter, B group, pending matter.
B group, 25th, yes.
My lord, BML gratuity matter, your lordship has, yesterday Naganand has given a judgment.
Yes.
A reply I have served him, my lord, reserved, my lord.
Yes,
Reply I have giving about the judgment.
yes.
Reserved.
Matter pertaining to 2021, my lord. Yours have heard the price, my lord, regarding refund of amount, my lord, under the Supreme Court order, Rafiq Mais, lordship able to allow the, my lord, the other side took time, my lord. Twice your lordship has heard, last time you are sitting, my lord.
Yes, 12th.
Another matter is there, my lord, 2022.
Matter is on 25th, yes.
Please.
This matter, 2022, PF ಬಂದಿಲ್ಲ ಅರ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀವಿ.
Yes, 19th.
Matter pertaining to seniority.
Seniority is 23rd, yes. Number 2, mediation drive on 3rd. All list number 2 will be referred to mediation. on 3rd.
Adjournments, if any, in list number 1, adjournments.
My lord, item number 74, my lord, in list number 1, and the respond number 2 in this case, my lord. I have informed the other side also. Another matter is listed as 11, my lord. Kindly have it on 11, my lord. Next month.
74,
Yes, my lord.
yes. Leave this
My lord.
matter.
My lord.
For the petitioner, 70 petitioner. For petitioner in this matter.
You
Interim
are appearing
order.
for whom?
I am appealing for the respond number 2, my lord.
Hmm.
They want an extension of interim order, and it may be have it on 11, my lord. Another matter is there, my lord.
Yes, please, matter on 11th. Interim order
My lord.
granted earlier, it is this.
Much obliged.
Serial number 42. Serial number 34, my lord. There is one matter related to Supreme Court also. Kindly short accommodation.
You are appearing for?
I'm for petitioner.
Yes, at the request of counsel for the petitioner. Yen matter?
My lord,
What is that in Supreme Court? 2015 matter, Mr.
I'll inform next year.
Yes, at the request of counsel for the petitioner, leave this matter next week.
My lords, serial number 42. I am for respondents, my lords. We have informed the petitioner, my lords. Kindly a short date may be given, my lords. Any day.
The request of counsel for respondent number
8, my lords.
8, leave matter next week.
Appearing for respondent in the
Number 58, my lords.
58.
Appearing for respondent, petitioner is also here.
For petitioner.
Raise at 2 weeks' time, my lords, to file our objection.
You are appearing for respondent.
Yes, my lords.
Yes,
For
who is for?
Petitioner.
serial,
Yes, at the request of respondent, leave this matter after 2 weeks.
serial number 7.
Serial number 38 and its batch matters, my lords. That is regarding the revision of pensions. Lords, today there is bit inconvenience for the senior. May I request for next week?
Yes,
For the
at
petitioner.
request of counsel for petitioner, leave this matter next week. Yes.
Serial number
Interim order
7.
there in the all the matters. Lords.
Who is other side?
I have informed the contesting respondent to
Order
universities.
granted earlier, if any is extended till next date of hearing.
Please, my
This
lords.
matter after 2 weeks.
Please.
Serial number 75, my lordship. Appearing for the respondent in the matter.
For the petitioner in this matter, my lord.
I informed short accommodation can be given, my lordship.
Matter pertaining to regularization, my lord.
75.
75 and 84.
75 and 84.
You are appearing for?
Respondent in.
And for the petitioner, my lord. It's matter pertaining regularization, madam.
ಎಲ್ಲ ರೆಗ್ಯುಲರೈಸೇಷನ್ ಎಲ್ಲವೂ ರಿಜೆಕ್ಟ್ ಮಾಡಿರವೆ ಎಲ್ಲವನ್ನೂ we have to be heard.
This is a covered by. Similar matter was allowed.
When do you want?
After 10th of February, my lordship.
Yes, leave this matter on 16th.
Yes, please.
Interim
my-
order maybe.
Interim order granted earlier is extended till next date. of-
Apply.
Much obliged.
54,
My lord, serial number 37.
54. I am respondent.
For the
Petitioner is there.
54.
Weak accommodation order.
Who is petitioner? Yes, at the request of
Interim order.
counsel for the respondent. Leave this matter next week. Interim order granted earlier is extended till next.
Serial number 37. my lord. We have to file rejoinder, my lord. They
I am for-
filed objection.
I am for respondent.
Kindly any short
You are appearing for
petitioner.
petitioner. Yes, at the request of counsel for the petitioner, leave this matter after 2 weeks.
37.
Please.
Yes.
Interim order.
Order granted earlier is extended till next date of hearing. Yes.
Serial number 66. I am for respond number, I filed my wakalat yesterday on behalf of respond number 3 and 4, my lord. I undertake for respond number 2. Some time may be given for me to seek instructions and file my objections, my lord.
You are appearing for?
For R2, R3 and R4, my lord. On the last date notice was issued.
Have you informed?
No, I have not informed, I will inform, my lord. I undertake
No,
to file
first you have
wakalat
to
for R.
inform them. Then you have to seek, mister. Yes, you informed and move at 1:30. Yes.
Correct.
Just now I had mentioned, my lords, serial number 41, my lord. Kindly a short accommodation may be given, my lords. We have informed the petitioners.
What it says?
For respondent number 8, my lords. Just now I had mentioned.
41.
41.
Respondent 8 ಇಲ್ಲ sir. ನಂಬರ್ ತಪ್ಪಿದೆ.
41 ಅಂದ್ರೆ
42 ನೀವು ಹೇಳಿದ್ದು. List number 1 for preliminary hearing, serial number 1, Narendra Gowda for petitioner, government advocate.
What is this, mister? None appear for the petitioner. Leave this matter in B group.
Last hearing, my lord, this honorable court directed me to file affidavit. Accordingly, I have filed affidavit.
Yes, I B group ಅಲ್ಲಿ here.
Please.
Yes, leave this matter.
Serial answer. Serial number 2, BB Vidyulata for petitioner, Pradeep S. Saukar.
My lord, I appear for respond.
I appear for the petitioner, my lords, in this matter. Similar matters has already been disposed by this honorable court, and the matter is pending before the appellate court, my lord, before in the writ
We are
appeal.
yet
my
to
lord.
receive instructions in this matter, my lord. We will file our objections, my lord.
No, that it's pending in that appeal. Then we will hear after that disposal of that appeal.
Yes, my lords. By the time my learned friend, if he needs to, they will be bound by the writ appeal order.
Yes, least
Please, my lord.
least in that B group. Leave
Please.
this matter in B group.
Serial number 3, Sri Rama Reddy RV. Serial number 3.
I appeal for the petitioner. The first petitioner is the wife, and the second petitioner is the married daughter of one Vinko Rao, who was working as a gangman, road worker, in respond number 5, assistant executive engineer, Jilla Panchayat, Ramnagar. He died on 23/12/2013. That's it.
Jilla Panchayat.
My lord?
He was working in the Jilla Panchayat.
Yes, yes, ma'am.
Working as in what?
As a gangman, gangman, road worker.
Gangman. Yes.
He died while in service on 23/12/2020. I have a producer. Death certificate annexed EAP.
23/12.
2023, 2013.
2013. 13.
The first petitioner, who is a handicapped woman, she is depending on only her 2 daughters. She gave a petition to give appointment on compassionate ground to second petitioner, Bharti Bai. The petition dated 25/9/2014 at Annexure B.
Annexure B page.
And he also gave a number of petitions.
ಹೆಣ್ಣು ಮಕ್ಕಳು ಇರ್ತಾರೆ, ನನ್ನ ಗಂಡ ಕೆಲಸ, ನನ್ನ ಎರಡನೇ ಮಗಳಾದ ಹೊರಬಾಗಿ so on. ಆಮೇಲೆ ಏನಾಯ್ತು?
ಆಮೇಲೆ as per Annexure C, ಅವರು dated 15/10/2014, they gave endorsement as per Annexure C stating that married daughter is not entitled for appointment on compassionate ground. Now the rules are amended.
No, that you can wait till that rule has to be amended.
Amend ಆಗಿದೆ.
ಆಯ್ತು ರೀ, ನೀವು ಯಾವಾಗ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರು? 2014.
ಹೌದು.
ಮತ್ತೆ ಈಗ after 10 years you are challenging that rule is amended.
ಅಲ್ಲ, ಕಂಟಿನ್ಯೂಸ್ ಅಲ್ಲೇ ಡೈಲಿ ಬೇಸಿಸ್ ಅಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಕೊಡ್ತೀವಿ ಅಂತ.
Now that what is the age of the petitioner?
on the date of application ಕೊಟ್ಟಾಗ she was ಇವಾಗ 37
Not be, it is rejected, Mr. After 2014, you have to wait for that. After another 2 years, rule will be amended. If the person who is appointed contrary to the rule, then can be removed.
ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿದೆ ಸರ್.
ಆಯ್ತು ರೀ, ಗೊತ್ತಿದೆ ರೀ, ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿದೆ. 2014 ಅಲ್ಲಿ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ರೂಲ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಯು ಕೆನಾಟ್ ಕಮ್. ಯು ಕುಡ್ ಹ್ಯಾವ್ ಬೀನ್ ಚಾಲೆಂಜ್ ದಟ್ ಟೈಮ್ ಇಟ್ ಸೆಲ್ಫ್.
ಅಲ್ಲೇ ಡೈಲಿ ವೇಜಸ್ ನೋಟಿಸ್ ಆಗ್ಲಿ ಸರ್.
ಯು ಹ್ಯಾವ್ ಟು ಬಿ ಕಂಟಿನ್ಯೂ ಆಸ್ ಎನ್ ಡೈಲಿ ವೇಜಸ್.
ನೋಟಿಸ್ ಆಗ್ಲಿ. ನೋಟಿಸ್ ಆಗ್ಲಿ ಸರ್. ಏನು ಕೊಡ್ತೀವಿ ಅಂದಿದ್ದಾರೆ.
Government advocate is directed to take notice 1 to 3. Issue emergent notice to 4 and 5.
Serial number 4, Janardana G. Serial number 4.
Petitioner, the earlier round, even the Act 7 has been already quashed. So was not joined earlier. Because of that, she has denied the all promotion, even though lecture C, the government, the college has recommended.
To take notice?
Yes.
Government advocate is directed to take notice for. It is a government polytechnic.
Yes, madam. It is not a government polytechnic.
Private, yes.
It's not a private government, but aided.
Yes, 1 to 3. Directed to serve 3 sets of copies. Issue emergent notice to respondent number 4.
Serial number 5, Srinivasa K.
The petitioners are working as sanitary workers, my lord, under the respondent company. They have sought for absorption of their services since they have been working, my lord, for the last 25 to 30 years. But the similar cases, my lord, are posted on 4th of this next month, my lord. This matter was also connected to the.
Government advocate is directed to take notice.
Respondent
number 1. Who is that counsel?
Rakshita DJ.
Rakshita DJ is directed to take notice for respondent number 2 to 5. Counsel for the petitioner is directed to serve 3 sets of copies on Rakshita DJ. Is this matter along with that?
4th February.
Is this matter on 4th?
Number. Serial number 6, Kavita D for petitioner.
Lord, this petition for consideration of representation, my lord. They have issued suspension order in the month of 16/9, my lord. Till today, they have not conducted a departmental inquiry. To conduct.
Where you are working?
I'm working in Halli, Mysore, and as a procurement officer, my lord.
Karnataka State Cooperative Marketing Federation. Registered under the Karnataka Cooperative. Is it private cooperative societies or?
No, my lord, it's aided.
Where is that?
Suspension order is on annexure N, page number 78, my lord.
Annexure?
N, page number 78. Karnataka Sahakara Marata Mahamandali Nimit.
Yes. What was he?
He was a procurement officer, my lord. He's a deputy to procurement officer for Halli, Mysore, my lord. There, the computer operated has played fraud and 578 kilo of ragi has been.
Yes, issue notice.
Serial number 7, Muthu Rangappa.
For the petitioner, my lord, petitioner is the wife of the Shotraju, who died on 4/1/24, my lord. And his services have not been regularized since he was on unauthorized return, and she is seeking for compassion appointment and the settlement of family pension, my lord.
No, he is not a permanent employee.
No, my lord. He was a permanent employee. He was
Not
posted
regularized antira matte annexure A another.
My lord, annexure A is the endorsement given by the fourth respondent, my lord.
What is that endorsement?
So since he was working very originally in GKVK, and after the formation of Horticulture University, so he was directed to report before the Horticulture University, Bagalkote, my lord. During that period, he could not report because of chronic disease, my lord. So since he was not reporting before the Bagalkote, in the meanwhile, he died during the course of that period. So now she is seeking compassion appointment and settlement of family.
Government advocate is directed to take notice for respondent number 1. Kaushal is directed to take notice for 2, 4 and 5 ಅವರೇ ಅಲ್ವೇನ್ರಿ?
4 and 5.
No, GKVK administrator, GKVK Bangalore.
2 and
Administrator is 2 and 4 is Kaushal.
2
5 is.
5.
Vice Chancellor ಯಾರು? Horticulture University. Government advocate is directed to take notice for respondent number 1, issue emergent notice to 2 to 5. Yes, let us.
Serial number 8, Vijay Raghava Sarvati, HM for petitioner.
Yes.
So the first petitioner society runs an ITI college, which is a grant in aid institution.
Yes.
The second petitioner is promoted to the post of principal in pursuance of retirement of the existing principal in 2024 itself. Proposal is also submitted to the government.
Yes.
And as per requisition, it is the management who is supposed to pass an order for promotion, followed by the approval. I request your lordship kindly take the rules, page 42. Annexure K. Request your lordship kindly take page 54.
Yes.
Subclause 13, the last portion.
Yes.
The management may fill up the post of principal by promotion as per the cadre and recruitment rules of Government of Industrial Training Institution. The management may take recourse to direct recruitment for those posts which are to be filled up by promotion only if none of the existing employees considered adequately qualified or experienced. Since the second petitioner is the only person who is working as a turning officer, from turning officer there is a promotion for principal. There is no from JTO, there is no. Only if the college has turning officer, then he is eligible for promotion. Accordingly, he has been promoted.
Where is that C&R says?
It is says. This is what I am placing the rules itself.
No, see, rule says person who is eligible to be promoted.
See, other next 14 alla barutte. Your lordship get it.
Yaar eligible idare annadಕ್ಕೆ.
The promotion shall be subclass 14, your lordship. The promotion shall be based on seniority and eligibility. In all cases, the promotions, the inter-se seniority of employees and reservation policy shall be observed. All promotions must be preceded by screening committee to be formed by the management and to be the head of the president of the head of the management. There is no dispute as regards to the seniority of the.
No, there is no. See, I am saying that you are working as an what?
Turning officer.
Turning officer is the feeder cadre for a promotion to the principal. Where is it?
And promotion order letters. Lordship get it, page annexure F, page 36.
Yes.
I have been promoted from JTO to turning officer. Serial number 1, Altaf Ul Sharif.
Yes.
ಹಿರಿಯ ತರಬೇತಿ ಅಧಿಕಾರಿಯಿಂದ ಮುಂಬಡ್ತಿ ಅಂದ್ರೆ ತರಬೇತಿ ಅಧಿಕಾರಿ ಟರ್ನಿಂಗ್ ಆಫೀಸರ್ಗೆ.
Yes.
From turning officer, it is only principal.
ಅಲ್ಲ ಟರ್ನಿಂಗ್ ಆಫೀಸರ್ ಪ್ರಿನ್ಸಿಪಾಲ್ ಗೆ ಪ್ರಮೋಷನ್ ಅಂತ
ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ನನ್ಗೆ ನನ್ನ ಹಿಂದೆ ಇದ್ರಲ್ಲ ಅವ್ರದ್ದು ಪ್ರಮೋಷನ್ ಹಾಕಿದ್ದೀನಿ.
C&R ಅಲ್ಲಿ ಇಲ್ವಾ ಅದು?
ಅಲ್ಲ ಇದೆ. This is what I request annexure E.
Then what has happened now?
Now there is under the rules also there is provided for transfer from management to another management. Rule 23, I request your lordship kindly take page 56.
Yes. Yes.
Last 23. Transfer of aided employees allowed based on the following different circumstances, namely transfer between one aided institution to another aided institution subject to consent by both the managements. Now there is no requisition to the petitioner management and there is no post which is available.
Other person
has been promoted. Annexure A without even consent. When my proposal ತಾವು ಕೇಳಿದ್ರಿ lordship, where is that proposal which is sent to the authority?
Who has been transferred to there?
Now respondent number 6.
No, where is that reference? 24 page. What is his name?
That reference annexure A, your lordship get it. Page 24.
Yes, 24.
Last block ಅಲ್ಲಿ ಅದೇ ಇದರಲ್ಲಿ tabular column ಅಲ್ಲಿ.
Yes.
ಉದಿಯಾಂಡ ನಂಜುಂಡ ರವಿ ಪ್ರಾಚಾರ್ಯರು ರಾಘವೇಂದ್ರ ಕೈಗಾರಿಕಾ ತರಬೇತಿ ಸಂಸ್ಥೆ 9ನೇ ಕ್ಲಾಸ್ ಸೋಮಶೇಶ್ವರ ತುಮಕೂರು ಶರಾದಲ್ಲಿ ತೋರಿಸ್ತಾರೆ. ಶ್ರೀ ಶಿವಪ್ರಕಾಶ್ ಹಿರೇಮಠ್ ಪ್ರಾಚಾರ್ಯರು ಇವರು.
What is that upper column?
ಯಾವುದು?
That is it related to some other persons also, this annexure?
ಹೌದು. ಯಾರ್ಯಾರ್ದು ಏನೇನು ಅಂತ ಅಲ್ಲಿ.
Yes.
ನಮ್ದು ಬರುತ್ತೆ.
Issue notice. Government advocate is directed to take notice for
1 to 5.
Respondent 1 to 5. Issue emergent notice to respondent. 5 is government.
How the
case.
government?
Yes, council is directed to serve 3 sets of copies on government advocate. Issue emergent notice to respondent number 6. Stay of annexure A only in respect of petitioner and respondent number 6 respondent.
6 respondent transfer.
Yes.
Obliged.
Till next date of hearing. IA for dispensation. Yes, dispense for a period of 4 weeks.
Serial number 9, Raghavendra G. Gayatri for petitioner.
Appear for the petition. Subsistence allowance for my lord.
Dispensation of annexure J for a period of 4 weeks. 2 is allowed. Dispensed production of typed copy of so and so annexure. Yes.
Subsistence allowance during the period of suspension.
Not
Yesterday,
granted.
one more matter, your lordship already issued notice.
Yes.
B. Pramod is directed to take notice.
Pramod is directed to take notice for respondent number
1 to 5. My lord.
1 to 5. Council is directed to serve 3 sets of copies.
Connect along with WP 2155 of 26. My lord.
All this matter along with that so on. Yes.
Serial number 10, Manjunath Rao Bonsle.
For the petitioners, my lord. Petitioner seeking mandamus to the respondent to dispose of their representation, my lord.
For what?
And, for granting the benefit under the 7th pay commission, my lord. The coordinate bench of the Solemn Court, my lord, is allowed the earlier batch of the petitioners, my lord. And the director.
All working where?
Yes, my lord.
ಎಲ್ಲಿ ವರ್ಕ್ ಕೆಲಸ ಮಾಡ್ತಿದ್ದೀರಾ?
No, retired person.
No, earlier you are working in which
You
department?
are also you are working as a serious in the they are court employees, my lord. They are court employees, retired court employees. In respect at corporation, my lord, the Solemn Court has disposed of the writ petition. Given the direction to the respondent to dispose of their respondent, a similar representation has been given, only changing the address, my lord.
No, you are all employee of that district.
Yes, a district and
You
small
have
cause
not
court.
made High Court as party here.
No, my lord, only government has to consider our representation, my lord. You are not given any representation, but copy has been furnished to the serious the respective court, my lord.
No, that is true. That yes, Mr. What is this?
Copy has
Is
been
it,
already served, my lord.
covered. You verify. We can. Yes. Respondents to direct a consider representation on annexure. Soon as possible appropriate order in accordance with. Yes. This writ petition. Petitioner has sought following relief. The case of the petitioner that they are retired judicial. They are retired. What is that, Mr.?
Retired as a serious additional serious and bailiff.
They are retired judicial department service.
Yeah, service.
Now, what are that?
Their designation, my lord.
Employee.
First petitioner is serious my lord. Second petitioner is a senior serious and another is a serious and superintendent, my lord, fourth one. Fifth one bailiff. Fifth, sixth, seventh, eighth are bailiff, my lord.
Retired employee of the district judiciary in different cadre. They are retired on superannuation from 1/7/2022 between 1/7/2022 to 31/7/2024. The state government has accepted recommendation of the 7th State Pay Commission report and passed that government order on 22/7/2024. Therefore, petitioner also submitted a representation. Where is your representation?
Annexure B, my lord. Page number 21. One of the petitions has been furnished, my lord.
ಬಾಕಿದರ್ಗ
ಬೇಕಾದ್ರೆಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ, ಅದು ಎಲಿಮೆಂಟ್ಸ್ ಆಗುತ್ತೆ ಅಂತ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ. ಐ ಹ್ಯಾವ್ ಸ್ಟೇಟೆಡ್ ಇನ್ ಮೈ ಪಿಟಿಷನ್, my lord. Annexure B, my lord.
For implementation of 7th Pay Commission to that petitioner. Since they submitted a referendum B dated 30/6/2025. Since their representation is not considered, they are before this court. Learned counsel appearing for petitioner has submitted that in identical matter, this court in the number 19856 of 2025 and connected matter disposed of on 14th November 2025 has directed that respondent to consider that representation within 8 weeks from the date of receipt of copy of this order. Government advocate has not disputed that same. In view of the above writ petition is disposed of, directing who has to consider, Mr.
Both, both Chief Secretary as well as the Additional Chief Secretary
are directed to consider that representation submitted with the petitioner with annexure B in accordance with law as expeditiously as possible, not later than 3 months from date of receipt of copy of this. Yes, government advocate is directed.
8 weeks we can continue, 3 months of the 8 weeks. Early 8 weeks.
Yes.
Cell number 11.
8 weeks al madli first nodana. Yes.
ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದಾರೆ ಹಾಗಾಗಿ.
Cell number 11. Ingalagi Kotappa.
Yes, where is that? Ingalagi Kotappa. Pastor, who is that counsel? Yes.
Cell number 12. Parmeshwaraya DC.
Case. Dear petitioner, seeking for mandamus matter. Consider the proposal sent by the DDP Shumaga as per annexure real milad.
What is that?
Please, milad, the petitioner is appointed as a SDA under compulsion bond appointment, milad. See, in the year 2022, milad.
Where?
At milad Sarvodaya MS Ramaya Sarvodaya School, Shumaga. That was sent to the authorities, my lord, for approval. Meanwhile, my lord, one Asha has filed the writ petition before the sample court, my lord. The sample court, my lord, heard that, my lord, this writ petition is not maintainable because of, my lord, it is communication between the two department. Then, my lord, after disposal of this writ petition, my lord, the secretary again sent the proposal to through proper channel, BO Shumaga. Then BO Shumaga returned back, the proposal sent to deputy director as per annexure K. Then the deputy director Shumaga has sent the proposal for approval, annexure L on 25/11/2025. Page number 26.
Proposal for what?
For approval of the post, as a SDA under compulsion bond appointment.
Annexure?
L, page number 26.
L.
Till today, they have not acted upon that, petitioner before this court.
Yes. Heard. To notice. Government advocate is directed to take notice for respondent number.
All the respondents.
1 to 4. Counsel for the petitioner is directed to serve. Reset. What is that earlier petition filed by that Asha?
Please, my lord. Annexure.
She has filed a petition for what?
For, my lord, challenging our proposal, my lord, sent to the department. It is not maintainable. That's why, my lord, this sample court, my lord, page number 19, my lord.
Yes.
Page number 19, annexure H.
To emergent notice, government advocate is directed to take notice for respondent. Directed to serve 2 sets of copies on government advocate.
Kindly fix the date, my lord, seeking for mandamus.
Barley. Yes.
Cell number 13. Narayana, yes.
Petitioners, my lord, petitioners are seeking mandamus to consider their representations, my lord. They are working as superintendent engineers. Now a proposal was sent for selection to the chief engineers from PWD department alone, my lord.
You are working where?
We were earlier in PWD department, my lord. Now they are working in irrigation department. Now as per the KPSC regulations only, they have been appointed. Subsequently, they were absorbed in irrigation department. Now they are eligible for chief engineer post. Now the recommendation was sent only for
KT.
only for mandamus, my lord.
Even mandamus also you have to go to the KT. Writ is not maintainable.
226, my lord. We are not seeking any relief, my lord. Only we have given the representation to the respondents. They have not considered. For that, my lord.
Even if I disposed of that similar circumstance, the division bench has allowed that appeal set aside in the single judge order because it has to go to the KT. That has been challenged in that Supreme Court. Supreme Court has upheld, Mr. It is also from our High Court. Why do you want to take that risk? Even if it is allowed tomorrow, challenge, it will go. You go before that KT, Mr. Single judge cannot decide that it's a original first jurisdiction is to that KT.
There is no any adverse order, my lord. Therefore, we are.
No, that is
before
what
this
that
honorable
recent Supreme Court held, Mr. Yes. At outset, government advocate submits that matter in dispute in respect of civil post. Petitioner has to approach Karnataka Administrative Tribunal. The writ petition is not maintainable. In view of judgment of apex court in so and so, the above writ petition is disposed of, reserving liberty to the petitioner to approach KSAT in accordance with law. Yes.
Admission matter serial number 14, YK Narayana Sharma for appellant, Umesh BN.
The matter has already been admitted, my lord.
Yes, admitted.
It's already been
Substantial
admitted.
question of law is framed.
That has been framed, my lord.
Yes, then why it is come?
It's on 17/1/2025, my lord.
Heard the learned counsel following substantial question of law. Admit ಇದೆಯಲ್ಲ ಮತ್ತೆ post this matter.
I have to file paper book. Kindly give me
You have
4.
not filed the paper book.
I have to file paper book. I'll file a paper book.
Yes, matter is already admitted. No, because of IA ಅದೇನಾರು post ಮಾಡಿದ್ದಾರೆ. IA 1 of 2021 will be considered along with that main
That has
matter.
already been allowed.
IA allow ಆಗಿದೆಯಾ?
Allowed. On the same order.
ಹೌದಾ?
It was IA 1/21 is allowed.
Yes. This court. ಮತ್ತಿಲ್ಲ. Post this matter in final hearing.
Serial number, for order serial number 15, Jagan Mohan MT for petitioner.
Yes, 1 week time, my lord. Because I have to produce the certified copy of annexure N. How you got the annexure N?
ಅದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನೋಡಿದ್ದೇನೆ. That office objection will not come in the way of disposal of the writ petition. There is no merit in writ petition. 21 matter ಅವ್ರು ಇವತ್ತು ಹಿಂಗೆ ಟೈಮ್ ಲಾಸ್ಟ್ ಟೈಮ್ ತಮ್ಮ ಹತ್ರನೇ 3 ಸಲ ಬಂದಿತ್ತು.
ಏನು what is their matter?
Only the allow special allowances was are sought for from the petitioner as working as assistant medical officer. So university has issued an endorsement saying that there is no provision for special allowances.
And argument ಮಾಡ್ತೀನಿ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಕೊಡಬೇಕು ಅಂತ ಇತ್ತು ಅದನ್ನ.
Under which law you are entitled for that special allowances?
I will sufficient kindly 1 week time may be granted.
Or say otherನೇ if you make out any case we will consider that. What is that certified copy?
Office objection overrule ಮಾಡಿ ಸ್ವಾಮಿ ಅದೇನು ತೊಂದ್ರೆ ಇಲ್ಲ.
Specific within the relevant.
ಇಲ್ಲ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಕೊಡಬೇಕು.
ಬೇರೆ ಸರಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿದಾಗ ಓವರ್ ರೂಲ್ ಮಾಡಿದ್ರೆ ನಾಳೆ ಈ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ has not been produced. How can that be quashed, mister? We will dismiss it that non-compliance of office section for 6 times.
1 week time. Last chance 1 week time produce ಮಾಡ್ತೀನಿ ಇದೆ.
Finally, week's time is granted to comply office objection. If office objection is not complied within 1 week, without reference to the court, the writ petition will be dismissed.
Please.
Then you have to go to that.
He is working in Kolar.
ಆಯ್ತು ಅದೆಲ್ಲ ನೋಡೋಣ ಅವತ್ತು. ಇಲ್ಲ ಅಂದ್ರೆ ಈ ಒಂದು ವಾರದಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಗ್ತದೆ.
Serial number 16, VS Nayak for petitioner.
Appearing for the petitioner, my lord. It is a case of court fee to be paid individually.
Yes, where is that judgment?
Judgment, my lord.
In view of judgment of division bench of this court. The office objection is overruled. Judgment this court in writ appeal 5802 of 2012 disposed of on 14th November 2013. Office objection is overruled. ಇನ್ನೊಂದು ಯಾವ್ದಿದೆ court fee ಮತ್ತೆ beneficiary court fee to be made. Yes, that's all. Office objection is overruled. Yes, what is this matter?
The matter is regarding implementation of pay scales of 2007.
Yes, issue notice.
Earlier, this honorable court had directed that to give a representation to the first respondent.
Yes.
The first respondent has rejected the reference.
Yes. Now we will issue notice.
Okay.
Yes.
Number 17, Anusha L for petitioner.
My lord, serial number 17,
Hmm.
as per the direction of this honorable court, the service of the petitioner is regularized, my lord. I'm placing the memo.
Service
Service of the petitioner has been regularized, my lord.
regularized.
Please.
That is what that they have to be reported. Yes.
Regularization has already been done. That order was not given effect. Now if they have given effect, my lord,
17/1/2026, my lord.
17/1/2026.
Now that
Your lordship may have it next week, so that meanwhile let them settle all benefits.
yes, at the request of counsel for.
ಒಂದ್ಸಲಿ ಡಿಸ್ಪೋಸಲ್ ಆದ್ಮೇಲೆ ಅವ್ರಿಗೆ ಏನು ಸಿಗಲ್ಲ.
Let us see that. Yes, leave this matter next week. Yes. ಅದಕ್ಕೆ ಇದರಲ್ಲಿ ಫೈಲ್ ಮಾಡ್ಬಿಡಿ ಕೌಂಟರ್.
Please.
Yes, because there is a direction.
Serial number 18, Mulimani Basavaraj for petitioner. Government advocate, Sunil Desai.
My lord, I appear for the, my lord, I appear for the respondent. My lord.
Yes.
Last to hear this on for vacating stay.
Yes, what is this,
My lord,
Mr.
this is the case, my lord, wherein, my lord, this is a guest lecture, my lord. Your lordships kindly take note, my lord, the prayer in the writ petition, my lord.
Yes.
The prayer in the writ petition is, my lord, to quash annexure C, that is 9(5), my lord, the annexure C, if your lordship see, my lord, this is a guidelines which has been issued for the purpose of, my lord, the selection of a guest lectures, my lord, on
Yes.
a recruitment process. My lord,
Yes.
in pursuance of that, my lord, there is a notification for the application from the.
No, your voice is not clear, mister. You wait, what is this, madam? What is this? Notification for?
Calling for the post of guest lecturers.
Yes.
And this is of the date 9/5/2025. I think this is being implemented, my lord. Therefore, my lord, that filed an impeding application. Being response.
No, that who are the petitioners?
The petitioners are also their guest lecturers.
Now that who is that impleading applicants?
They have filed an application on 4/1/2025. Include the name of allotted school in respect to the judge's selection. So they've been selected.
They are selected. What is that interim order now?
They have to file an amendment. Cost title not amended by order dated 21.
They have been impleted. Who is that council? Consideration of a vacating stated advocate for one shot. Past title not amended. For learned council appearing impleading applicants filing applications on guest lecture. Application for guest lecture which is produced along with impleading applicants have been passed patent are reported to duty and they are working. But in view of the interim order granted by this court, the respondent necessary and proper protest is allowed. Impleading applicants are permitted to come on records and possibilities are permitted. What is that interim order?
Their participation is, my lord, is reflected in the merit list. And
No, their interim order is not extended, Mr. It is not extended in last this thing also. Yes. IA 4 of 2025 is filed for vacating. None appear for the petitioner. This court by order dated 12/1/2026 has allowed that impleading application, directed that counsel for the petitioner to amend that cause title. Even cause title is not amended. The interim order is concerned. Interim order granted on is granted on 26/9/2025 till next date of hearing. On next date, on 12/12/2025, none appear for the petitioner. The interim order is not extended. Thereafter, interim order is not extended. Yes. Even today, none appear for the petitioner. Leave this matter after 2 weeks. Yes.
Serial number 19, Anusha L for petitioner.
I'm for the petitioner. There is some minor office objection. Kindly pass it on, my lord.
Yes, pass on.
Serial number 20, Anusha Devi H for petitioner, connected matter.
Respond.
Yes.
My landfill has furnished a copy of the.
Finishing up, we have written with office objection. Yes, madam.
Please, my lord, I have secured this hand summons. The party is here. They will produce it to the school. They are taking with them today. Matter may be listed.
And I have not received a copy of the petition.
In one of, please, my lord, in one of the petitions, I have not served a copy. I'll do it during the course of
Yes.
the day.
At the request of petitioner, leave this matter after 2 weeks.
My lords,
My lord,
on request, my lords,
Before I may require time to file
a
objection.
date may be fixed, my lords, in February.
23rd.
Grateful.
Yes.
And there is one connected petition, WP 34045. Very similar facts and similar relief, my lord. Only petitioner is different. The parties are also the same. If
Is it Mr. Who is appearing? Let us see when the matter is posted, we'll see, then we'll connect it. Yes.
Grateful. 23rd, my lord.
Yes.
Great.
Serial number 21, Vinay Kirti M for petitioner. Serial number 21,
Yes. Week's time is granted to comply of subjection.
serial number 22, Ashoka T.
My lords, in this matter for petitioner, it's a writ up for.
Copies annexed to the type, copies annexed to the original certificate copies. Yes, Mr.
Certificate copy, I'll file an IA for dispensation, my lords.
Yes.
Okay, a week's time may be granted.
Week's time is granted to comply of subjection.
Serial number 23, Abhishek K for petitioner.
The office objection I will clear, my lords. The office objection I'll clear, my lords.
No, it is there.
Lords. I will do the office.
Copy to be annexed to be filed. Detail of the annexure have to be stated in the writ petition.
I will comply the office objection, my lord. There cannot be overruled. My lords, I have sought for interim order, my lords.
So you comply it, then only. If you want, you pass over. If there is an urgency, you will pass over, comply it. Yes.
Please.
Serial number 24, Vardhan Chennai K for petitioner.
Objection was non-servicing of copy of the caveat.
Received the
I have
caveat.
served the copy, my lords.
I have received the repetition, my lords.
Yes.
Kindly pass to our my lords, 2:30 and Martin. I'll instruct the management, I'll file my power and I'll submit. 2:30.
Also, your lordship's board is heavy today, my lords. It may not reach.
Well,
Could have
2:30
sought
again
interim
time.
order that could be considered, my lords.
Tomorrow.
I've sought an interim order because there is.
It may be after 2:30 Swami, Ivattina Martin.
2:30.
Pass over. 2:30, I have to decide.
Please, please.
If it's pass over, it will be granted. Yes, pass over.
Pass for right. Grateful.
Serial hearing interlocutory application matter, serial number 25, P. Nataraju for appellant, Narendra D.V. Gowda.
Appellant number 2, appearing for the respondent, appellant number 1, madam. So I filed LR application, my lords, to bring the
legal representatives of deceased A1H and A1E, my lords. A1H, Wakalat has been filed, my lords. A1E, LRs of A1E are served, but they are unrepresented.
No, you are appearing for the appellant itself.
Appellant number 2, my lords.
I am appearing for the appellant number 1, my lord.
No, who is dead now? Appellant number 1 is dead.
Also.
I now, who has filed an application? Appellant number 2 has filed.
Appellant number 2, my lord.
Then you are not taking notice to that LR.
Already application ಇದು ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದೀನಿ ಸ್ವಾಮಿ.
ಯಾರಿಗೆ?
Appellant number H1 and 2 and 3.
Appellant number appellant number
1, 2, 3. H1 and 1, 2, 3.
H1, 2, 3 na?
H1, 2, 3 ಸ್ವಾಮಿ. ಇವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿರೋದು ಅಪ್ಲೈಂಟ್ ನಂಬರ್ 1H ಇದು ಡೆತ್ ಆಗಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
ಅಪ್ಲೈಂಟ್ ನಂಬರ್ 1H
ಡೆತ್ ಆಗಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ಆಲ್ರೆಡಿ ನಾವು ಫೈಲ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ, ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದ್ವಿ.
No, Mr. Appellant number 1 is dead.
ಹೌದು ಮ್ಯಾಮ್.
His LRs is brought on record.
LR application was filed, my lords. Notice was issued. When notice was issued, it was written that
Who are that LRs?
My lords,
LRs ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ appellant number 1 ಗೆ? A12
A12 A1I
A12 A12 A1A to A1H, my lords.
A1 ಹೆಂಗ್ ಮಾಡಿದಿರ್ರಿ? A1 ಆದ್ಮೇಲೆ A2 A3 A4 ತಾನೆ?
A1 has died, my lords. ಅವರೆಲ್ಲ ರೆಕಾರ್ಡಿಗೆ ಬರ್ಬೇಕು ಅಂತ
ಫಸ್ಟ್ A1 ಸತ್ತೋಗಿದ್ರು. ಫಸ್ಟ್ ಅಪ್ಲೈಟ್ ಸತ್ತೋದ್ಮೇಲೆ ಅವ್ರ ಎಲ್ಲಾರ್ಸ್ ನ A1A A1B A1C ಮಾಡಿದ್ದೀರಾ? ಅಪ್ ಟು ವೇರ್?
A1H, my lords.
A1H. Now A1H is dead.
A1H and A1E are dead, my lords.
A1H and A1E is dead.
Please.
Now their LRs has been made as a party.
Their LR has been made as party.
ನೀವು
A1H
na before you brought that on records, he is dead.
Please.
Why can't you file an application that A1 A B C D H LRs nu kuda id ಮಾಡಬಾರದು? ಯಾಕೆ ಅದಕ್ಕೊಂದು ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ? Now who you are appearing for? A1
A1H ಇವರು ಆಲ್ರೆಡಿ ಅರ್ಲಿಯರ್ ಆಗಿ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿದ್ರು.
ಆಯ್ತು, ನೀವು ಯಾರ್ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತೀರಿ? A1A ಇಂದ
A1A A to D F G I J and H. AE A1E ನ ಹೊರತುಪಡಿಸಿ ಎಲ್ಲರಿಗೂ
A1E and H
A1E ಬಿಟ್ಟು ಇನ್ನೆಲ್ಲರಿಗೂ ವಕಾಲತ್ ಹಾಕಿದ್ವಿ. ಹೆಚ್ಚಿಗೂ ನಾವು ಆಲ್ರೆಡಿ ವಕಾಲತ್ ಹಾಕಿದ್ವಿ.
ಬಟ್ ನೌ he is dead.
ಹೌದು ಸ್ವಾಮಿ.
ಹಂಗಾಗಿ H ಬರಲ್ಲ
ಸ್ವಾಮಿ. ಅರ್ಲಿಯರ್ ಆಗಿ ಇವರು ನೋಟಿಸ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ. A1H
ಗೊತ್ತಾಯ್ತು ಬಿಡ್ರಿ.
ಹೆಚ್ಚಿಗೆ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ, ಹೆಚ್ಚಿನ LRs ಗೆ they have filed.
ಈಗ A1E LRs ಗೆ ಹಾಕಿದಿರ ಅಪ್ಲಿಕೇಶನ್?
Served unrepresented.
ನೀವು ಅದಕ್ಕೆ ವಕಾಲತ್ ಹಾಕಲೇನ್ರಿ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ ಯಾರು ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿಲ್ಲ. ಪಾರ್ಟೀಸ್ ಯಾರು ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ.
ಆಯ್ತು, H LRs ಗೆ ಹಾಕಿದಿರಾ ನೀವು?
H LRs ಗೆ 26/4/2025 ನಲ್ಲಿ ವಕಾಲತ್.
LRs is served now. Now everybody is served. I will allow that application. You have any objection?
No. Yes.
IA 1 of 2025 is filed for condonation of delay of 1101 days in filing LR application to bring LRs of. Now first we'll LRs of deceased A1H. And IA 2 of 2024 is filed for condonation of delay of 384 days in filing an LR application. First ಅದನ್ನ allow ಮಾಡಿ. A1H for the reason stated in that accompanying affidavit, learned counsel appearing for LRs of A1H has no objection to allow that application. Accordingly, delay is condoned. IA 1 of 2025 is allowed. IA 1 of 2025 for condonation of delay in filing LR application is condoned. Abatement is set aside. LRs of deceased A1H is permitted to come on record. IA 2 of 2024 for condonation of delay of 384 days in filing an LR application proving LRs of A1E. LRs of A1E served unrepresented. IA is allowed. Delayed condoned. Abatement is set aside. LRs of deceased A1E is permitted to come on record. 2 of 2022 to 4 of 2022 is filed being LRs of appellant A1. For the reason stated in that accompanying affidavit, IA 1 of 2022 is allowed. IA 1 of 2022 to IA 1 of 22 of 2022, 3 of 2022, 4 of 2022 is allowed. The LRs of deceased appellant number 1 is permitted to come on record. Learned counsel for the appellant to permit, appellant number 2 is permitted to amend the cast title and also directed to file amended cast title. Clean amendment ಮಾಡಿ ABC E ಅಲ್ಲಿ E1 E2 E3 confusions ಆಗಬಾರ್ದು. Yes. Then other one H1 H2 H3 correct ಆಗತ್ತೆ. Yes.
Amendment ಮಾಡಿ amendment. Serial number 26, Ramachandra for petitioner, connected matter, Muhammad Ayub Ali.
Covered by judgment, my lord, regarding the stipended nurses working in the Bangalore Medical College. Covered by judgment.
Yes,
Even
Mr.
the
I visit covered.
connected.
What is that matter, Mr.?
Madam, this regularized service, madam. Stipended nurses covered by judgment. You will also turn to annexure AG, page number 70, 170.
Observe the
In
petitioner.
writ petition number 28/532.
Page number?
Page number 172, 11. 170, madam, 170.
72.
AG,
Page number? Page number 72.
170. 170, annexure AG, madam. And relevant pages are 2011. And covered by judgment.
Judgment.
Page number 211, 42, internal page 42, madam.
211 ನಾ?
Yes, madam, 211.
ಏನಂತ ಹೇಳಿದ್ದಾರೆ? ಓದಿ para 7.
As this says, the counsel for the petitioner point out the interim orders issued by this court, reserving 102 posts for the staff nurses for consideration of the case. The petitioner from out of 600 posts that are be filled by the second respondent, it is submitted that the respondent may be directed to keep 102 posts reserved as has been stated in the recommendation dated 15/2/2019 made by the second respondent to the first respondent state government. It is further pointed out that there are 169 petitioners before this court and only 100 posts were directed to be kept in vacant for filling up those posts. The interim orders directing the second respondent to keep the 102 posts reserved for the petitioners shall continue till the case of the petitioner are treated in terms of the direction given above. Even otherwise, further vacancies would have occurred, and therefore the interest of the other petitioners, 67 of them who did not have the benefit of the interim order, shall also be considered by the second respondent before they proceeded to issue fresh notifications. This is the order.
ಏನಾಯ್ತು ಆರ್ಡರ್ ಆದ್ಮೇಲೆ?
Implement ಮಾಡಿಲ್ಲ. In the connected writ petition ಅಲ್ಲಿ writ appeal ಹಾಕಿದ್ರು. Writ appeal was dismissed.
ಈ petition ಏನಕ್ಕೆ ಇದು?
ಇಲ್ಲಿ ಕೊಟ್ಟಿದೆ.
No, earlier writ petition for what?
Earlier same subject. In the connected writ petitions.
No, same subject ಅಲ್ಲ, ಏನಕ್ಕೆ ಅಂತ ಹೇಳ್ರಿ.
ಅದು regularization of the staff stipended nurses of working in the second respondent college. ಅದರಲ್ಲಿ writ appeal connect earlier.
ಆಯ್ತ್ರಿ, ಇದ್ರಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡೋ ತನಕ
it is pending.
It's pending now. That state government, it is further pointed out that there are 165 petitioners before this court.
Not one submission, my lord. Writ appeal number 446 for 2024 is still pending, my lord.
Henry?
Filed against which order?
No, order dismissed. ಏನಕ್ಕೆ ನೋಡ್ಕೊಂಬಂದು ಹೇಳ್ಬರಿ.
ಕೊಡಿ.
ಇದ್ರ ಮೇಲೆ ರೀ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರೆ ಇಲ್ಲಿ ತನಕ ಹೋಗುವಿಲ್ಲ.
Yes. ಈಗ ನೀವೇನ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
ಈಗ ಸೇಮ್ implement and also regarding in this particular petition.
Directing that respondent to observe the petitioner as directed by the honorable single judge and directions already ಕೊಟ್ಟಿದಾರಲ್ಲ, ಮತ್ತೇನ್ directions ಕೊಡೋದು?
ಇವು ಈ petitions ಕೊಟ್ಟಿಲ್ಲ. ಈಗ ಇದಕ್ಕೆ ಯಾಕಂದ್ರೆ ಅರ್ಲಿಯರ್ ಎಲ್ಲರೂ ಹಾಕಿದ್ರು, ಬಟ್ ಬ್ಯಾಚ್ petitions ಹಾಕಿದ್ರು. ಆ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ರೆ ಇದಕ್ಕೆ ಸಿಮಿಲರ್ ಡೈರೆಕ್ಷನ್ ರಿಕ್ವೈರ್ಡ್.
You are not the parties earlier.
Earlier we are party.
No, they were party.
We are parties to the petition. And regarding in the earlier order, how it is to pay regarding back wages, how it is to pay, and also increment ಅದನ್ನ ಮಾಡಿಲ್ಲ ಸಾವ್ರೆ. That is, I'm relying on the reported judgment of the reportable judgment.
You
of the
read
honorable-
para 7 of that judgment. Para 7 was the page 210.
211, man.
210.
210. Seven. In the light of this court is of the opinion that these matters may be disposed of while fixing a time frame for the respondent to consider the representation made by the petitioner. In the light of the recommendations made by the second respondent to the first respondent, the state government shall consider the recommendation made by the second respondent and pass orders within a period of 3 months from the date.
Where is that recommendation?
This is the recommendation.
ಎಲ್ಲಿದೆ recommendation? ಅದರಲ್ಲಿ ನಿಮ್ಮ ಹೆಸರು ಇದೆಯಾ?
ಹೌದು ಇದೆ ಸರ್.
ಎಲ್ಲಿದೆ ತೋರ್ಸ್ರಿ.
ತೋರ್ಸಿರಿ. For a moment, your lordship turn to page number 6, writ petition. Earlier writ petition, the Shiv Kumar first person.
ಅಲ್ರಿ ಆ ರೆಕಮೆಂಡೇಶನ್ ಎಲ್ಲಿದೆ ರೀ? ರೆಕಮೆಂಡೇಶನ್ ಎಲ್ಲಿದೆ ರೀ?
Recommendation ಕೊಡಿ.
Into 2009 and 2019.
Recommendations ಇದರಲ್ಲಿ ನಾವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ, ಬಟ್
ನೀವು ಈ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ನೀವು ಪಾರ್ಟಿ ಇದ್ದೀರಾ?
ಅದು ಇದ್ದೀನಿ, ಅದನ್ನ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ಇದರಲ್ಲಿ
ಸೀರಿಯಲ್ ನಂಬರ್
ಪಾರ್ಟಿ ಇನ್ ದಟ್
They are the party. They are.
ಎಷ್ಟು ಜನ ಪಿಟಿಷನರ್ ಇದ್ದೀರಾ ಅಲ್ಲಿ?
ಅದ್ರಲ್ಲಿ ಇದ್ದೀನಿ ಸರ್, ಇದ್ದೀವಿ. ಅದನ್ನೇ ನಂಬರ್ ತೋರಿಸ್ತೀನಿ, ನಂಬರ್ ಹೇಳ್ತೀನಿ.
ಎಷ್ಟು ಜನ ಪಿಟಿಷನರ್ ಇದ್ದೀರಾ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಇದರಲ್ಲಿ 21 ಇನ್ ದಿ ಕನೆಕ್ಟೆಡ್
ಈ ಪಿಟಿಷನ್ ಅಲ್ರಿ,
ಅದರಲ್ಲಿ ಟೋಟಲ್ 102 ಆಗಿತ್ತು, 67 ಇದ್ರಲ್ಲಿ ಇರ್ಲಿಲ್ಲ. ಆ 67 ರಿಗಾರ್ಡಿಂಗ್
ನಾನು ಕೇಳ್ತಿರೋದು ಕೇಳಿ, ಅದ್ರಲ್ಲಿ ಎಷ್ಟು ಜನ ಇದ್ರಿ? 102 ಇದ್ರಿ, ಅದ್ರಲ್ಲಿ ನೀವು ಒಬ್ರು.
Yes, I am also one of the
Be directed to keep 102 posts reserved to be have stated under so and so. The respondent state. It is further pointed out that there are 169 petitioners before this court. 169 re. Only 100 post has been kept. Who are 104? Yarig 104? Which 104 has been kept vacant?
Vacant earlier petition.
Order director respondent to keep that 104 post reserved petitioners will be continued till that petitioners to treat them as an even otherwise further vacancies should be. Now that you are all working still today.
Still working. That is not.
Now that direction is to consider that representation.
Yes.
In the light of the recommendation made by that.
The light of the
there is already any directions by this court. What else you want?
The batch by batch ಇದನ್ನು consider. Earlier WP number 14, 12, 14, 20 ಹಾಕಿತ್ತು. ಅದರಲ್ಲಿ earlier direction.
ನೀವು ಪಾರ್ಟಿ ಇದ್ದೀರಾ ಇದರಲ್ಲಿ? ಕೋರ್ಟ್ ಆಲ್ರೆಡಿ ಡೈರೆಕ್ಟ್ ಮಾಡಿದೆ, ಇನ್ನೊಂದ್ಸರಿ ಏನಕ್ಕೆ ಡೈರೆಕ್ಟ್ ಮಾಡ್ಬೇಕು? ಬೆಂಚ್ ಚೇಂಜ್ ಆದಾಗ ನೀವು ಡೈರೆಕ್ಷನ್ ತಗೊಂತಾ ಇರ್ತೀರಾ. ವಾಟ್ ಇಸ್ ದ ವ್ಯಾಲ್ಯೂ ಆಫ್ ದಟ್ ಕೋರ್ಟ್ ಆರ್ಡರ್? Can't you file a contempt for implementation?
No, contempt is also issued, but they don't bother about it. They are seeking.
Then what to do? You go and pursue before the division bench.
Division contempt order ಮಾಡಿದ್ದಾರೆ.
ಏನಂತ ಮಾಡಿದ್ದಾರೆ? What is that order in that contempt, Mr.?
Page number 44.
ಕೊಡ್ರಿ, ನಾನು ಕಾಪಿ ಕೊಡ್ದೇನೆ ನೋಡಿ ಪೇಜ್ ನಂಬರ್ 44 ಅಂತ. ಕಂಟೆಂಪ್ಟ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ?
ಇಲ್ಲಿ ಕಂಟೆಂಪ್ಟ್ ಅಂಡ್ ರಿಚ್ ಅಪೀಲ್
ಕ್ಲಬ್ ಮಾಡಿದಾರಾ?
ಕ್ಲಬ್ ಆರ್ಡರ್.
ಏನ್ ಮಾಡಿದಾರ ಇದರಲ್ಲಿ?
ಅಲ್ಲಿ ನೋಡಿ ಸರ್.
ಓದಿ.
Para 43, page number 19.
ಓದಿ.
Having perused the recommendation on the memo placed on record in the earlier batch of petition, perusing the judgment of the single judge, which is produced in Annexure B, we noticed that the recommendation was specifically only with regard to the framing of the special recruitment rules, granting the benefit of age relaxation on service weightage to contract employees, the single judge in the judgment under appeal. Error in wording that the direction, the WP number 3405, 3431 was connected cases were observed the contract employees as nursing staff in the post kept vacant. However, we noticed that the private sector have not been working in the contract employees since 2008-2009. Most of them were reaching the end of their normal service tenure. The government in an earlier occasion decided to regularize their service, which decision was thereafter withdrawn. At present, it is admitted fact that there are vacancies available to accommodate the petitioners who are in continuous service since 2008 to 2009. It is also an admitted fact that the cadre recruitment rules and the special rules for granting service weightage and age relaxation to contractual employer have not been framed so far, in spite of clear direction issued having been issued in 2019. In the above circumstances, we are of the opinion that the instant fit case where the government should direct to consider the claim of the contract authority for regularization at least prospectively. In the facts and circumstances of the case, we are of the opinion that the directions issued by the Federal Single do not require any interference in this writ appeal. The appeals accordingly failed. Under this November 3-month time is granted.
Division bench time fix ಮಾಡ್ಬಿಟ್ಟು 3 months ಹೇಳಿದೆ ಕಂಟೆಂಪ್ಟ್ ಆಗ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಬಂದು ನಾನ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ ಇನ್ನು 6 ತಿಂಗಳು ಕೊಟ್ರೆ will it not be extended, mister?
No.
Petition itself.
Idರಲ್ಲಿ your prerogative lordship can't even contempt petition is also here. Prerogative lordship can do this.
ಆಯ್ತ್ರಿ ಎಲ್ಲಾ ಸೇರಿ ultimately court said division bench said that you comply it within 3 months. ಮಾಡಿಲ್ಲ ಅಂತಂದ್ರೆ ಕಂಟೆಂಪ್ಟ್
ಸಿಮಿಲರ್ ಡೈರೆಕ್ಷನ್ ಇಸ್ ರಿಕ್ವೈರ್ಡ್ ಬೇಕಾದ್ರೆ ಅವ್ರು ಮಾಡೋದಿಲ್ಲ
ಅಲ್ರಿ ಆಯ್ತ್ರಿ ಡಿವಿಷನ್ ಬೆಂಚ್ ಆರ್ಡರ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ನಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ವಾಟ್ ವಿಲ್ ಬಿ ದಟ್ ಎಫೆಕ್ಟ್
ಏನ್ ಮಾಡುತ್ತೆ
then you are arguing for the respondent or the petitioner. If I grant time another 6 weeks, then you can't file a contempt, mister.
Even this is the Supreme Court direction.
I will dispose of that. You take that benefit. I don't know how that advice has been given.
One more thing is regarding the how the salaries is
already ಈ ವಿಷಯರನ್ನ ನೀವು ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿ ಹೇಳ್ಬೇಕು ನೋಡಿ ಹೆಂಗ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ನನ್ನ ಹತ್ರನೇ ಬಂದು ಹೇಳಿದ್ರೆ ಮತ್ತೆ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಡ್ಬೋದು. I can't punish them.
That is too much, but similar.
Then now today if I dispose of, I will say that to consider 3 months from today. Then earlier division bench order has been watered down, mister.
Lord, this petition itself is not maintained. Kindly go through paragraph, page number 24, my lord. In the prayer, he seeks a direction. Issue a writ of mandamus or any other writ directions or orders. It is directing respondent number 2 to observe the petitioners are directed by learned single judge anta keltare. It's already been passed.
That, mister, that is not understanding.
Earlier,
now you are not going to comply the direction of the division bench.
My lord, no, the problem is we have to get approval from the finance department, my lord. Because they have given approval only with respect to the 200 nurses to appoint 200 nurses, which have been already been appointed.
Regarding the how the regularization to be made.
No, I don't know whether you are understanding what I am conveying to you or not.
I am not disputing that is not. Ekandre repetition ಮಾಡಿದ್ರೆ at least pressure ಇರ್ತದೆ ಮಾಡ್ತಾರೆ ಅಂತ ಮಾಡ್ತಾನೆ ಇಲ್ಲ. That is the main reason. ಇಲ್ಲಿ one more submission man. In the earlier which I read out, there over the regularization to made ಅಂತ ಇಲ್ಲ. ಅದಕ್ಕೆ Supreme Court judgment ಅಂತ ಕೊಡ್ತಾರೆ. Latest judgment.
This petition I will dispose of. I will grant some more time, mister. Now you have been saved by the contempt.
ಅಲ್ಲ ಇದಾದ್ಮೇಲೆ ನಾವು contempt ಹಾಕಿ ಈ direct these regularization regarding how the regularization is to be made.
No, I can't go over that division bench, mister. I will say that
Supreme Court judgment regarding how the regularization is to be made ಅನ್ನೋ ಕೇಸ್ ಅದಕ್ಕೆ judgment ಕೊಡ್ತಾರೆ.
That's this court has directed to consider your representation for a regularization. If they have rejected, then we will see that what the method they have to be adopted.
That observation can be made.
Yes.
Already the direction has been issued. It has been challenged before the division bench.
Our contempt ಹಾಕದ್ಬಿಟ್ಟು ರಿಟ್ ಹಾಕಿದ್ದಾರೆ. I can't do anything. Otherwise, I could have been held in contempt against your officer. In this writ, what is that connected matter?
Similar.
They are also parties in that earlier petition.
Same.
Yes. In this writ petition, petitioners are sought following relief.
ಇದು ಕಂಟೆಂಪ್ಟ್ ನಂಬರ್ ರೆಫರ್ ಆಗಿದೆ ಇದ್ರಲ್ಲೇ ಇಟ್ಟಪಿಲ್ಲಿ ಕಂಟೆಂಪ್ಟ್
ಓದಿದೆ ಕಂಟೆಂಪ್ಟ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ ಕೋರ್ಟ್ ಸೆಡ್ ಕಂಪ್ಲೈ ದಟ್ division bench order as well as single judge order 3 months. Division bench has given direction on 22nd July 2025.
Yes,
till limitation is there to file in a contempt. Yes. Checking following the petitioners The case of the petitioner that they were appointed by second respondent Bangalore Medical College and Research Institute stipendiary nurse for the black period of 6 months during 2008 to 2009.
11 months.
It is further contended by the petitioners that second respondent institution appointed the petitioner by giving 1 day break in service and extended the appointment of the petitioner from time to time. Since the petitioner case for regularization is not considered, they approach this court filing in a writ petition in WP number
3405. Connected.
3405-3431 of 2015 and connected matter. This court has disposed of the writ petition on 25th February 2019 with following observation.
Also another batch is there.
Para 7.
Another batch at the annexer AH.
Para 7 to para 9.
22, 6, 21, 21.
Extract matter.
Other batch in the other same annexer
Yes.
AH. Page number 213.
Yes. Being agreed by that order of that learned single judge, the Bangalore Medical College respondent number,
Same petitioners.
Second
respondent has filed an appeal in writ appeal number 571 of 2024. The petitioner also filed a contempt in CC. Contempt petition number 575 of 2023 and connected writ appeal number so and so on connected matters. Contempt petition 575 of 2023. The division bench of this court on 25 July 2025 has dismissed that appeal and passed following order, para 21 extract, and granted 3 months time
to the first respondent.
view of the order passed in the writ appeal CC after 3 months time. ಅಲ್ರಿ ಕಂಟೆಂಪ್ಟ್ ಇನ್ನೂ ಇದೆಯಲ್ರಿ contempt is there. Court said that after 3 months post that contempt petition before that roster bench ideyalri, then why you do want to directions, mister?
At least let me file. Total last time I filed an application also. No, let it be asserted that will be forward to you also ಅಂತ ಹೇಳ್ಬಿಟ್ರು. ಅದಕ್ಕೆ ನಾನು
ಆಯ್ತ್ರಿ, ಅದಕ್ಕೋಸ್ಕರ ಅಲ್ಲಿ ಕಂಟೆಂಪ್ಟ್ ತಗೊಳ್ಳಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇಲ್ಲಿ ರಿಟ್ ಹಾಕೊಂಡು why do you want to do it all these things?
ಇದನ್ನ ಅದೊಂದು ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿ so that we can also file a contempt. ಯಾಕಂದ್ರೆ ಅದು ಮಾಡೋದಿಲ್ಲ. ಅದಕ್ಕೆ that is my sincere request.
Contempt also, they are the parties in contempt.
ಅವ್ರು ಕೇರೆ ಮಾಡೋದಿಲ್ಲ ಸರ್. ಇವನ್ ಇಷ್ಟು ದಿವಸ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಯ್ತು ಅಂತ ಡೇಟ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡು 6 months 6 months they have taken.
What benefit you will get, mister,
ಏನ್
by
ಮಾಡೋದು
disposing this case?
This is the way they are making to run to pillar to post.
See, by don't want to say
ಸ್ವಲ್ಪ
that.
serious
This is the way you are advising.
The lordship kindly make some serious
Not contempt is initiating the contempt is can be taken action against that or in the writ, mister.
ಇದ್ರ ಬಗ್ಗೆ same observation so that we can also
Observe that you are also insisting for this. Yes. Further extension time of 3 months to comply that order and directed to restore that complaint contempt petition before the roster bench. In spite of pendency of that contempt, petitioners are, instead of pursuing that contempt petition, they have filed this writ petition.
These petitions are not the content, petitioners before the contempt. There are other petitions.
Yes.
They connected
Since
petition.
These petitioners,
Parties to that, in that.
ಆಯ್ತು ನೀವೇನು ಈಗ ಹಾಕ್ಬಾರ್ದು ಅಂತಿದ್ಯೇನು?
ನಾವು ಇದರಲ್ಲಿ contempt ನಾವು party.
Herein are not the parties in the contempt petition. Instead of filing a contempt, they are filing this writ petition. Learned counsel for the petitioner submitting that the above writ petition may be disposed of to granting some disposed of to direct the respondent to consider the case of the petitioner in terms of the order passed by this court in writ petition so and so and writ appeal so and so. Since this court and the division bench is already directed that respondent to
First
respondent to consider the case of the petitioner within 3 months from date of disposal of that. Writ appeal 571 of 2024 disposed of on 22nd July 2025. Therefore, there is no further directions required to issue by this court. However, there is already an directions issued by the division bench of this court. Respondent is directed to consider the case of the petitioner in terms of directions issued by this court in writ petition number connected matters and writ appeal so and so. Yes. Time frame ಯಾಕ್ರಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿಸ್ಕೊಳಕ್ ಹೋಗ್ತೀರಾ? In terms of that ಅಂತ ಹೇಳಿದೀನಿ, ಹೋಗಿ ಕಂಟೆಂಪ್ಟ್ ಹಾಕೊಳ್ರಿ. Yes. All pending applications are disposed.
Number 27, Srinivasa K for petitioner, Satish K.
Lord, I appear for the petition. Application number 3 of 2025, Lord, is filed by me, seeking to include the general manager SESCOM, Lord, as the one of the respondent member. Because, my Lord, earlier, my Lord, it was the superintending engineer who was exercising the powers, my Lord. Now that power of appointing and promotion has been taken over by the general manager. Hence, my Lord, I have filed this application so as to include the general manager as respondent number 9.
Whom you have been made as a party here?
Lord, earlier, my Lord, I have made the superintending engineer the respondent number 1. He was the
number 1.
My Lord. He was the one, my Lord, who had given the promotions to the respondents number 2 to 8 on the earlier occasion.
ಆಯ್ತು, ಯಾವುದು ಸೆಸ್ಕಾಂ ಎಲ್ಲಿದದು?
SESCOM, Chamundeshwari Electric Supply Company.
Who is that council? Served is unrepresented.
I will serve, my Lord, on general.
No, what is that you are seeking for?
Seeking, my Lord, I am seeking for implementing the general manager.
No. What is that prayer in the
Prayer, my Lord, is, my Lord, to quash the promotion given to the respondents number 2 to 8 and to consider the seniority, my Lord, only on the basis of the as per the notification issued by the corporation. My Lord,
has issued Annexure L.
Annexure L was issued by the, my Lord, of the respondent corporation, my Lord, K petition.
Respondent number 1.
I will ask him to present before the court. See, his order is challenged. He is not appearing even after service of notice. This is how that they are taking it casually. Let them fight. Leaving between to the private parties to fight, they will keep quiet. Their records is necessary. We will ask them to present before this court. Yes. The order which is impugned in this writ petition is Annexure L. Dated 11/7/2022 is passed by first respondent. Annexure.
Annexure L, page 90.
Yes. In spite of service of notice None appear for first respondent. Who is the answering respondent in this case? First respondent is directed to be present before this court on next date of hearing on 10th. Office is directed to communicate this order to first respondent. Let it come.
Meantime, my application.
Let him come. That we'll see. We'll teach them, Mr. This is how that they are taking casually, Mr. High Court. Yes.
Serial number 28, Joshi Dattatreya for petitioner, connected matter, Anita HR.
Petitioner in second petition, Mullah. Last occasion, third respondent took time to file the objection to IA, Mullah, direction IA.
Yes. What is this? Why it is posted IA 1 for?
Direction.
Who has filed that IA?
Direct.
Both of us have filed.
No.
That they have to.
Who has filed this application, madam? One of two.
Petition both we filed, Mullah, for direction to pay the 7th pay scale, Mullah, to us.
Who is both? Only one petitioner is there. Who has filed that? Connected.
Matters is there, Mullah.
There is a application in that also.
Please.
Yes. Yes, Mr. What is that application?
Matter has to be heard. The main prayer is.
What is the prayer in that petition?
Yes,
Regularization of the appointment of the petitioners.
regularization, similar employees, so it's not for regulation, there was a direction issued. Against which, my lord, the state government has prepared an appeal. The appeal is pending, my lord, now.
No, what is the directions issued?
To consider their representation for
regularization. Regularization defined. Now that you have rejected their regularization. Now they are seeking for a 7th pay commission. Temporary employees entitled for 7th pay commission also.
Objections because
just let them file an objection.
Lord, already given to similar employees, Lord. Kindly see the along with my application, Lord. I produce annexure.
Case number 11.
Second petition, Lord. Yes. Case number 17, Lords. Last annexure. 6 members already given, Lords. Similar employees.
Page number?
Page number 17, Lords.
When application has been filed?
Application filed on Lot 22/1/2025, Lords.
Yes.
There is a order, Lord.
Read.
Syndicate prakara ಪ್ರಾಧಿಕಾರದ ನಿರ್ಣಯ ದಿನಾಂಕ 16/7/2025 ಅನ್ವಯ ಬೆಂಗಳೂರು ವಿಶ್ವವಿದ್ಯಾನಿಲಯ ಮಾಸಿಕ ಕ್ರೋಢೀಕೃತ ವೇತನದಲ್ಲಿ ವಿವಿಧ ವಿಭಾಗಗಳಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ 6 ಜನ ಕಂಪ್ಯೂಟರ್ ಲ್ಯಾಬ್ ಇನ್ಸ್ಟ್ರಕ್ಟರ್ ನೌಕರರ ಸೇವೆಯನ್ನು ದಿನಾಂಕ ಸೋನ್ಸೋ 2 ದಿನಗಳ ಗಡುವು ಇಡೀ ಅನ್ವಯವಾಗುತ್ತೆ 1 ವರ್ಷದ ಅವಧಿಗೆ ಮುಂದುವರಿಸಿ ಅವರುಗಳ ಹೆಸರಿನ ಮುಂದೆ ನಮೂದಿಸಿರುವ ಕಾಲಿಕ ವೇತನ ಶ್ರೇಣಿಯ ಕನಿಷ್ಠ ವೇತನ ಸೋನ್ಸೋ ರಾಜ್ಯ ಸರ್ಕಾರದ ನೌಕರಿ ಕಾಲಕಾಲಕ್ಕೆ ನೀಡುವ ತುಟಿ ಭತ್ಯೆಯ 90% ಮತ್ತು ಆಯಾ ಪ್ರದೇಶದ ಅನ್ವಯ ಮನೆ ಬಾಡಿಗೆ ಭತ್ಯೆಯ 90% ನೀಡಲು ವಿತ್ತಾಧಿಕಾರಿಗಳಿಗೆ ಅಧಿಕರಿಸಿದೆ. This is the order, my lord. They have total 18 members were transferred to second respondent to third respondent, my lord. All 15 were on the request of their letter, my lord. They were transferred to 15 members transferred to Bangalore University, my lord, second respondent. Only 3 members, these 3 members, my lord, when they filed the writ petition, my lord, because of that they are not ready to take transfer to Bangalore University, my lord. The petition.
Now you are all working in which university?
Third respondent, my lord, UEC.
Vishwesvaraya
Please, my lord.
Yes.
The petitioner also ready to go to Bangalore University, my lord. And they are also given the application, my lord.
Come to that.
Kindly see the annexure,
you are appointed in which university?
Please, my lord.
You are appointed in which university?
Bangalore University.
Now, why you have been transferred to that Vishweshwaraya University?
Because, my lord, when the university is formed, my lord, themselves they transferred, my lord. 15 members on the request, my lord, they have gone to Bangalore University, my lord. These people also ready to give, go
Bangalore
there.
University or Vishweshwaraya University?
Bangalore University, my lord. Kindly see the page 16, my
No,
lord.
madam, you have transferred from Bangalore University to Vishweshwaraya University or Vishweshwaraya University to Bangalore University?
Bangalore University to Visvesvaraya University, my lord. Now they are ready to go back to Bangalore University, my lord, sir. They are ready to take, my lord. But subject to, my lord, kindly see the page 16, my lords.
16 of?
My IA.
Same, previous page.
This annexure X2,
Yes, ma'am.
these 6 members are working in Bangalore University.
Yes, ma'am.
You are in that Vishweshwaraya University.
Please, my lord. Kindly see the page 16, my lords. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಯುಇಸಿ ವಿಶ್ವವಿದ್ಯಾಲಯದ ಕಾರ್ಯನಿರ್ವಹಿಸಿದ ಶ್ರೀಮತಿ ಕೋಮಲಾ, ಶ್ರೀಮತಿ ನಳಿನಿ ಮತ್ತು ಶ್ರೀಮತಿ ಕಲ್ಪನಾ ಕಂಪ್ಯೂಟರ್ ಲ್ಯಾಬ್ ಇನ್ಸ್ಟ್ರಕ್ಟರ್ ಮಾಸಿಕ ಕ್ರೋಢೀಕೃತ ವೇತನದ ನೌಕರರಾದ ತಾವುಗಳು ಯುವಿಸಿ ವಿಶ್ವವಿದ್ಯಾಲಯದ ಬೆಂಗಳೂರು ವಿಶ್ವವಿದ್ಯಾಲಯದಲ್ಲಿ ಸೇವೆಯನ್ನು ಮುಂದುವರಿಸುವಂತೆ ಕೋರಿರುತ್ತೀರಿ. ಈ ವಿಷಯದಲ್ಲಿ ತಿಳಿಸುವುದೇನೆಂದ್ರೆ ಕೋಮಲಾ, ಶ್ರೀಮತಿ ನಳಿನಿ ಇವರುಗಳು ಬೆಂಗಳೂರು ವಿಶ್ವವಿದ್ಯಾಲಯ ಸೇವೆಯನ್ನು ಮುಂದುವರಿಸುವಂತೆ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ರಿಟ್ ಪೆಟಿಷನ್ ಸೋ ಅಂಡ್ ಸೋ ದಾವೆಯನ್ನು ದಾಖಲಿಸಿರುವುದರಿಂದ
Vishweshwaraya University.
I appear for UC. Both. Bangalore University, my lord, the council is there.
You are there. No, let them go.
Yes, I have absolutely no problem, my lord. Let them go to the Bangalore University and whatever the benefits they will get.
No,
UC has no objection.
No, who has to send them to Bangalore University now?
Our request ಕೊಟ್ಟಿದ್ದಾರೆ because the Bangalore University has issued this endorsement which says after pending ಇರೋದನ್ನ consider ಮಾಡಕ್ಕಾಗಲ್ಲ.
The pendency of this matter will not come in the way
Yes,
of
let there be an observation and the direction be issued to consider their request for transfer from UC to Bangalore.
Learned counsel for the petitioner. Ibrolo same,
please.
ಎರಡು same. ಇಬ್ರು
submitted that. They were that employee of that Bangalore University. After formation of University of Vishweshwaraya College of Engineering, they have been transferred to third respondent university. Wide annexure X1 on 1/10/2024, on 4/11/2023, the petitioners has given a requisition to the Bangalore University to transfer them back to the Bangalore University.
Please.
Pursuant to that, who has passed that endorsement? He is not a party here.
Second respondent.
Second respondent.
Kula Sachivaru. Yes, second respondent has issued an endorsement in view of pendency of this writ petition. Petitioner request for transfer cannot be considered. It is made clear that pendency of this petition will not come in the way of the second respondent to consider that request of the petitioner for the transfer in accordance with law.
Please.
Yes.
And pay the 7th pay scale according
ನೀವು ಅಲ್ಲಿಗೆ ಹೋದ್ಮೇಲೆ ಅವರಿಗೆ ಅವರು ಕೊಡಲ್ಲ ಅಂದ್ರೆ ಆಮೇಲೆ ನಾವು ಡೈರೆಕ್ಟ್ ಮಾಡಿ.
Please.
First you let go there. Yes. ಎರಡರಲ್ಲೂ ಎರಡು ರಿಟ್ ಪಿಟಿಷನ್ ಸೇಮ್ ಡೈರೆಕ್ಷನ್. ರಿಟ್ ಪಿಟಿಷನ್ ಏನ್ ಡಿಸ್ಪೋಸ್ ಅಲ್ಲ, ಡೈರೆಕ್ಷನ್ ಸರ್. Yes.
For 29 with Rajendra Kumar Sangai for petitioner connected matter.
These cases, the writ petitions, my lord, where my lord, all these petitioners, they are all working as a guest lecturers, my lord, in the government colleges. For the past 15-20 years. Then, my lord, these candidates possess, my lord, post-graduation degree as well as, my lord, the MPhil degree, which was considered as equivalent to hold the post of assistant professor, my lord, in these colleges. Then, my lord, what happened was they have been working every year. They have been removing and they are continuing their service. And the state government has considered their past service also. Their weightage also has been given for 1 year the services, and based on the merits, my lord, they used to. What happened, my lord? There is a writ petition filed before this honorable court. 2003 and 300 of 2014, where a petition was filed saying that as per the UGC guidelines of my lord, regulations 2018, to possess, to become eligible to hold a post of a guest of lecturer, one should have passed net SLET or my lord PhD. That was the regulations, my lord, and the allegation in that petition was the state government has been appointing the ineligible candidates who do not have all these three qualifications, and they have been appointing every year, and they have been continuing. We do not have any chance for even to get a post. So this court, my lord, has held that as per the 2018 regulations, whoever is qualified, they would be eligible, my lord, for the post, and from 23-24 onwards, the state government should strictly adhere to that and have a counseling and admit them in, fill up the post. Then, my lord, that was challenged before this honorable court in a writ appeal by the state government, saying that they want to continue for the present year. That was not considered. And that petition, my lord, writ appeal also came to be dismissed. Now, then, my lord, the state government has started the counseling in the previous year. At that stage, my lord, all those who are working for 15-20 years, who are not the UGC eligible candidate, they approached this honorable court. This court has granted an order saying that one temporary employee cannot be, because that is also a temporary post only. They are not appointing any sanctioned post. No, that is not a permanent post. Yes. So they should not be. This honorable court has passed an interim order, and all of them have continued. They have been continuing, my lord. They have continued. Previous year, next year also they have continued. Then in the meantime, the writ appeal, my lord, which was filed on the earlier occasion, the earlier writ petition came to be dismissed. Thereafterwards, my lord, they started commencing counseling, saying that only eligible candidates would be considered. Though, my lord, we were also working and we were there in the roles, we also permitted to file an application. Everybody has made an application that was not considered on the eligible candidates. Now, because there are two types of lecturers, my lord, who are working on the previously, my lord. One is those who have got only postgraduate degree without passing net SLET or PhD or MPhil, anything. In these batch of petitions, we hold MPhil degree. After post graduation, we hold MPhil degree, and MPhil degree is to be, for MPhil degree there is a relaxation, and we need not pass net or SLET, and we would be eligible on par with other eligible candidates. That is our case. That point has to be decided. In fact, the state government has considered this aspect, and on the previous occasion, the recruitment was made based on MPhil qualification. They have been regularized and they have given a promotion also. All those documents I have produced. Apart from that, in the state of Maharashtra also, my lord, the last year, that also I have
Now, why it is posted today?
The IAS, my lord, were filed, but now, my lord, what has happened? All these persons, my lord, they are out of service now. Now, my lord, next in June, my lord, another counseling will be held, because it's only a temporary period for all temporary. In spite of the interim order, my lord, they have held a counseling and they did not allow us to.
No, even then, that I think direction is that to consider that appointment of temporary employees also if they are qualified.
Yes.
Only. Otherwise, how can that become?
That's what. So the question which has to be decided here is whether we are not only PG graduates, my lord, we hold MPhil degree. Whether the candidates who hold MPhil degree are considered are exempted from attending for net or SLET passing also. That is the question, my lord, has to be done.
No, what is the qualification required under that this thing?
That's what my net SLET. Yes.
No, your lordship may kindly see.
And
the law is very clear. Now the division bench has also held, there is no departure from UGC prescribed qualification. Under the regulation, if lordship sees this writ petition number 1150 of 2025.
May I make one submission, my lord?
Regulation 13 may kindly be seen.
We'll see just facts. That's all.
Facts 13 or Purti Kotilla. It is not in dispute that the qualification for appointment as a guest faculty is same as qualification prescribed for assistant professor for regular appointment. If lordship sees page 36
in writ petition.
1150 of 25 ನಲ್ಲಿ ತಾವು ತೆಗೆದ್ರೆ ರೆಗ್ಯುಲೇಷನ್ 35 ನ annexure B1 ಅಂತ ಇದೆ ಅದು. ಅದರಲ್ಲಿ ತಾವು ನೋಡಿದ್ರೆ
Qualification ಎಲ್ಲಿದೆ ಅದು?
ಅದೇ ರೆಗ್ಯುಲೇಷನ್ 3. If lordship will get
Yes.
page 36 ನಲ್ಲಿ 3 requirement and qualification. The direct recruitment to the post of assistant professor, associate professor and professor in the university and colleges, the senior professors in the university shall be on the basis of the merit through All India so and so following so and so. The 3.2, the minimum qualification required for the post of assistant professor and other so and so shall be specified by UGC in this regulation.
ಏನು specify
3.3 ಏನ್ ಹೇಳುತ್ತೆ, national eligibility test or an accredited test, state level eligibility, ಕರ್ನಾಟಕದಲ್ಲಿ ಸ್ಲಾಟ್ ಆಗುತ್ತೆ, state level eligibility test or SCT ಅಂತಾರೆ, shall remain the minimum eligibility for appointment of assistant professor and equivalent positions wherever provided in this regulation. So the first thing is, ನೀವು ಏನೇ ಮಾಡ್ಕೊಂಡು ಬನ್ನಿ, minimum qualification is net or slet ಅಂತ ಹೇಳಿದೆ. Then my lords, provided that this is what they are taking.
All these persons are not having any
No.
net or slet.
They are not having net or slet. They are claiming, if lordship sees next, PhD ಅನ್ನ ನೀವು ಮಾಡಿದ್ರೆ in accordance with that regulation, then that is one. Secondly, there are some subjects for which net or slet is not conducted. These are the only two propositions where a person without net qualified could be appointed.
Yes, that's all.
That's all. ಇಲ್ಲಿ ನೋಡಿ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ, provided ನಲ್ಲಿ clear that PhD under a regulation, the regulation name ನಲ್ಲಿ MPhil and PhD ಅಂತಿದೆ, but it says that only those who have acquired PhD under that regulation are exempted ಅಂತ. They are trying to say regulation name ಅಲ್ಲಿ MPhil ಅಂತಿದೆ, MPhil ಗೂ ಕೂಡ
PhD ಮಾಡಿದ್ರೆ
PhD under this regulation. PhD ಏನಾಗುತ್ತೆ, with great respect,
PhD under this regulation ಅಂದ್ರೆ ಏನದು?
ಅಂದ್ರೆ ಏನಾಗುತ್ತೆ, they have to part time PhD ಕೊಡ್ತಾರೆ, they have to do certain minimum exercises, ಅವರೊಂದಿಷ್ಟು ಇದೆ, ಅದೆಲ್ಲ ಇದೆ. ಸೊ ಅವಾಗ ಇವ್ರು none of them are PhD.
ಫಸ್ಟ್ ಆ
ಕ್ವಶನ್ ಬರುದಿಲ್ಲ. ಹಾಗಾಗಿ ಇವರೆಲ್ಲ MPhil ಮಾಡಿದ್ದಾರೆ. MPhil ಮಾಡಿರೋರು they want an exemption from net, which is not permissible. That is a sum and substance.
That is provided, providerly, minority is not there.
Provider
Further that, the award of degree to the candidates registered for the MPhil / PhD program prior to July 11, 2008 shall be governed by the provisions of the then
existing ordinance, by laws or regulations
prior to 2009. Hagagi we would be exempted from that net and slet. That is my case. That has to be interpreted.
We'll see that.
Yes, my lord.
Yes, when
Date may kindly be given, my lord. I'll give a synopsis also.
Yes.
Fourth, my lord.
Fourth ಆಗಲ್ಲ. Yes, 18.
Serial number 65 also, my lord, the similar matter.
65.
30 also.
Previous matter, serial number 28. Within 2 weeks, that representation should be done.
No, you are there. We said that there is no bar for them. They are ready to consider. But the only thing is case is pending. We said that it will not come in their way.
Within 2 weeks.
No, that is not the case before here. Here is the case that they cannot be considered. Because of this, we said that there is no bar. Yes. Yes.
Serial number 30, Suresh V, Amit Deshpande for petitioner, B. Pramod.
Yes. Who has to serve the copy? Who has filed an impleading?
Let him serve a copy.
Third para onwards. In view of the order passed by the coordinate bench of this court in the Honorable Supreme Court
respondent number one undertakes the selection process in accordance with the orders passed in the above proceeding, services of the petitioner shall be continued. It is however made clear the petitioner shall not claim any equity of whatsoever nature in the event they are found to be not suitable during the recruitment process to be undertaken by the respondent number one. Process to start ಮಾಡಿದ್ರೆ even three were appointed members. That is challenged. One matter is listed today at serial number 87. ಅದರಲ್ಲಿ 3 ಜನ select ಮಾಡಿದ್ದು, one challenge ಮಾಡಿದ್ರೆ last 2 weeks back it was listed. Two matters which were there also listed.
Yes.
Subject to selection process ಆಗಿದೆ, 3 ಜನ select ಮಾಡಿದ್ರೆ one post is challenged and it is pending.
Right, this is selection so far as the assistant professor. We have been promoted to the associate professor and the professor. So far as this, our selection is annulled, my lord, by this honorable court. It went up to Supreme Court. So far as these posts of professor and associate professors are concerned, we were working, my lord, not in the cadre of assistant
What is the
professor.
directions you have sought in this writ petition?
No, my lord, what happened? In view of the further development, now they are already, the syndicate is already appointed 3%, approved 3%. I think this.
No, that you are the one of them.
Let them give us
What
all
is
the-
your application? You give impleading applications, let us see.
Your lordship may have it next week, my lord. Yes.
Approval ಆಗಿಲ್ಲ. ಆದ್ರಿಂದ this repetition does not provide.
No.
Because.
ಅಪ್ರೂವಲ್ ಆಗಿ ನೀವು ಅಸಿಸ್ಟೆಂಟ್ ಪ್ರೊಫೆಸರ್ ಆಗಿ ಹೋಗೋದ್ರಿಂದ ನಮ್ದೇನು ಅಭ್ಯಂತರ ಇಲ್ಲ. We were working as a professor and put in 22.5 years of service. We want saving of appointment. That's all, my lord.
Now, how can see if they are, did not have a requisite qualification to hold either assistant professor or reader or professor? How can they continue here as a professor? See, their contention is we did a master degree in some other subject. This honorable court is already held that you are disqualified on account of you are not qualified to have a requisite qualification. Thereafter, appellate court is already that in the petition that division bench also held. You are not entitled to hold that post. So finally, Supreme Court also held. Now they find this petition stating that his appointment of 3%.
No, what is that annexure A? What is that impugned annexure? In pursuance of so and so, in view of that order, we have been terminated. Yes.
Their question in this petition is, till appointment of 3 candidates will continue. For that, without any salary.
No, that is,
now they are not working.
no, interim measurement, till that regular appointment has to be made, they can be continued.
But now they are not
Their termination is correct or not has to be examined.
That is all, my lord.
That's one.
My
Interim
lord,
order
so
is
far
concerned,
as-
once their regular appointment is there, they are out. Whether their termination is right or wrong, that will be considered.
Question is, now they are working or not, that is the question. Now they are not working.
No, even, no, mister, even if they are working, they can work till that regular appointment has to be made. That is what the interim order. Once regular appointment is made, they are out. That is for the university to decide. Yes, you've given a copy to them. Yes, this matter of 2 weeks.
My lord, interim order to continue.
Interim order granted earlier is extended till next date of hearing. Yes.
But copy may be given.
ಅಲ್ಲ, ನಾನು ಕೊಡ್ತೀನಿ.
Impleading application.
Yes. Yes.
ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ serial number 87 ಬಂದಿದೆ.
ಅದೇನದು?
Same ಇದೆ. ಅಲ್ಲಿ ಏನಾದ್ರು ಈಗ ರಿಸಲ್ಟ್ ಆಯ್ತು ಅಂತ ತಕ್ಷಣ ಇದು ಹೊರಟೋಗುತ್ತೆ. ಈ restriction ಹೋಗುತ್ತೆ.
ಅವಾಗ ಎಲ್ಲರೂ
ಅಲ್ಲ ಇದು ಹೋಗುತ್ತೋ ಇಲ್ಲ ಅಂತ ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ.
ಅದ್ ಬರ್ಲಿ ಅದ. ಅದನ್ನ ಅದ್ರ ಜೊತೆಗೆ ಪೋಸ್ಟ್ ಮಾಡ್ಬೇಕಾ? ಆಯ್ತು, ಅದ್ ಬಂದಾಗ ಹೇಳಿ. 87, I mean only 32. Yes, yes.
Serial number 31, Anusha L for petitioner.
Yes.
My lord, this is a case where, my lord, both the managements have agreed. And Mudigere and Kadur Darlu. Banakal school.
Now you are working in which school now?
Mudigere.
Mudigere.
Yes. and it has to be transferred to Sakrapatna Tarlu.
Bankal Vidya Sanstha, Sevala Vidya Sanstha.
Sakrapatna. What is that annexure Q?
That is the, now the endorsement says in view of 2017 rules. My lord, only one post is there in both the management.
Yes, what is your instruction? They cannot be.
My lord, I will just make only one sentence. Kindly come to 32 minutes. It is a compassionate appointment, approved post, granting aid, page 32. What they quote, my lord, the rule.
Yes.
In case of non-teaching staff already admitted grant in excess of the staffing pattern. Page 32. Page 32, note 1.
Page number 32.
Yes.
Yes.
Note 1. In case of non-teaching staff already admitted granted in excess of the above staff, the post held by sexes shall be ceased to exist. Illon the post is alone, that is a sanctioned post. In excess of the sanctioned post.
There he is seeking interchange.
Yes, prohibition comes. That is all, my lords.
Similar. No, both are not a sanctioned post. Other. No, he is seeking an interchange. Who is that person who is working there? Who is that person who is working?
My lord, he is a retired vacancy.
Vacancy is there.
Yes. Let him verify.
Wait, let him. No, it is not a sanctioned post. No, but there is a vacancy, but it is not a sanctioned post. Yes, mister, where is the materials to show that?
My lord, the resolution is there, my lord.
No, resolution, whether it is approved.
It is an approved post.
No, show me that.
Kindly come to my lord, page 18.
Treated as unaided post and rural school Sakleshpura. Yes. Now you want to seek transfer to that Bankal.
Sevalal.
Sevalal.
Arsikere Taluk.
Arsikere Taluk. Show
6
me
in the
that
7.
Sevalal High School.
Yes.
Which post that is SDN?
Illala. Group D.
Group D.
Group D.
Group D.
Annexure D may kindly come. Seen, my lord. Page 18. Sri Chandru BD D group Naukararu. Banakal Shala ಈ ಶಾಲೆಯಿಂದ ಶ್ರೀ ಗಂಗಯ್ಯ ಬಿ ಡಿ ಗ್ರೂಪ್ ನೌಕರ ನಿವೃತ್ತಿಯಿಂದ ಖಾಲಿಯಾಗದ ಹುದ್ದೆ ತಮ್ಮ ಶಾಲೆಗೆ ವರ್ಗಾವಣೆ ಮಾಡಿಕೊಳ್ಳಲು ಸಭೆಯಲ್ಲಿ ಸರ್ವಾನುಮತ. It is a retired vacancy. In excess of the
No. Let me first show that the vacancies which that Chandru was working is a sanctioned post and it is approved.
It is an appointment on compassionate grounds.
That management has to say. Otherwise, we'll no direction to go there, but we will not get a salary from the government. Annexure B. If it is not a sanctioned post.
Milord, you will also may kindly come to B, Milord, page 15.
Yes.
ನೇಮಕಾತಿ ಅನುಮೋದನೆಯಾದ ದಿನಾಂಕ 15/9/2016. ಕರ್ತವ್ಯಕ್ಕೆ ಹಾಜರಾಗ ವೇತನ ಮತ್ತು ವೇತನ ಶ್ರೇಣಿ. It is an approved post and it is a compassionate appointment. ಇನ್ನೊಂದು ರಿಟೈರ್ಡ್ ವೇಕೆನ್ಸಿ.
ನೋ ಎಲ್ಲಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಕೇಳ್ತಾ ಇದಾರೆ ಅವರು?
7 ಗೆ.
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್
7 ಗೆ. 6 ಇಂದ 7 ಗೆ.
Chandru is the petitioner. Your post is, see, there is no doubt. You want to go to that non-sanctioned post.
Malad, it is a retired vacancy.
No, Mr.
Just now I read the resolution.
Even non-sanctioned post employee can also retire. There is no bar for them. They have to be retired after 60 years.
Malad,
whether it is sanctioned post or not has to be shown. See, now that in respect of Chandru, you have shown annexure B. Like
Malad,
that,
may make Malad to resolve this controversy.
Yes.
If the post in which I wanted Malad to go there, if it is an approved post and the sanctioned vacancy, let them give the rule in which they are quoting is not applicable.
No. Now that instruction he is saying that it is not sanctioned. If you
My lord,
want,
let
I
him
will
make-
ask them to place it by affidavit.
Let them file affidavit, my lord.
It ceases to exist ಅಂತ ಹೇಳ್ತಾರೆ. Annexure ಇದು ಇರುತ್ತೆ. In similar circumstance, ಅವರು ನಾನ್ ಟೀಚಿಂಗ್ ಅಲ್ಲಿಗೆ ಮುಗಿದೋಗುತ್ತೆ ಅಂತ ಅವರದ್ದು ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಹೇಳುತ್ತೆ.
No.
Lord, I don't want this kind of
What he is saying
submission.
that, see, you should be firm. If you, file it that objection saying that this is not a sanction post, then we'll reject. Yes.
My lord,
If
may
it-
request, my lord, page 35.
So we will go that if it is not a sanction post, you will not get that salary. Yes.
Page 35, my lord.
Yes.
Mr. Ravi Shankar, similar to management, NOC was given, yes, they have been approved.
Say that.
Nirdeshakaru, Praudashala, same authority.
No, there is no problem for giving in a permission. Now the post which you are claiming is not sanctioned, that is what that instruction.
Let him file an affidavit.
Let him
my lord.
file with this. Still you want that, will permit you to go there, but you will not get the salary. If it is not a
No,
sanction.
my
post.
lord. What they wanted, my lord, they are invoking 2017.
No, you forget about that. Rule will come later. First, there should be a two sanction post for interchange.
Yes, my lord.
Let them first verify that whether it is a sanction.
Let them file an affidavit.
Yes, government advocate press 2 weeks time to file objection. You file it that, then we'll.
My lord, if it is not sanctioned post, my lord, why should I go there, my lord? I will not go.
No, therefore, you yourself is not sure that it is sanctioned or
ಇಲ್ಲ
not.
ಇಲ್ಲ ಇಲ್ಲ ಅವೆಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿದೆ ಕರೆಕ್ಟ್ ಆಗಿದೆ.
Yes. Yes, you give it that. Yes. Yes. File an affidavit whether. it is
ಎರಡು
sanctioned.
ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ರೆಸಲ್ಯೂಷನ್ ಏಡೆಡ್ ರಿಟೈರ್ಡ್ ಅಂತ ಇದೆ. If there are two vacancies, rule apply. If it is one, rule will not apply.
Let that, even that management, let them come and say that it is in a
My
vacancy.
learned friend can make an enquiry whether it's a, because records are with him.
File that affidavit. Yes.
1 week. ಏನಪ್ಪ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಹೇಳುತ್ತೆ, ರೂಲ್ ಅಪ್ಲೈ ಆಗುತ್ತೆ ಅಂತ ಹೇಳುತ್ತೆ.
You file it, mister. File it. Yes. We'll
matter?
decide on that affidavit.
Serial number 32, T.S. Venkatesh for petitioner, Vaishali Agre.
May I please, my lords. My lords, in this.
Yes, what is this? Yes, they wants to file objection.
Please,
Yes,
my lord.
at the request of council.
My lords, that IA for dispensation at file, my lords, the order, I have this copy, my lords. My dispensation IA, my lords.
Two for director to file IA for dispensation, you have certified copy is
I'll
there.
file it in the office.
You file it in that office, please. Yes. Government, learned council for respondent number 2 and 3, place 2 weeks time to file objection. Yes. 18. Yes.
Please, my lords.
Serial number 33, V.S. Nayak for petitioner, S.H. Prashant.
Survey copy. Yes, you verify that.
Next week.
Yes. You file it in the counter. Yes. At the request of respondent, leave this matter next week.
One date, maybe, after 2 weeks, here.
Yes, 24th.
Please,
Yes.
much.
Serial number 34 adjourned. Serial number 35, P.P. Agde for petitioner, P.D. Vishwanath. Serial number 35.
What is this matter, mister?
Related to giving directions, to consider the petitioner as first period.
Consider?
Consider him as the first period project displaced family, but he's entitled under second period category.
Nobody is representing.
Was given. They didn't join.
Yes. Yes, we'll issue rule. Yes, issue rule.
Directly not respond to court to consider not representation. Not the basis of not the matter.
No, nobody is representing. He is designated senior counsel, but nobody is coming. What to do? Even if he files, who will argue for the petitioner? What is the directions they have sought?
It's a government policy. It says that, my lord, the rehabilitation scheme, my lord, to the land users, my lord. Application made for by the state government, not the KDP.
Hmm.
Then, my lord, the,
No, we'll have it after 2 weeks. Let us see. Yes. None appear for petitioner. Leaves this matter after 3 weeks.
Number 35. I undertake to file wakalat on behalf of designated.
File it.
Please, my lord.
Yes, you need not required any permission.
Please, please.
He is designated. You can file it. File that.
Please, please.
Yes.
Sir, number 36, Tanuja ME for petitioner, MC Nagashri.
Lord, one submission, Lord, suppress name is showing, Lord, in the case.
Office is directed to delete the name of Basraj V. Sabrat for respondent number 4. 35 serial number. Show the name of so and so for R4. Yes. Yes.
Cell number 36.
Yes. Who is Tanuja? What is this matter, madam?
This matter,
You are appearing. Yes.
and idella petition. Kindly see page number. Very unfortunate situation, Lord. I was working
Yes.
in the electricity department,
Yes.
in the power corporation.
Yes.
And Lord, in the year, by virtue of page 21, without notice, they removed me.
Yes.
No notice, no inquiry. They said, we will not hold any disciplinary inquiry.
Yes. Why? Read. You are temporary employee.
No, my lord, I'm a permanent employee. I'll just come to that, my lord.
Yes.
The action is arbitrary. Now, my lord, I challenge this in the industrial tribunal,
Yes.
page 23.
Yes.
Industrial tribunal confirmed it.
Yes.
And then I went to High Court,
Yes.
page 36.
Yes.
This honorable court said, kindly see para 6. my lord.
Yes.
This court finds no ground to entertain writ petition. Writ petition is rejected on sole ground of delay and laches. However, liberty is reserved to the petitioner to approach this court in the event of his acquittal in the jurisdictional criminal case. Registered in for offences so and so, 406, 407. Now, my lord, in the criminal case, what happened? 40 is the judgment. It was a acquittal based on merits, not on technicality. Page 51. my lord.
Yes.
16, para 16.
Yes.
ಪ್ರಸ್ತುತ ಪ್ರಕರಣದಲ್ಲಿ ಚರ್ಚಿಸಬೇಕಾದ ಪ್ರಮುಖ ಅಂಶವೆಂದರೆ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಚಾಸ 1 ಎಂ ಪದ್ಮನಾಭರವರು ನೀಡಿದ ಪ್ರಥಮ ವರ್ತಮಾನದ ವರದಿಯ ಆಧಾರದ ಮೇಲೆ ದಾಖಲು ಮಾಡಲಾಗಿರುತ್ತದೆ. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಅಭಿಯೋಜನೆಯವರು ಹಾಜರುಪಡಿಸಿರುವ ಮೌಖಿಕ ಮತ್ತು ದಾಖಲಾತಿ ಸಾಕ್ಷ್ಯಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾದಾಗ ಆರೋಪಿಯನ್ನು ಜನರಲ್ ಕ್ಯಾಶಿಯರ್ ಎಂದು ನೇಮಕ ಮಾಡಿರುವ ಅಂಶ ಎಲ್ಲಿಯೂ ನಿಖರವಾಗಿ ವ್ಯಕ್ತವಾಗುವುದಿಲ್ಲ. ಸದರಿ ಅಂಶವು ನಿಖರವಾಗಿ ರುಜುವಾತಾಗದೆ ಇದ್ದಲ್ಲಿ ಅಭಿಯೋಜನೆಯ ಆರೋಪಿಯ ವಿರುದ್ಧ ಹೊರಡಿಸಿದ ಆಪಾದನೆಗಳು ದೋಷಾರೋಪಣೆಯು ಮೂಲ ಅಂಶವೇ ನಿಸ್ಸಂಶಯಾತೀತವಾಗಿ ರುಜುವಾತುಪಡಿಸುವಲ್ಲಿ ವಿಫಲರಾಗಿರುತ್ತದೆ. Then 17 lot. ನಿಶಾನೆ P1 ಪರಿಶೀಲಿಸಿದಾಗ ಚಾಸ 1 ರವರು ಆರೋಪಿಯು 1996 ಇಂದ 2000 ಇಸವಿವರೆಗೆ ಸುಮಾರು 18 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ದುರ್ಬಳಕೆ ಮಾಡಿಕೊಂಡಿರುವುದು ಕುರಿತು ಆಪಾದಿಸುತ್ತಾರೆ. ಆದರೆ ದೋಷಾರೋಪಣಾ ಪತ್ರವನ್ನು ಸಲ್ಲಿಸಿದ ಸಮಯದಲ್ಲಿ ಸದರಿ ದುರ್ಬಳಕೆ ಮಾಡಿಕೊಂಡ ಹಣವನ್ನು ಮೊತ್ತವನ್ನು 6,29,000 ರೂಪಾಯಿಗಳೆಂದು ಹೇಳಿರುತ್ತಾರೆ. ಸದರಿ ವ್ಯತ್ಯಾಸ ಕುರಿತಂತೆ ಅಭಿಯೋಜನೆಯು ಯಾವುದೇ ವಿಚಾರಣೆಯನ್ನು ನಡೆಸುವುದಿಲ್ಲ. So therefore, Lord, I am acquitted on merits. Now, Lord, kindly see, interesting. At the impugned order and annexure at page 21.
Yes.
In the middle.
Yes.
They say, kindly see the 24,33,000 blood. And then these acts committed by Lakshmi Narayana are very serious. In the meantime, kindly see, Lord, next page. In view of the alarming situation and the necessity for dealing with appropriate measures, corporation, after examining the entire issue, is satisfied that in the interest of security of the corporation, it is not expedient to follow the procedure prescribed in Regulation 11 of Rule 12
of KEBC CDSA 1987 rule for imposing penalties. Since the survival of the organization is being shaken by such acts of the above said employee, corporation has come to the conclusion Sri Lakshminarayana Junior Assistant has committed the acts as said above, and so he be imposed with penalty that is warranted not only for safeguarding the revenue of the corporation, but also to send a message to one and all in the organization of the corporation. Would invoke the provision available under Regulation 14(3) to deal strongly with the acts of the employees which endangers the security of the corporation. But this provision, I do not know whether such a provision can ever be on a statute or on any regulation.
This you have challenged in that labor code.
This I challenge in the labor code.
What is the finding of the labor code?
ಅಲ್ಲ ಇದಾದ್ಮೇಲೆ ಏನ್ ಹೇಳ್ತಾರೆ ಲಕ್ಷ್ಮೀನಾರಾಯಣ is dismissed with immediate effect.
ಆಯ್ತು
ಅಂತ ಮಾಡ್ಬೇಕು.
ಲೇಬರ್ ಕೋರ್ಟ್ ಅವಾರ್ಡ್ ಅಲ್ಲಿ ಏನು ವಾಟ್ ಇಸ್ ದಟ್ ಹ್ಯಾವ್ ದೇ ಸೆಡ್ ಸಚ್ ಎ ಪವರ್ ಇಸ್ ದೇರ್?
ಇಲ್ಲ ಅವಾರ್ಡ್ ನಲ್ಲಿ they do not discuss that issue at all.
What is the discussion in that award?
That is at para 11. The fact that first party was working as general cashier during 11 period is not in dispute, is only the contention of first party. No such inquiry was held against him, and such a proper opportunity was not extended to the first party during course of an investigation. On the other hand, it was pointed out by the advocate for second party, Chief Engineer invoked Regulation 14(3). That is the issue, Lord, of Karnataka Electricity Board employees 1987, wherein authority was empowered to pass special speaking dismissal order, and it is not expedient to follow any procedure. Therefore, it cannot be said that the order of dismissal
is that provision
passed by parties. Blood, such a provision, even if it is exists, it cannot be
now where is that
valid in the eye of law. That 14(3) provision,
madam,
last time ತೋರಿಸಿದ್ರಲ್ಲ, ಅದು 14(3). Can an employee on whom there should be fact finding
yes,
by the authority? Regulation 14(3). Where the board is satisfied, special procedure in certain cases. 14(3).
ಇದ್ರಲ್ಲೇ ತಾನೆ ಕರ್ನಾಟಕ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಬೋರ್ಡ್
ರೂಲ್ಸ್ ರೆಗ್ಯುಲೇಷನ್ 14 ಇಲ್ಲೇ ಇದೆ.
ಡಿಸಿಪ್ಲಿನ್ ಅಂಡ್
ಹೌದು, ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಬ್ಯಾಂಗ್ಳೂರ್ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಸಪ್ಲೈ ಕಂಪನಿ
ಇದ್ರಲ್ಲಿ
14(3). Such a not, it is an anathema to the Constitution of India, and it is manifestly arbitrary.
Unless you challenge, I
cannot challenge a vehicle. It could be ignored, Lord. It could be completely ignored.
No, as long as it is not challenged, presumption is that it is in.
Lord, I'll be able to produce, Lord, judgments before your lordships. Suppose, Lord, such provisions are there also. One is the courts of law, Lord, your lordships will read it to include natural justice, or else will ignore such laws, which will not have any effect at all because it violates natural justice. Basic, yes.
First we'll see that what is the law.
Special procedure in certain cases, regulation 14(3). Kindly straight away 3 ge.
Yes.
Where the board is satisfied, not 2 odd bidtini.
Yes.
Protection. Where the officer concerned has absconded, or where the officer concerned does not take part in inquiry, where for any reasons to be recorded in writing it is impracticable to communicate to him, or where the disciplinary authority for reasons to be recorded in writing is satisfied it is not reasonably practicable to follow the procedure prescribed in such regulations. Or 3, where the board is satisfied that the interest of the security of the board, it is not expedient to follow such procedure, the disciplinary authority may pass such orders thereon as it deems fit. Even, Lord, so for an instance, 14(3), the ingredients are taken into account. Security of the board,
of natural justice should be given.
And security of the board, Lord, has nothing to do
they
with.
Can dispense that detailed inquiry, but notice is necessary.
Notice is necessary. Yes, notice is necessary to not expedient to follow such procedure.
In that regulation 12(3), where the penalty imposed on the board.
Yes, Lord, procedure
on the ground that conduct which is
procedure is at 11, Lord.
Conviction on the criminal charge.
Yes, procedure 11 ನಲ್ಲಿ ಇದೆ, Lord.
That in the interest of the security of the board, it is not expedient to follow such a
Yes.
procedure. The disciplinary authority may pass
such order thereon as it deems fit. Now, not kindly see regulation 11 ಒಂದ್ಸಾರಿ ನೋಡಿ.
No order of imposing a penalty may be bypassed without giving any employee an opportunity of making a representation. ಕೆಳಗಡೆ ಇದೆಯಲ್ಲ proviso.
ಅಲ್ಲ. In a case covered by clause 1.
No proviso there, you read that proviso after that 3.
ಅಲ್ಲ. 1 ಏನಂತಂದ್ರೆ.
No, your case is there, Mr. 14(3) proviso body.
ಅಲ್ಲ. That is not provided for the in case covered by clause 1. Clause 1 ಏನು? On the ground of
Order imposing penalty may be passed.
Conviction ಆಗಿದ್ರೆ. Conviction ಆಗಿದ್ರೆ then.
No order of imposing penalty imposed without giving any.
Conviction ಆಗಿದ್ರೆ.
To make a representation. No, even then also he has to give a notice.
Notice.
That is what that proviso says.
Elementary lord.
That means to say. That it is deemed that in other 2 classes also they have to give a notice.
They have to give notice. Now, Lord, what is the normal procedure contemplated? Regulation 11.
Regulation
11. Part 6. And this is, Lord, the constitutionally enunciated procedure for government servants.
11.
There should be imputation. Regulation 11.
Yes.
Major, yes.
Till today, this regulation is there or it has been amended?
And this court has upheld this and it is covered by the judgment of this honorable.
Yes.
Regulation 11, major penalty shall not be imposed after an inquiry held as far as may be, as provided in regulation 1A, the disciplinary authority may inquire into or appoint an authority. The disciplinary inquiry shall drop or cause to be drawn by.
As like a CCA rules. Yes.
3-step.
Yes.
In a imputation
what is that,
charge.
Madam?
My lord, I have already produced the judgment of this court, my lord. I mean, produce.
Where is that?
Copy. Last time kotra. Yaru Justice V. Gopal Gowda.
This is Indresh judgment have.
ಯಾದ್ರ ಜೊತೆ ಕೊಟ್ಟಿದ್ದೀರಿ?
Adral, this point was not considered.
Let us see what is that.
I will give my copy, my lord.
Wait. If it is there, you need not.
Regulation ಜೊತೆಗೆ ಒಟ್ಟಿಗೆ ಕೊಟ್ಟಿದ್ದೇನೆ.
ಯಾವ್ದು regulation?
Regulation. I have produced the regulation along with the judgment also.
ಅದೇ ಇಲ್ಲೇ ಇಟ್ಟಿದ್ದೆ ಇಲ್ಲಿ ನಮ್ಮ ಫೈಲ್ ಅನ್ನ.
Yes, you give one more copy.
Copy ಕೊಡಿ.
ಇದೆಯಾ ಕಾಪಿ ಒಂದು ಎಕ್ಸ್ಟ್ರಾ?
ನನ್ನ ಕಾಪಿ ಕೊಟ್ಟೆ.
3 ಜನಕ್ಕೆ ಒಂದೇ ಕಾಪಿನಾ ಈಗ?
ಇಲ್ಲ, ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ ಅದು ಕಾಪಿ.
No, that copy, it might have been here. What is that? Not right? Underline or you can.
I have it. I'll have it. I'll give it.
Yes, read.
But ಇಲ್ಲಿ habitual offender 7 cases.
Lordships and
This
my
this
lords
case.
can kindly see.
Kindly see not page internal page 8. I have carefully considered the reasons. ಮೇಲ್ಗಡೆ third line ಇಂದ.
First of all, it is a special provision, my lord. Special procedure.
ಅಲ್ಲ ಒಂದು ನಿಮಿಷ.
The clause itself says.
Internal page 8. Not the gravity can vary.
Internal page
8.
Yes.
The respondent corporation, third line, mele. In this regard, it is not disputed, council appearing for petition, the respondent corporation has lodged 7 cases of similar nature against the delinquent. In all those cases, petitioner was exonerated in criminal proceedings. I have carefully considered the reasons recorded by the respondent corporation and the finding made by with regard to the reply made by the delinquent and the reasons for dispensing with the department inquiry in terms of the aforementioned matters. Finding would indicate that petitioner was a habitual offender and his service was discharged on the ground of unsuitability based on record of punishment imposed for misconduct. Previous punishment for earlier misconduct. The Honorable Supreme Court in Tulsiram Patel, that not by doctrine of proportionality, they cannot impose that here because he had 7 cases here. This case cannot be a precedent in my case.
Conduct an inquiry.
Yes.
That cannot be done, my lord, in view of section rule 13. Lordships can kindly see page 21, my lord. Page 21, annexure D. The proceedings has been conducted. Board has taken the resolution. Board resolution dated 18/8/2001. Records all the reasons. Second paragraph, my lord.
Yes.
The letter dated, may I read it, my lord?
Yes.
The letter dated so and so of the superintendent and Kolar, relevant records and contents of the letter dated 25/6/2021 and Bangalore rural were examined by the corporation it has been observed that the above said employee has remitted lesser amount due to the bank and for correction of figures in the bank statement in respect of the figures, remittance is made. The sum of rupees 24,33,181 has been absorbed as short remittance made by him for the above said period. The acts of remitting lesser amount than the actuals in the bank, making false entries in the remittance register, changing the figure shown in the bank statement in respect of the payment received by the bank, etc., committed by so and so, is very serious. The acts have been committed by him intentionally. He had misused the said sum. Revenue collection from the consumers of subdivision in the backbone for every functioning of the organization. If it is misappropriated, various activities of the corporation for which the revenues are needed will be affected very badly. The unpardonable acts of the said employee has shaken the roots of the organization. It has enlarged the very security of the corporation. Hence necessitated stringent and immediate action, which should only is
Not all
the
this
view
is
of
without inquiry,
alarming
without notice.
situation. No. This provision itself clearly said it is special provision under section and rule.
These are
Rule
findings
30.
of fact, Lord.
Lordship can kindly
No,
read the language
So
of the.
fact against a person.
Special provision
Lord, kindly
has to
see
be
the.
invoked in a
Kindly
special
see-
cases.
No,
This is not the case where otherwise in government department every day without conducting
The
an
provision
otherwise
itself, he has not challenged the provision.
No,
The
he need
provision
not.
itself
I need
speaks.
not. No, provision
The
is.
language employed in the provision may be kindly
Security
be
of the
perused.
board.
My lords can kindly see the
No, I
language
will
employed.
consider that. I will consider.
3 may be kindly.
Otherwise, you have to
Before that-
nullify that article
Well,
311.
Then these type of people will exist throughout. Then we don't
there
have.
is not-
Lordship,
Madam-
kindly
Madam,
for a moment, page number
Draconian-
21.
They have been protected
27
under the custom. They have been
Lordship
protected
can
under the
kindly
custom.
see the page number
Draconian
internal
provisions,
9,
Lord.
my lord.
Draconian provisions which
Yes,
cannot
yes.
stand.
Internal 9, my lord.
Yes.
Internal page 9, my lord.
Yes.
Of page 31, my lord.
Yes.
31.
In
My lord, last paragraph.
Yes.
In the cross-examination of his elicited that he has worked about 9 long years and misused about 24 lakhs. That
Where-
is the observation and it is recorded by the labor code.
Yes.
My lords can kindly see attending the electricity electricity
the original
ledger
vice.
pertaining to home purpose. It is also admitted that he was working in KGF division. In fact, the first party has worked as general cashier during the relevant period is not in dispute at all. That is all recorded. The entire thing is recorded by the labor court, my lord. And then lordship can kindly see the next page, page 11, last paragraph. Therefore,
Yes.
there is the oral evidence coupled with the document to establish the charges against the first party. For these
No,
reasons,
see,
the order of dismissal.
for me-
Therefore, my lord,
Notice
Kindly-
issued before findings.
Wait, madam.
my lords can kindly
Show
see the
me-
language employed in the.
No, I read, madam. Language employed, you cannot be implemented. Show me any judgment showing that by dispensing that inquiry.
Yes.
My lord, this
Even
is a special
after
provision.
You
This
are
is
not
a
hearing me,
board-
madam. See, dispensing that inquiry, you are given an opportunity in that before the labor court. It's sufficient to show that he has been misappropriated. Show me any judgment on that
Sir,
point.
he is dismissed. He is dismissed and 24 lakhs.
Not
and-
understanding that
There
what
is a
courts is-
special provision
But-
there, my
Madam,
lord.
you are not
Based
understanding.
on the
Provision
special
is
provision, my lord, we
draconian.
have taken action.
Findings are given by the board, my lord, without notice to me.
ಅಲ್ರಿ
For a
ನಾನು
moment.
ಆಯ್ತು ನಾನು ಏನ್ ಹೇಳ್ತಿದ್ದೀನಿ ನಿಮಗೆ ಅರ್ಥ ಆಯ್ತಾ
ಇಲ್ಲ ma'am.
ನಾನು ಹೇಳ್ತಾ ಇರೋದು ನಿಮಗೆ ಸಪೋರ್ಟಿಂಗ್ ಆಗಿ ಎನ್ಕ್ವೈರಿ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿದ್ರು ಕೂಡ ಲೇಬರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅವರಿಗೆ ಅಪರ್ಚುನಿಟಿ ಕೊಟ್ಟು ಎವಿಡೆನ್ಸ್ ಮಾಡಿ ಅಲ್ಲಿ ಪ್ರೂವ್ ಆಗಿರೋದ್ರಿಂದ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಆಫ್ ಎನ್ಕ್ವೈರಿ ವಿಲ್ ನಾಟ್ ಎಫೆಕ್ಟ್ ಇಸ್ ರೈಟ್ಸ್ ಅಂತ ಏನಾದ್ರು ಜಡ್ಜ್ಮೆಂಟ್ ಇದ್ರೆ
ಕೊಡ್ತೀನಿ ಸರ್.
ನೀವು ಏನು ಕೇಳದನೆ ಮತ್ತೆ
ಆಯ್ತು ಕೊಡ್ತೀನಿ.
yes this is the problem Mr. What
Next week I will, next
you
week.
give that judgment, then you can save some extent, saying that he has been given all opportunity in that, therefore inquiry need not be dispensed.
Yes.
Otherwise, your board is taking out that article 311.
Yes.
Or
Original
you
vice
produce, you produce all the records from that day to
Yes,
today.
I'll
In
produce
all
all the
misappropriation cases,
Yes,
you have not conducted an inquiry.
Yes, ma'am.
Yes.
Lord, the board gives findings, Lord, without notice to me. How could that be sustainable?
Yes.
Next week,
That
Lord.
law is all
Yeah,
done, madam.
yes,
Now that even for murderer, we have to give an opportunity. That
Opportunity.
is what the law in India. Madam. Yes. What you want, madam?
Next Tuesday.
Judgment.
Judgment irli idralli. Yes.
Next Tuesday, my lord.
Yes, leave this matter. When do you want? You find
After
out.
10 days, my lord.
Yes. Leave this matter on 11th.
Please.
Yes, you see that judgment on that point. If that is there, then you can save.
I'll
Yes,
schedule it.
please.
Serial number 37, 38 adjourned. Serial number 39, Kumar JC for petitioner. Venkatesha Sarvatti, connected matter. Serial number 39.
Yes.
Objection has to be filed by Sir But team, Lord, last occasion he sought time, but next week it may be called out.
Next week. Yes,
Can
at
I
the
date
request
may
of
be fixed, my lord.
respondent, leave this matter on 11th.
Please.
Yes.
Interim order.
Interim order granted earlier is extended till next date of it.
Please.
40.
I appear for the
Nagendra
petitioner,
Nayak
my
for
lords.
petitioner.
Yes,
Venugopal
this is for
MS.
respondent.
This is a case, my lords, where we are being aggrieved
Yes.
by the order passed by the respondent number 2, wherein they have denied to pay the full pension to us,
Yes.
stating that we are only entitled for 40% of the pension amount,
Yes.
which is entirely contrary to the judgments of the CGIT and the Honorable High Court of Karnataka in writ petition 15108 of 2006.
Yes, where is that
My
endorsement?
lords, as per endorsement is as per Annexure A, page number 13, my lords,
Yes.
wherein they have only paid us 40% of the pension amount.
Yes.
And at page number 15, my lords, they have stated that the basic pension which is payable to us is 2,659.89, my lords.
Where
which
it
is page number 15, my lords.
150.
15.
Yes.
Wherein it is only 2,659.89, my lords.
Hmm.
But instead it should be 7,600, my lords.
Why?
My lords, I'll explain the facts of the case, my lords.
Yes.
In brief. My lords, the thing is, the petitioner joined the services of the respondent bank in the year 1973, my lords, on 19/9/1973,
Yes.
and he was issued a charge sheet
Yes.
on in 1995, my lords, on 21/8/1995, alleging certain irregularities against him, and an inquiry was done and he was dismissed from service. Being aggrieved by the same, the petitioner preferred to raise a dispute before the conciliation officer. Thereafter, the matter was referred to the Honorable CGIT, my lords. The order is as per Annexure B, page number 46, my lords. The order was modified from the order of dismissal to compulsory retirement from the date of award,
Yes.
with continuity of service and payment of all other consequential benefits, my lords. The order is at page number 46. The operative, sorry, not 46. It's at 37, my lords. The operative portion of the order.
Yes.
Sorry, my lords. 36 and 37. In
Yes.
36.
Punishment dismissal
Therefore,
here is replaced by the order of compulsory retirement
retirement
to give effect from the date of
passing of this award. The first party shall be paid 50% of the back wages from the date of original punishment order till the date of passing of this award.
Back
My lords, the operative portion, that is the para above it, my lords.
Yes.
Kindly come to page number 36, below 5 lines, my lords.
Yes.
Therefore, from this fact also, punishment of dismissal appears to be shockingly disproportionate with the gravity of the misconduct committed by the first party. It is in this view of the matter, punishment of dismissal passed against the first party in the interest of justice may be converted into punishment of compulsory retirement to be given effect from the date of passing of this award. However, not glossing over and overlooking altogether the aforesaid past records of the first party, it appears to me that the ends of justice will be met if he is denied back wages to the extent of 50%. This is only with respect to the payment of back wages. from the date of original punishment order till the date of passing of the award with continuity of service and other consequential benefits.
Yes.
Maloj, the bank being aggrieved by this award preferred a writ petition. And we also preferred a writ petition. A common order was passed. There, the said award was modified to the extent of 50% of back wages to 40% back wages. The operative portion of the said order is at page number 46, Maloj. The impugned award dated in CR number passed by the central.
Other is remain intact.
Other consequential benefits remain intact. With only with respect to the back wages, it was changed from 50% to 40%.
Now all other benefits you are entitled. Yes. Now what is that?
Maloj.
Why that pension has been? Where is that order?
At page number 46, Maloj.
Yes. No, that impugned order.
Impugned order of the High Court, Maloj, or CGI?
No, order which now you are challenging. That relief.
At Annexure A, Maloj, where they have given us only 40% of the pension, Maloj.
No, that 40% is for back wages. Pension fees.
Annexure A does not say it is 40%. Annexure A ನಲ್ಲಿ pension fix ಮಾಡಿದ್ದಾರೆ. He has sought for refixation by giving a representation. Your Lordship may direct the bank to consider that representation and pass order.
We've already
It is
submitted
it
representation.
is a fresh fixation of pension under second option. Notice Annexure A is the order of fixing the pension. He has raised a grievance by giving a representation, my lords. Annexure E.
Yes, you have explained that in that annexure representation.
Yes.
Now let him reconsider and pass in a fresh order for fixation. This can be considered only a provisional fixing of the pension. Yes. This writ petition, petitioner called in question order dated 8/3/2019 passed by respondent number 2, whereby his pension has been fixed
Annexure A nowhere say it is 40% of the pay is taken. Annexure A ಎಲ್ಲೂ ಹೇಳಲಿಲ್ಲ 40%.
ಅವ್ರದ್ದು ಸ್ಯಾಲರಿ ಎಷ್ಟು?
ಅದೇ ಸ್ಯಾಲರಿ ನನಗೆ
What
ಇನ್ಸ್ಟ್ರಕ್ಷನ್
is that salary at the time of retirement?
ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. We will consider that and
Then if it is taken, and if you want to decide, you will decide here only. If you take it that salary, if 1/3, if it is less than, then you will say it is a 40%. Yes. Called in question order dated 8/3/2019 wide annexure A, fixation of pension of the petitioner. Petitioner joined the service of the respondent bank on 19/9 to 1973. When he was in service, departmental inquiry has been initiated. After conducting an inquiry, he has been dismissed from the service. He has challenged the same by filing an dispute before labor court. Wide annexure B, award dated 11th July 2006. The labor court has modified that dismissal order into compulsory retirement and directed to pay 50% of the back wages. Being agreed by the same, petitioner as well as respondent bank has filed a writ petition before this court. WP 15108 of 2006 and 14823 of 2006. This court by order dated 24th October 2007 has modified that award only to the extent of back wages, reducing from 50% to 40%. 50% back wages has been reduced to 40% back wages. In other aspects is concerned, the award remains intact. Thereafter, petitioner attained superannuation. Yavaga?
ಇಲ್ಲ ಕಂಪಲ್ಸರಿ ರಿಟೈರ್.
He was
Yes,
compulsory.
compulsory. Yes. Thereafter, petitioner pension has been fixed by impune annexure.
Petitioner opted for second option. Earlier it was not there. He was not a pension optee. He opted for pension under second options.
Since petitioner, when he was in service, he was opted for a second option for pension.
After compulsory retirement.
Oh, yes.
During service, he has not opted for pension under pension scheme. Not sir, 2010 second option was introduced and that option was given to compulsory retirees also.
After compulsory retirement, he has opted for pension scheme
under second options.
Under second option. Pursuant to that, the respondent bank has issued an impune annexure A fixing that petitioner pension the grievance of the petitioner that while fixing the pension, it has been reduced to only 40%.
40%.
The same is contrary to that judgment of this court. This court in WP number 15108 of 2006 and connected matter, only back wages has been ordered for 40%. Pension is concerned, petitioner is entitled for the pension 100%. Therefore, he has filed an objection/representation to annexure A dated 8/3/2019 as per
annexure E, my lord.
As per annexure E,
page 53.
Annexure E dated
24/12/2019.
Learned counsel appearing for the respondent bank has submitted that before finalizing that petitioner pension will consider that representation and pass appropriate order in accordance with law. In view of the above, without expressing any opinion on the merit of the case, respondent's bank is directed to consider that representation submitted by the petitioner by annexure E dated 24/12/2019 in accordance with law. If respondents come to the conclusion that the pension fixed by the respondent by annexure A has to be modified, they can issue a modified order and communicate the same to the petitioner. In case respondent wants to reject that representation, after considering that representation, if they are come to the conclusion that representation has to be rejected, even such a order also has to be communicated to the petitioner forthwith. With that observation, repetition.
Plus, 8 weeks time may be fixed.
Yes,
Otherwise, they
8
will
weeks time is granted to consider the representation. If it is required for modification, issue a modification order or communicate the decision to that petition.
Serial number 41, Vinayaka B. Vishnu for petitioner, B.L. Sanjeev.
Preparing for the petitioners in this matter.
Yes.
Now, the petitioners were initially working as assistant engineers in Karnataka State Construction Corporation.
Yes.
After that, my lord, the service was been deputed, observed by the respondent authority, my lord, on 25/2009. Kindly see, my lord, now annexure A, that is page number 20.
Yes.
Where the that condition number 4, my lord, the pay scale.
What is that annexure A?
Annexure A, my lord, is a notification that is BWSSB regulation 2008.
What is the notification?
That condition, my lord, deprives the petitioners from getting the.
ಅಲ್ಲ ಏನು ಟೆಂಡರ್ ಏನು ಕರೀತಾ ಇದಾರೆ ಅದು ಟೆಂಡರ್ ಬಹಿರಂಗ ಹರಾಜು.
Tender means, my lord, the appointing the employees, my lord, on a deputational basis. Deputational basis, my lord, appointment of the employees, they're issuing that notification.
ಗ್ರಂಥ ಎಲ್ಲ ಅವನದು ಬಹಿರಂಗ ಹರಾಜು ಮುಖದಲ್ಲಿ ವಿಲೇವಾರಿ ಮಾಡಲಾಗುವುದು.
ಅಲ್ಲಲ್ಲ.
I make a submission.
That is different, Mr. Yours is.
That is, my lord, our notification starts from page number 19.
19. ಅದೇನ ಕಾರ ಹರಾಜಿಂದು
ಅಲ್ಲ, ಅದು ಬೇರೆ, ಅದು entire notification produce ಮಾಡಿದ್ರು.
This notification for what?
Page number 20, my lord.
Yes.
There, my lord, the condition number 4, subcondition 3, that, my lord, which deprives the petitioners from getting the old pension scheme from and considering the past service, my lord.
Or regulation. Which is that?
My lord, that regulation has been quashed by this honorable court, my lord. That is, my lord, annexure.
Which part of that regulation is quashed?
That annexure, that is, my lord, regulation 4.
Entire regulation is
4/3. 4/3.
4/3.
Please.
ಏನದು as regarding the pension, other retirement
benefit, they shall be governed by the terms and condition as stipulated by the government order, so and so. That is new pension scheme. That was, my lord, quashed by this honorable court. A division bench order is there, my lord, at annexure G, page number 67, my lord.
Yes.
67, that from 11th line, my lord, in the middle. A constitutional bench of the honorable Supreme Court, page number 67.
67,
67. Annexure starts from 55, my lord.
Yes.
There 60 in 67, my lord, in the middle, my lord, a constitutional bench of the Supreme Court in so and so cases has held that the amendment which has takes away the benefit already available to the employees existing rule is arbitrary, discriminatory, and in violation of the rights of rights guaranteed under Article 14. In view of that aforesaid enunciation of law by the Supreme Court, the provisions of regulation 4/3, insofar as it deprives the benefits to the petitioners of the old pension scheme, are held to arbitrary and in violation of the guarantee. That was quashed, my lord. So now, my lord, the petitioners are herein also similarly situated, my lord. So therefore, they are also entitled for the consideration of past service and benefits under old pension scheme.
What is that you are seeking for?
The petitioners therein, in that writ petition, my lord, have filed a contempt. That contempt came to be disposed of. The respondent university has approached the respondent authority has approached the Supreme Court. Supreme Court rejected to decline in this matter. After that, my lord, I have filed a memo.
No, for them they have given that benefit. For you they have denied.
Denied.
Where is that denial?
My lord,
annexure A again.
Till now we have not received, my lord. So therefore, I am seeking for
why
a
you are challenging annexure A? It is already quashed.
Consequently, I have sought another prayer, my lord. In that consequence, to consider my rights under
the
that.
same case of the petitioner in view of this judgment, my lord.
ಈ judgment then already ಆಗೋಗಿದೆ. It's confirmed.
ಆಗೋಗಿದೆ.
Now the class is not there.
Similarly situated persons, my lord,
Similarly situated persons have already been given, my lord.
Now, my lord, service of the petitioner before absorption.
Last page of 17 only, 14 paragraph number 14.
ಎಲ್ಲಿದೆ ನಿಮ್ದು representation ಎಲ್ಲಿದೆ?
Representation they'll have to give. That is what the division bench has said. It has to be considered ಅಂತಾನೆ ಮಾಡಿದ್ದಾರೆ. 14 paragraph 14 at page 71.
Yes. Petitioner with regarding the retirement benefits so and so within that period of 3 months. Yes, you given a representation.
Please.
Yes.
like the respondent authority may be directed to consider the representation in accordance with that judgment, my lord.
Judgment already ನಿಮಗೆ they can't deny it on the basis of that rule because that is quashed. Again, how can that again and again we can be quashed?
Please.
Now that if they denied on that basis, we can say that they have no power. Yes.
Please.
This petitioner has sought following relief prior to Matrakat. Case of the petitioner that petitioners were initially joined the Karnataka State Inspection Corporation. Respondent number?
They have not been made parties.
They have not made, subsequently you have shifted to that.
Subsequently, I have been.
Absorbed to BWS.
Which is government undertaking on contract basis. Thereafter, their service has been absorbed in second respondent board. Now the petitioners are retired. All the petitioners are retired from the service. Their pension has not been fixed. Therefore,
pension has been fixed in the old scheme, my lord.
Old scheme al fix ಮಾಡಿದ್ರು. Old pension scheme which is in
New scheme, I'm sorry, my lord.
New scheme al ಮಾಡಿದ್ರು. ಹೆಂಗ್ ಮಾಡಕ್ ಬರ್ತದೆ?
ಅಲ್ಲ ಇದು ಮುಂಚೆನೆ ಮಾಡ್ಬಿಟ್ಟು ಕೊಟ್ಬಿಟ್ಟಿದ್ವಿ. Now they are challenging this.
They have paid, yes, their
paid the
pension
pension.
has been fixed under the new pension scheme. The grievance of the petitioner that the petitioner's pension has to be fixed under the old pension scheme. In view of judgment of this court in writ petition 10019 of 2021 disposed of on 26th May 2022. Therefore, the petitioner is before this court. Learned counsel appearing for the petitioner has submitted that the second respondent board has issued a regulation called Bangalore Water Supply and Sewage Board bracketally absorption of engineers and ministerial staff appointment on deputation basis in Bangalore Water Supply and Sewage Board Regulation 2008. As per Regulation 4 subclass 3, reads that pension and other retirement benefits shall be governed by term and conditions as stipulated in government order dated 31/1/2006. The relevant regulation 4 subclass 3 has been extracted below. Similarly situated persons like petitioner was filed in a writ petition in WP 10019 of 2021 challenging Regulation 4(2) and 3. What is that cost, Mr.?
Regulation 4(3).
4(3).
4 subclass 3.
Order line for 2 ಅಂತ ಬಂದಿದೆ.
ಇಲ್ಲ 4(3) ಅಂತಾನೆ ಇದೆ. It's in page number 67.
Page number 70. Pay benefit provided under the regulation 4(2) in so far as depriving that fixation of the pay benefit under strike down. It is 4(3), Mr.
4(3) ಅಂತಾನೆ ಇದೆ. 67 page number.
Page 70 ನೋಡಿ ಏನಿದೆ.
ಒಂದ್ ಕಡೆ 4(2) ಅಂತ ಆಗಿದೆ.
Yes. 4(3) of regulation has been struck down by this court. Even thereafter, the respondent has not considered the case of the petitioner for fixing their pension under old pension scheme. Therefore, petitioner is before this court. The division bench of this court, while disposing of that writ petition, has directed the petitioner therein to submit in a representation and the respondent's board is directed to consider that representation in accordance with law. In view of the above, liberty is reserved to the petitioner to submit in a representation enclosing the order passed by this court in WP number 10019 of 2021. If such a representation is submitted, the respondent board is directed to consider the same within 8 weeks from date of receipt of that representation.
My request, my lords, para number 6 in page 9, in which my lord petitioner number 2 is not been given any pension because of some departmental inquiry.
No, he said that representation consider, you can say that because of this case, your case is not considered.
Okay.
Reject ಮಾಡಿ ಅಷ್ಟೇ.
Yes.
Cell number 42 adjourned. Cell number 43, Srinivasa K for petitioner, Nagaya.
42 ಏನಾಗಿದೆ?
ಅದು ಅವರು ಲಾಸ್ಟ್ 6 months ಇಂದ ಟೈಮ್ ತಗೊಳ್ತಾನೆ ಇದ್ದಾರೆ.
ಅಲ್ಲ, respondent has taken a time.
ನಾನೇ ರೆಸ್ಪಾಂಡೆಂಟ್.
Respondent number 8. Respondent number 8, you are appearing for university ನಾ?
ಹೌದೌದು.
ಏನ್ ಸ್ಟೇ ಇದೆಯಾ ಅದರಲ್ಲಿ?
ಸ್ಟೇ ಇದೆ. ಅಂತ ಸಬ್ಜೆಕ್ಟ್ ಟು ರಿಸಲ್ಟ್ ಅಂತ ಏನಿದೆ.
ಅವ್ರೇನ್ they are not working.
Petitioner is challenged the appointment of 8th respondent.
But 8th respondent has taken a time. Then why do worry? You are an university. Yes.
Short date में तो
But next week.
43, Srinivasa K for petitioner, Nagaya.
Password.
Cell number 44, Annapanavar Ramesh for petitioner, Shrikant MP.
Yes.
44.
Yes, none appear for the petitioner. Leave this matter up to 4 weeks. Let it be up to 4 weeks.
Cell number 45, Nanjareddy PN for petitioner, Ganapati Nayak.
And for the respondent number 2 in this.
Nanjareddy, what is this, mister?
This case is employee of the cooperative society. His claim is some retirement benefits not yet given to the petitioner. In this case, what I will note, after retirement, he has not handed over the.
Yes, leave this matter after 3 weeks. None appear for the petitioner. Leave this matter after 3 weeks.
46, Rajesh Shettigar for petitioner, Chandrakant Argole.
Yes.
For the respondent number 2 in this matter.
Not followed the, in some transaction. Login ಆಗಿ some transactions ಮಾಡಿದಂತೆ, there is no misappropriation. This honorable court was issued notice and granted interim order. So far they have not continued him in service and complied with the orders.
Contempt ಹಾಕಿ.
In fact.
Otherwise we have to.
ಅವರಿಗೂ request ಮಾಡಿದ್ದೇವೆ.
No, Malats, with respect to that, we have to take a instruction, Malats. We will take a instruction and make our submission, Malats.
Let them get. Yes.
Continued, my lord, after hearing it has been continued.
Continued.
No, Malats. In fact.
As on today, it is enforcement. Stay of interim order is.
No, you are working as on today. ಈ contempt ಹಾಕಿ.
Malats, in fact, they have filed a contempt petition.
Then I will decide from tomorrow, I will not grant any interim order. Because nobody is going to implement our order by filing in a contempt. Then why you want to?
It is.
main matter ಮೇಲೆ hear ಆಗೋದ್ರಿಂದ ಸದ್ಯ don't precipitate
No, my lords.
Contempt is closed, not to
For the present. I
Then
requested my learned friend, my lord, Gode, senior Gode also.
Yes, that
We
is
will
for you.
take instruction, my lords,
When
any
do you
date by next week, my lords.
Yes, at the request of respondent.
Interim order maker.
Is this matter? Next week, interim order granted earlier is 2 weeks. Interim order granted earlier is extended till next date of it.
Serial number 47, Ranganatha is choice for petitioner.
Should I appear for? Should I appear for the petitioner, my lord? Petitioner is appointed as a computer operator. Annexure
Yes.
A, my lord. 2013, my lord, in presence of a notification, she was called for an interview and then appointed, my lord, as per Annexure B, page number 16. Thereafter, my lord, she completed the probationary period and probationary period was declared by order dated 5/12/2017, Annexure E, page number 19. Thereafter, my lord, the applicant for services were confirmed, Annexure F, page number 21. ಮೇಲಿನ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿದಂತೆ ಉಲ್ಲೇಖ 2ರ ಆದೇಶವನ್ನು ಆಧರಿಸಿ ಕುಮಾರಿ ಕೆಜಿ ನೇತ್ರಾವತಿ ಕ್ಲರ್ಕ್ ಕಮ್ ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ ಪಂಚಾಯತ್ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಬೇಲೂರು ಸೋಮವಾರ ಅರ್ಹತಾ ಪರೀಕ್ಷೆಯನ್ನು 19ರಲ್ಲಿ ಪೂರೈಸಿರುವುದರಿಂದ ಘೋಷಣೆ ಮತ್ತು ಸದರಿ ನೌಕರನ್ನು ಗ್ರಾಮ ಪಂಚಾಯತ್ ಲೋಕ ನೌಕರನ್ನು ಕಾಯಂಗೊಳಿಸಲಾಗಿದೆ. And then the seniority list was prepared as per Annexure G, page number 23.
Yes.
25/9/21, my lord. ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧ ಸರ್ಕಾರಿ ಸುತ್ತೋಲೆಯಲ್ಲಿ ಸೂಚಿಸಿರುವಂತೆ ಕೊಡಗು ಜಿಲ್ಲೆಯ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಗುಮಾಸ್ತ ಕಮ್ ಬೆರಳಚ್ಚುಗಾರರು ಕಮ್ ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ 21ರ ಸಾಲಿನ ಜ್ಯೇಷ್ಠಾಪತಿಯನ್ನು ಅಂತಿಮವಾಗಿ ಪ್ರಕಟಿಸಿದೆ. ಇನ್ ದಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೈ ಕೈಂಡ್ಲಿ ಮೈ ನೇಮ್ ಇಸ್ ಅಟ್ ಪೇಜ್ ನಂಬರ್ 26, serial number 74.
74.
74,
Yes.
page number 26. Column number, last 3 columns, my lord. The date of appointment 2/12/2013, declaration of probation 30/12/16, and last column 9 is Jilla Panchayat Anumodane. Therefore, my appointment and all approved and probationally declared, my lord. It appears, my lord, one B.C. Pavitra Kumari, who was also appointed as an account cum data entry operator earlier and whose probation has not been declared and she has not been regularly appointed. She, her services were terminated by an order on the ground of allegation of taking money. Page number 28, Annexure H, my lord.
Yes.
Her order of termination, which was issued in 16/9/2013, was challenged in this petition. And that petition, my lord, your lordship may see, the order was passed holding on the principles of natural justice. Her termination was quashed with liberty to hold the page number 32, my lord.
Yes.
Dismissal from service being grossly disproportionate to the gravity of allegation shakes the conscience. In the circumstances, the writ petition succeeds. Petitioner from service is set at not so and so 50% of back wages. My lord, thereafter, my lord, the said person, my lord, as in this there is nothing regarding my appointment, nothing has been stated, though I was a party in the said petition, page number 29, serial number for respondent 5, my lord. So far as my appointment, approval, probation, nothing has been stated. However, after the disposal of the said writ petition, my lord, I submit representation annexure K, page number 34. That a letter has been addressed by one Sri H.B. Anjana Devi to the Panchayat Chief Executive Officer, stating that the very appointment of Pavitra Kumari, who was the writ petitioner, was not proper. Kindly permit me to read annexure K for 1 minute, my lord. ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಬೇಲೂರು ಗ್ರಾಮ ಪಂಚಾಯತಿ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಬಿಸಿ ಪವಿತ್ರ ಕುಮಾರಿ ಅವರ ಕೇಸ್ಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ನ್ಯಾಯಾಲಯದಿಂದ ನನಗೆ ಹಾಗೂ ಕಾರ್ಯನಿರ್ವಹಣಾ ಕಂಟೆಂಪ್ಟ್ ಬಂದಿದ್ದು. ಈ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ನಾನು ಶ್ರೀಮತಿ ಬಿಸಿ ಪವಿತ್ರ ಕುಮಾರಿರವರು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಕಡತ ಮತ್ತು ನೇಮಕಾತಿ ಸಂಬಂಧಿಸಿದ ನಡವಳಿ ಹಾಗೂ ಹಾಜರಾತಿ ಸಂಬಂಧಿಸಿದ ದಾಖಲೆಗಳನ್ನು ಪರಿಸಿದ ಕಡತದಲ್ಲಿ ಬಿಸಿ ಪವಿತ್ರ ಕುಮಾರಿ ಅವರನ್ನು ಹಿಂದೆ ನೇಮಕಾತಿ ಮಾಡಿಕೊಂಡ ವಿವರದ ಬಗ್ಗೆ ಕ್ಲರ್ಕಮ್ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ 2007 ಠರಾವು 11ರಲ್ಲಿ ಸಂಬಂಧಿಸಿದಂತೆ ಪರಿಶೀಲನೆ ಮಾಡಿದಾಗ ಸರ್ಕಾರದ ಸುತ್ತೋಲೆಯಲ್ಲಿ ಈ ಹುದ್ದೆಯು ಇಲ್ಲದಿದ್ದರೂ 2014ರಲ್ಲಿ ಸೃಷ್ಟಿಯಾಗಿದ್ದ ಹುದ್ದೆಯಲ್ಲಿ ತಿರುಚಿ ಕಾನೂನು ಉಲ್ಲಂಘನೆ ಮಾಡಿ 2007ರ ನಡವಳಿಕೆ ಅನಧಿಕೃತವಾಗಿ ಅದ್ರ ಬೇಸಿಸ್ ಮೇಲೆ now what has been done is annexure L, page number 35. My approval appointment is cancelled, page number 35, annexure L. I will read. KG ನೇತ್ರಾವತಿ ಅವರ ಹುದ್ದೆಗೆ ನೀಡಿರುವ ಅನುಮೋದನೆಯನ್ನು ರದ್ದುಪಡಿಸುವ ಬಗ್ಗೆ ಪ್ರಸ್ತಾವನೆ. ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಉಲ್ಲೇಖಿಸುವಂತೆ ಬೇಲೂರು ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ಕ್ಲರ್ಕ್ ಕಮ್ ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ ಆಗಿ ಕರ್ತವ್ಯ ಶ್ರೀಮತಿ ಪವಿತ್ರ ಕುಮಾರಿ ಇವರನ್ನು ಕಾರಣಾಂತರದಿಂದ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ವತಿಯಿಂದ 13ರಿಂದ ಸೇವೆಯಿಂದ ವಜಾಗೊಳಿಸಲಾಗಿರುತ್ತದೆ. ಬದಲಾಗಿ ಕ್ಲರ್ಕ್ ಕಮ್ ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ ನಿಯಮಾನುಸಾರವಾಗಿ ಶ್ರೀಮತಿ ನೇತ್ರಾವತಿ ಇವರನ್ನು ನೇಮಕ ಮಾಡಿಕೊಂಡು ಕಚೇರಿಗೆ ಅನುಮೋದನೆ ಸಲ್ಲಿಸಿ ಈ ಕಚೇರಿಯಿಂದ ಅನುಮೋದನೆ ನೀಡಲಾಗಿರುತ್ತದೆ. ಯಾವಾಗ ಅಂದ್ರೆ 17ಕ್ಕೆ ಶ್ರೀಮತಿ ಪವಿತ್ರ ಕುಮಾರಿ ಬಿಸಿ ಅವರು ವಜಾಗೊಳಿಸುವ ಸಂಬಂಧ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಮೊಕದ್ದಮೆ ದಾಖಲಿಸಿ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಇವರನ್ನು ಕರ್ತವ್ಯಕ್ಕೆ ನೇಮಕ ಮಾಡುವಂತೆ ತೀರ್ಪು ಮಾಡಲಾಯಿತು. ಆದ್ದರಿಂದ ಬೇಲೂರು ಗ್ರಾಮ ಪಂಚಾಯಿತಿಯಲ್ಲಿ ನ್ಯಾಯಾಲಯದ ತೀರ್ಪನ್ನು ಆಧರಿಸಿ ಬೇಲೂರು ಗ್ರಾಮ ಪಂಚಾಯತ್ ಇವರನ್ನು ಕ್ಲರ್ಕ್ ಕಮ್ ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ ಆಗಿ ಮರು ನೇಮಕ ಮಾಡಿರುತ್ತಾರೆ. ಶ್ರೀಮತಿ ನೇತ್ರಾವತಿ ಕೆಜಿ ಇವರ ಹುದ್ದೆಯ ನೇಮಕಾತಿಗೆ ಅನುಮೋದನೆ ನೀಡಿರುವುದರಿಂದ ಪವಿತ್ರ ಕುಮಾರಿ ಬಿಸಿ ಅವರು ನ್ಯಾಯಾಲಯದ ತೀರ್ಪಿನಿಂದ 2015ರಲ್ಲಿ ಇವರನ್ನು ಮರು ನೇಮಕಾತಿ ಮಾಡಿಕೊಳ್ಳಲು ತೀರ್ಮಾನಿಸಿದೆ. ಅದರಂತೆ ನೌಕರರನ್ನು ದಿನಾಂಕ 12/3/20ರಂದು ಬೇಲೂರು ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ಕ್ಲರ್ಕ್ ಕಮ್ ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ ಹುದ್ದೆ ಕರ್ತವ್ಯಕ್ಕೆ ಮರು ಹಾಜರಾಗುತ್ತೆ. ಗ್ರಾಮ ಪಂಚಾಯಿತಿಗಳಿಗೆ ಒಂದೇ ಕ್ಲರ್ಕ್ ಕಮ್ ಡಾಟಾ ಎಂಟ್ರಿ ಹುದ್ದೆ ಮಂಜೂರಾದ್ದರಿಂದ ಸದರಿ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ 2 ಕ್ಲರ್ಕ್ ಕಮ್ ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ ಆಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಲು ಅವಕಾಶ ಇರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಈ ಬಗ್ಗೆ ಸರ್ಕಾರದ ಸ್ಪಷ್ಟೀಕರಣದಲ್ಲಿ ಒಬ್ಬರು ಕ್ಲರ್ಕ್ ಮಾತ್ರ ಅವಕಾಶವಿದ್ದು ಶ್ರೀಮತಿ ನೇತ್ರಾವತಿ ಕೆಜಿ ಅವರ ಅನುಮೋದನೆ ನೀಡಿರುವುದು ನಿಯಮಾನುಕ್ರಮವಾಗಿ ಸೂಚಿಸುತ್ತಾರೆ. ಉಲ್ಲೇಖ ಸರ್ಕಾರದ ಸ್ಪಷ್ಟೀಕರಣ ಆದ ಮೇಲೆ ನೇತ್ರಾವತಿ ಅನುಮೋದನೆ ಆದೇಶವನ್ನು ರದ್ದುಪಡಿಸಿದರು. Unilaterally, after completion of probation, after the declaration of probation and approval, after 5 years of my approval of appointment and nearly 10 years of my initial appointment, the very approval appointment has been cancelled. There was
now,
no direction by the...
Now, is there any stay?
Again,
stay is, now you are working. You are working now.
No, what they have done is both of us are there. Kindly come. That is why I want to suggest, page number 40, annexure N. After the said petition, a list has been prepared. 31/3/22, annexure N, page number 40.
Yes.
The final list which earlier was prepared, where I was so senior, that has been in that suddenly this Pavitra Kumari has been brought, page number 41 at serial number 1. Who was terminated for misconduct, my lord, and she was never probationary declared, never her appointment approval was also not made. Kindly come to column number 9, my lord, date of approval of her appointment, 17/3/22. Yes. Column number 9 is Jilla Panchayat in the Anumodayada Dinanka. Her appointment is approved in 22. So notwithstanding that, my name, my lord, your lordship may kindly see, page number 43, my lord, page number 43. Serial number
no, both are appointed.
No,
both are appointed to that same panchayat.
Same panchayat, and I have been regularly appointed. I have been regularly appointed. My appointment.
Now we have to be decided. One of them has to be there. One has to go.
Not necessarily. I cannot be disturbed because in the earlier case, my lord.
I'm not saying you are other. Now court has to decide. One has to be there. Yes. Correct. Where is that other side? Nobody is there for panchayat and.
They have filed the reply. Last occasion also same thing happened. They have filed. Fortunately, they have filed the reply statement. Jilla Panchayat has filed the reply. Kindly come in their own reply statement. Your lordship may kindly see.
No, now anyhow you are working. You are
yes,
working.
I am
there.
working, my lord.
Yes,
I am working.
Yes.
But the question is, my lord, seniority. My promotion is being denied because of this case. Though I was appointed, approved senior to her. My appointment, my further promotion is delayed because of that. That's why reply was directed to be filed there.
Is there any promotion has been given to other persons?
Promotion is not given, but they are likely to give promotion, my lord. That is the problem.
If the other person is given, then yes, Mr. How can you pass such an order?
My lords, I have taken 3 contentions. I'm just placing the contentions, and I will leave it to the court. One is there is only one sanction post for this particular.
We'll come back.
Yes. Obliged.
One submission, madam.
But serial number 66, I mentioned in the morning, I'm for respondent 2, 3, and 4, my lord. I've informed the other side. Serial number 66, my lord.
66.
I undertake for R2, R3, and R4. Sharanjit Shetty, my lord.
Yes, at the request of council. What the respondent number 2, 3?
2 to 4, 2, 3, and 4, my lord.
So and so undertake to appear for respondent number 2 to 4. Office is directed to show his name. Yes. This matter of 2 weeks.
Serial number 62, madam, for respondent number 5. I have to file a statement.
Have you informed other side, mister? ಹೇಳ್ಬೇಕಲ್ಲ ಮತ್ತೆ ಅವ್ರು ಬಂದು ಸುಮ್ಮನೆ ಕಾಯ್ತಾ ಇರ್ತಾರಲ್ರಿ.
ಅಲ್ಲ ಇದ್ರೊಳಗೆ ಅಂತಂದ್ರೆ ಡಿಸ್ಮಿಸಲ್ 2022 ಆಗಿರೋದು.
ಏನಾರ ಆಗ್ಲಿ ರೀ ಸುಮ್ಮನೆ ಲಾಯರ್ ಬಂದ್ ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಮೇಲ್ಗಡೆನೆ ಹಾಕಿದ್ದೀನಿ. ಬಿಫೋರ್ ದಟ್ ಯು ಹ್ಯಾವ್ ಟು ಇಂಟಿಮೇಟ್ ಅಂತ. Otherwise they will wait. Sometime we will sit for 6 o'clock also. Yes. At the request of council for respondent number 5 to 6 is this matter of 2 weeks.
Serial number 73, my lord. 73, my lord. I need to file objections. I have informed the other same lord. I
have informed
too.
Yes, at the request of council for respondent number 4 is this matter of 2 weeks. Your
Regularization. Because ಒಂದೇ ಸಲ ಬರ್ತಾರಲ್ಲ, I need to file objections. Objections, my lord, I will file my.
Have you any objection? Yes.
2 weeks.
2 weeks.
Date ಕೊಡಿ, right?
Yes. 16th.
Much.
16th. Yes. That's all.
ಇದೆಯಲ್ಲ
Sharanjit Shetty. ಇಲ್ಲ ಫುಲ್ ಈಗ ಲೀಸ್ಟ್ ಹೇಳ್ಬೇಕಲ್ಲ. ಇದೆ ಇದೆ
ಸರ್ ಮಧ್ಯಾಹ್ನ ಕಾಸು
ಪಾಸ್ವರು ಅದಿನ್ನೂ ಕೊಡ್ಲೇ ಇಲ್ಲ, ಅಲ್ಲೇ ಇಟ್ಕೊಂಡು ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರೆ.
ಬೇರೆ ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ
ಜಾಸ್ತಿ ಅವ್ರು ಡಿಸಿಷನ್ ಅವ್ರದ್ದು. ನಾನು ಹೇಳೋದು ನಾನು ಹೇಳ್ತೀನಿ, ಒಂದ್ಸಲ ಎಲ್ಲ ಬಂದಿದ್ರೆ ಅದನ್ನ ತಗೊಳ್ಳಿ ಅಂತ, ಇಲ್ಲ ಕಂಟಿನ್ಯೂ ಮಾಡಿ ಅಂತ. ಯಾವುದು ಎಲ್ಲಿದ್ದೀರಾ ಈಗ ನೀವು? ಬನ್ನಿ ಸರ್ ಬೇಗ. ಓಕೆ. ಪಾಸ್ವರ್ಡ್ ಎಲ್ಲ ಸ್ಕ್ರೂಟ್ನಿಗೆ ಹೋಗಿರುತ್ತೆ ಸರ್.
ಹೌದಾ?
5-6 ಇದೆ.
ಅದ್ ನಮ್ದು ಐಎನ್ಎಲ್ ಬರ್ಬೇಕಾಯ್ತು, ಬಿ ಗ್ರೂಪ್ ಬಂದ್ಬಿಟ್ಟೈತಲ್ಲ.
ಸಾಹೇಬ್ರು ಹೇಳಿರ್ಬೇಕು ಬಿ ಗ್ರೂಪ್.
ಇಲ್ಲ, ಲಾಸ್ಟ್ ಟೈಮ್ ಸೇಮ್ ಸ್ಟೇಜ್.
ಇನ್ನೊಂದ್ಸಲ ಹೇಳಿ ಅಷ್ಟೇ, ಅದು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿ.
ಬರ್ತಾರೆ ಸರ್, 5 ನಿಮಿಷ ಇಲ್ಲೇ ಬರ್ತಾರೆ. ಕೊಡಪ್ಪ ಸರ್, ಬರ್ತಾರೆ. ಹಾ, ಎಸ್ ಸ್ಲಿಪ್. ಕೊಡಪ್ಪ ಸರ್, ಬರ್ತಾರೆ ಒಂದು 2 ನಿಮಿಷ.
ಇದೆಯಾ ಅಯ್ಯೋ ಇನ್ನು ಅರ್ಧ ಗಂಟೆ ಅಜ್ಜನ್ ಆಗಿರುತ್ತೆ ಏಟ್ ನೋಡೋಣ ಅಂತ ಸುಮ್ಮನೆ ಡ್ರಾಯರ್ ನೋಡಿ ಸುಮ್ಮನೆ ನೋಡಿ ಅಲ್ಲೇ ಇದೆ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಬರ್ತಾರಾ?
Competent authority. Continue. ಏನ್ ಹೇಳಿ ಸರ್ 44 ಅರ್ಜನ್ ಆದಂಗಿದೆ ಸರ್. ಹೌದು ಹೇಳ್ತೀನಿ 4 weeks ಅರ್ಜನ್ ಆಗಿದೆ. ಇಲ್ಲ ಅವರು ಇರ್ಲಿಲ್ಲ, ಯಾರು ಇರ್ಲಿಲ್ಲ ಅಂತಾನೆ ಹೋಗಿದ್ದು. ಹೇಳಿ ಸರ್. ನೀವೇ ಇದ್ದೀಗ ಹೇಳಿ ಸರ್.
70 and 71 adjournment.
ಇಲ್ಲ ನಿಮ್ದೇನಪ್ಪ?
ಪಾಸ್ ಓವರ್ ಆಗಿದೆ, ಇವಾಗ ಸ್ಟಾರ್ಟಿಂಗ್ ಕರೀತೀರಾ?
ಸ್ಟಾರ್ಟಿಂಗ್ ಕರೆಯಲ್ಲ, ವೇಟ್ ಮಾಡಿ.
ಅದೇ ಇದು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಕ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ.
ಸರ್ ಅದೊಂದು ಇಂಟಿಮೇಟ್ ಮಾಡ್ಬೇಕು ನೀವು. ಅರ್ಜನ್ ಆಗಿದೆ, ಎಂಟ್ರಿ ಮಾಡುವಂತ ಪೆಂಡಿಂಗ್ ಇದೆ. ಕೂತ್ಕೊಳ್ಳಿ ಲೇಟ್ ಆಗಿ.
ಸಾಹೇಬ್ರೆ ಅದೊಂದು ಕಂಪ್ಲೇಂಟ್ಸ್ ಇದೆ, ಕಂಪ್ಲೈಂಟ್ ಅಂತ ಬರೆದ್ಬಿಡಿ.
ಸೀರಿಯಲ್ ನಂಬರ್
ಬೆಳಗ್ಗೆ ಇತ್ತು ನೋಡಿ 17 ಕಂಪ್ಲೈಂಟ್ ಅಂತ ಬರೆದ್ಬಿಡಿ.
ಕಂಪ್ಲೇಂಟ್
ಅದು 230 ಎಕ್ಸೈಸ್ ಮ್ಯಾಟ್ರ್ ಇದೆ, ಅಲ್ಲಿ ಹೋಗ್ತೀವಿ. ರೌಂಡ್ ಆಫ್ ಹಾಕ್ಬಿಟ್ಟು
ಇಲ್ಲ ವೈಡ್ ಆರ್ಡರ್ ಡೇಟೆಡ್ ಏನೋ ಇದೆ ಅದು
ಇವತ್ತು ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀವಿ.
ಅಲ್ಲೇ ಫೈಲ್ ಮಾಡಿ
ಅದಲ್ಲ, ಇನ್ನೊಂದು ನಮ್ದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಒಂದಿದೆ ನೋಡಿ.
ಪಾಸ್ವರ್ಡ್ ಆಗಿದೆ ಸರ್.
ಹಾ, ಅದು ಕಂಪ್ಲೈಂಟ್
ನೀವು ಬರಲ್ಲ, ಅದಕ್ಕೆ ಅಪಿಯರ್ ಆಗಲ್ಲ.
ಬರ್ತೀವಿ. 4 ಕಡೆ 230 ಇದೆ.
ಹೌದಾ? ಇಲ್ಲ ನಿಧಾನಕ್ಕೆ ಬನ್ನಿ, ತೊಂದರೆ ಇಲ್ಲ.
ಆಯ್ತಾಯ್ತು.
ಕಂಪ್ಲೇಂಟ್ ಬಂದಿದೆ ನನ್ನ ಹತ್ರ ಆಲ್ರೆಡಿ. ನೀವು ಅಪಿಯರ್ ಆದ್ರೆ ಸಾಕಿಲ್ಲ. ಬೆಳಿಗ್ಗೆಯಿಂದ ಇಲ್ಲ ಇನ್ನ ತೆಗಿಬೇಕು, ಈಗ ಆಗಿರೋದು ತೆಗಿತೀನಿ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಮೇಡಮ್.
ಸರ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀರಾ? ಅಲ್ಲ ಲಿಸ್ಟ್ 2 ಕರಿತೀರಾ ಸರ್?
ಲಿಸ್ಟ್ 2 ಎಲ್ಲ ಬೆಳಗ್ಗೆ ಆಗಿದೆ ಮೇಡಮ್.
ಓಕೆ, ಇವಾಗ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀರಾ ಪಾಸ್ ಅವರ್ ಮ್ಯಾಟರ್?
ಪಾಸ್ವರ್ಡ್ ತಗೊಳ್ಳಲ್ಲ ಮೇಡಮ್, ಆಮೇಲೆ
47 ಅಲ್ಲಿ 47 ಅಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಕ್ಯಾರಿ ಔಟ್ ಮಾಡಿದ್ದಾರೆ.
ಏನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗ್ಬೇಕಿತ್ತು? ಆಗಿದೆ. ಅಲ್ಲಿ ಸಾಹೇಬ್ರು ಅವರು ಇಟ್ಕೊಂಡಿದ್ದಾರೆ, ಏನೋ ಮಾರ್ಕ್ ಮಾಡಿರ್ತಾರೆ. ನಾನು ಕೊಡ್ಲಿಲ್ಲ, ಅವ್ರು ಇನ್ಫ್ಯಾಕ್ಟ್ ಕೊಡೋರು ಬೇಡ ಇಲ್ಲೇ ಇರ್ಲಿ. ಹಾಗಾಗಿ ಈಗ ಅವ್ರು ಬರೋವರೆಗೂ ನಾನು ತೆಗಿಯೋಷ್ಟಿಲ್ಲ. ಏನಾದ್ರು ಮಾರ್ಕ್ ಮಾಡಿದ್ರೆ ವ್ಯತ್ಯಾಸ ಬಂದ್ಬಿಡುತ್ತೆ. ಇಲ್ಲ ಸರ್, ಅವ್ರದ್ದಿದೆ, ನೋಡ್ಬೇಕು ಆಮೇಲೆ ಏನಾಗುತ್ತೆ ಅಂತ. ಆಮೇಲೆ ಕೇಳ್ತೀನಿ, ಇವಾಗ ಕೇಳಕ್ಕಾಗಲ್ಲ, ಯಾಕಂದ್ರೆ ಅವ್ರು ಕೊಟ್ಟಿಲ್ಲ ಇಲ್ಲ, ಎಲ್ಲ ಅಲ್ಲೇ ಇದೆ. ತೆಗಿಬೇಡ ಅಂತಲೂ ಹೇಳಿದ್ರು. ಬಂದಿದ್ರು ಸೀನಿಯರ್, 230 3 ಕಡೆ ಇದೆ, ಏನ್ ಮಾಡ್ಲಿ ಅಂದ್ರು. ನಿಧಾನಕ್ಕೆ ಬನ್ನಿ ಅಂತ ಹೇಳಿದ್ರು ಸರ್. ಅದೇ ಉತ್ತರ ನಿಮ್ಗೂ, ವಾಸ ಅವ್ರಿಗೆಲ್ಲ ಒಂದೇ ಉತ್ತರ. ಆ ಫೈಲ್ ಬರೋವರೆಗೂ ನಾನು ಏನು ಹೇಳ. ಹೊಸವ್ರು ಬಂದಿದ್ದವ ಜಾಸ್ತಿ ಜಾಸ್ತಿ ಇದೆ. ಒಂದೇ ಬಂದಿತ್ತು, ಈಗ ಒಂದು ಬಂತು. ಅದು ಹೆಚ್ಚೆ ಕೊಡಪ್ಪ. ಸರ್ ಯಾವ ಲಿಸ್ಟು ಸರ್? ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಎಲ್ಲ ಬೆಳಗ್ಗೆನೇ ಆಯ್ತು. ಅದ್ರ ಎಫರ್ಟ್ ಟು ಮೀಡಿಯೇಷನ್ ಡ್ರೈವ್ ಅಷ್ಟೇ. ಇನ್ನೊಂದು ಬರ್ಬೇಕು ಶೀಟ್. ನಿಮ್ಮ ಹತ್ರ ಎಷ್ಟಿದೆ ಫೈಲ್ ಇದೆಯಾ ಅಲ್ಲಿ? ಆ ಕಡೆ ಏನೋ ಒಂದು ಇಟ್ಟಿದ್ದಾರೆ, ಅದು ಕೊಟ್ಟಿಲ್ವಾ? ಹಾ ಆಯ್ತು. ಯಾವ್ದು 2310 ಬಂದಿಲ್ವಾ? ಅದು ಕೊಟ್ಟೇ ಇಲ್ಲ, ತೆಗಿಬೇಡಿ ಅಂತ ಈಗಲೇ ಕೇಳ್ಬೋದಾಗಿ. ಹಾ ಅದೇ ಆಪ ಈ ಸಲ ನಾನೇನು ಹೇಳಲ್ಲ, ಏನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ. ಅವರು ಕಾಯ್ತಾ ಇರ್ತಾರೆ. ಹೆಂಗೆ ಹೇಳ್ತಾರ ನಮ್ಗೆ ಅಲ್ಲ. ಫೈನಲ್ ಇಯರಿಂಗ್ ಇಲ್ಲ ಸರ್. 53 ಮೆನ್ಷನ್ ಏನು ಮಾಡಿಲ್ಲ, ಇದೆ ತಗೊಳಲ್ಲ, ಹೋಗ್ಬೋದು. ನೀ ಯಾವಾಗ್ಲೂ ತಂದು ಕೊಡ್ತೀಯಪ್ಪ. ಎಷ್ಟು ಯಾವ್ದು ಹಾಕಿದ್ಯಾ? ಇವತ್ತೊಂದೇ ಹಾಕ್ಬಿಟ್ಟಿದ್ಯಾ? ಒಂದು ನಿಮಿಷ ಸೀದಾ ಇದೊಂದು ಸೋಮವಾರ ತಗೊಳ್ಳಿ, ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಆಗಬೇಕು. 3 ದಿವಸದಿಂದ ಅಲ್ಲೇ ಇಟ್ಕೊಂಡು ಸೋಮವಾರ. ಹಾ 2ನೇ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್. ಹಾ ಮೇಲೆ ಮಾಮೂಲಿ ನಾವ್ ಹೆಂಗ್ ಮಾಡ್ತೀವಿ ಹಂಗಿರಪ್ಪ, ನಿನ್ ಕೈಗೆ ಕೊಡ್ತೀನಿ. ಆ ಫೈಲ್ ಎಲ್ಲಿದೆ ಅಂತಾನು ಹೇಳ್ಬಿಡ್ಬೇಕು ಅವ್ರು. ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಆಗಬೇಕು, ಬುಕ್ಕಲ್ಲಿ ನೋಟ್ ಹಾಕ್ತೀವಿ. 55 ಅಲ್ವಾ ನೀವು ಕೇಳಿದ್ದು? ಇನ್ನೊಂದು ಕೇಳ್ತಾ ಇದ್ದೀರಾ? ಆಯ್ತು, ಅದು ಇದೆ. ಅದ್ಯಾಕೆ ಡಿಲೇ ಮಾಡ್ತೀರಾ? ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಆಗಂತ ಫೈಲ್ ನಾನು ಅವ್ರಿಗೆ ಹೇಳಿ ಸಾಕಾಯ್ತು. ಮೇಲೂ ಒಂದು ನೋಟ್ ಹಾಕೊಂಬಿಡಿ ಶ್ರೀಧರ್, ಮಂಡೇ ಅಂತ. ಮಾಮೂಲಿ ನೀವು ಮಂಡೇ ಅಂತ ಮೇಲೂ ಹಾಕ್ತೀರ. ಆ ಇವನಿಗೆ ಉಮೇಶನ್ಗೆ ಹೇಳ್ಬಿಟ್ಟು ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಆಗೋಂಥ ಫೈಲ್ ಅಂತ ಹೇಳು. ಅವ್ನು ಅಲ್ಲಿ ವಿಶ್ವ ಬಂದಿಲ್ಲ ಅನ್ಸುತ್ತೆ. ಫೈಲ್ ನಾನು ಅಲ್ಲಿ ತರ್ಸ್ಕೊಂಡಿದ್ದೀನಿ, ಬೋರ್ಡಲ್ಲಿ ಇದೆ ಅದು. ಆಯ್ತಾ ಊಟ? ಇದೆ ಸರ್, ಇದೆ. ಗಿರೀಶ್, ಆ ಮೆಮೊ ಬುಕ್ ಕೊಡಿ ಗಿರೀಶ್, ಒಂಚೂರು ಮೆಮೊ ಬುಕ್ ಕೊಡಿ. ಇದೊಂದು ಮೆಮೊ ನಾನು ಇಲ್ಲೇ ಡೈರೆಕ್ಟ್ ಆಗಿ ಕೊಟ್ಟಿರ್ತೀನಿ, ಅವ್ನು ನಾಳೆ ಸೈನ್ ಹಾಕ್ಸ್ಕೊಡ. ತಾಳಪ್ಪ, ಫೈಲು ಬೋರ್ಡ್ ಬ್ರಾಂಚಲ್ಲಿ ಇದೆ. ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಆಗಬೇಕು, ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟ್ರ್ ಬೇರೆ ಅಂತ ಹೇಳ್ಬೇಕು, ಡಿಸೇಬಲ್ ಅಂತಾನು ಹೇಳ್ಬೇಕು. ಮಂಡೇ ಡೇಟ್ ಕೊಟ್ಟು ಅಷ್ಟೇ. ಅದ್ರಲ್ಲಿ ನೀವು ನೋಟ್ ಹಾಕೊಳ್ಳಿ, ನಾನು ಆಮೇಲೆ ಸೈನ್ ಹಾಕ್ಸ್ಕೊಡಿ. ಬರ್ದಿದೆಯಲ್ಲ ಮೆಮೊಪ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಸ್ಪೆಷಲ್. ಮೇನ್ ನಂಬರ್ ಯಾವ್ದಿದ್ರಲ್ಲಿ? ಫಸ್ಟ್ ಇರೋದು ಮೇನ್ ನಂಬರ್ ಅಲ್ಲ, ನೀನು ಅದೇ ತಪ್ಪು ಮಾಡಿದ್ಯಾವ, ಹುಡ್ಕೋದಕ್ಕೆ ಕಷ್ಟ ಆಯ್ತವ. ಫಸ್ಟ್ ಅಲ್ಲ ಮೇನ್ ನಂಬರ್. ಮೇನ್ ನಂಬರು 4723. ಅದು ಮೇನ್ ಅಂತ ಹೇಳ. ನೀನು ಉಮೇಶನ್ ಕೈ ಕೊಟ್ಟಲ್ಲಿ. Serial number 47, continuation of list, Ranganath S. Joyce for petitioner, Achappa PB.
Yes. When the petitioner is appointed?
Petitioner
Petitioner was appointed 2013, my lord.
2013.
Annexure B, my lord, page number 16.
Annexure?
Annexure B, page number 16.
Yes.
What about
25/11/2013.
13, my lord.
Yes.
Okay.
And the appointment has been approved by the authority and probation declared, my lord, as per annexure E, page number 19.
Yes.
ಬೆಳೂರು ಗ್ರಾಮ ಪಂಚಾಯತಿ 16 ಸಭೆಯಲ್ಲಿ ನೇಮಕಾತಿಯನ್ನು ಸಿಂಧುಗೊಳಿಸಿ ಸಭಾ ನಡೆವಳಿಕೆ ವಿದ್ಯಾರ್ಥಿಗಳ
What about the
ದಾಖಲಾತಿ.
respondent?
Respondent, my lord, she was appointed. The last her name, she was not there in the earlier seniority list, but in the subsequent seniority list, page number 40, annexure N.
Annexure L.
And N, page number 40, it starts, my lord.
Yes.
Her appointment, my lord, the lordship may kindly see column number 7, I think. Data entry ಹುದ್ದೆಗೆ ಸೇರಿದ ದಿನಾಂಕ. 16/4/2007. Column number 8, my lord, is ಗುಮಾಸ್ತಾ so 14ರ ಸುತ್ತೋಲೆಯಂತೆ ಕ್ಲರ್ಕ್ ಕಮ್ ಡಿಇಒ ಹುದ್ದೆಗೆ ಪರಿಗಣಿಸಿದ ದಿನಾಂಕ. ಅದು 2020. Your lordship may kindly see 1/3/2020.
Column number
8,
5.
my lord, 8.
Column number 5 is what?
Date of birth.
ಜನ್ಮದಿನ.
Date of ಜನ್ಮ ದಿನಾಂಕ ಅದೆಲ್ಲ ಸಂಬಂಧ.
ಡಾಟಾ ಎಂಟ್ರಿ ಹುದ್ದೆಗೆ ಸೇರಿದ ದಿನಾಂಕ 7.
7. ಆಮೇಲೆ 8 is important, my lord. Column number 8 is important. Column number 8 ಏನು ಅಂದ್ರೆ ಗುಮಾಸ್ತಾರ್ ಅವರು ಹುದ್ದೆಗೆ ಸೇರಿದ ಹಾಗೂ 2014ರ ಸುತ್ತೋಲೆಯಂತೆ ಕ್ಲರ್ಕ್ ಕಮ್ ಡಿಇಒ ಹುದ್ದೆಗೆ ಪರಿಗಣಿಸಿದ ದಿನಾಂಕ. ಅಂದ್ರೆ ಅವರ ಪೋಸ್ಟ್ಗೆ
1997 ಫಸ್ಟ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗಿದ್ದ.
97 ಅಲ್ಲ, ಡೇಟ್ 2007 ಅಂತ ಹೇಳ್ತಾರೆ. ಅದು ಟೆಂಪರರಿ ಅಪಾಯಿಂಟ್ಮೆಂಟ್, ಅವೆಲ್ಲ ರೆಗ್ಯುಲರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಅಲ್ಲ, ಟೆಂಪರರಿ ಅಪಾಯಿಂಟ್ಮೆಂಟ್. Until the appointment is approved as per the order, it is not an appointment. Page number 8, column number 8 ಅಲ್ಲಿ, column number 8 ಅಲ್ಲಿ.
8 is what?
8 is government order issue ಮಾಡಿ, government order
ಪರಿಗಣಿಸಿದ ದಿನಾಂಕ.
ಅದ್ರ ಪ್ರಕಾರ ಅವ್ರಿಗೆ 2020, kindly see 2020, my lord. ಆಮೇಲೆ ಅಪ್ರೂವಲ್ ಕೊಟ್ಟಿದ್ದ ಡೇಟ್. ನೆಕ್ಸ್ಟ್ ಕಾಲಮ್ ಇಸ್ ಮೋರ್ ಇಂಪಾರ್ಟೆಂಟ್. ಕಾಲಮ್ ನಂಬರ್ 9 ಏನ್ ಹೇಳುತ್ತೆ, ಜಿಲ್ಲಾ ಪಂಚಾಯಿತಿಯಿಂದ ಅನುಮೋದನೆಯಾದ ದಿನಾಂಕ 17/3/22. ನಂದು ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ಮೈ ಅಪಾಯಿಂಟ್ಮೆಂಟ್, ಪೇಜ್ ನಂಬರ್ 26. ಪೇಜ್ ನಂಬರ್ 26, my lord. ಕಾಲಮ್ ನಂಬರ್ 7 ನಲ್ಲಿ 2/2/2013 ನಲ್ಲಿ ಅಪಾಯಿಂಟ್ಮೆಂಟ್. 16 ಅಲ್ಲಿ ಕಾಲಮ್ ನಂಬರ್ 8 ಪ್ರಕಾರ ಅಪ್ರೂವಲ್ ಪ್ರೊಬೇಷನ್ ಡಿಕ್ಲೇರ್ಡ್. 8 ಅಲ್ಲಿ ಕಾಲಮ್ ನಂಬರ್ 8 ಪ್ರಕಾರ ಗುಮಾಸ್ತರ್ ಹುದ್ದೆಗೆ ಸೇರಿದ ಹಾಗೂ ಹುತ್ತೋಲಿಯಂತೆ ಡಿಇಒ ಹುದ್ದೆಗೆ ಪರಿಗಣಿಸಿದ ದಿನಾಂಕ 30/12/16. ಆಮೇಲೆ ಕಾಲಮ್ ನಂಬರ್ 17 ಅಪ್ರೂವಲ್. ಕಾಲಮ್ ನಂಬರ್ 9 is approval. So my appointment probation.
Yes, what is it?
My lords, the objections on threefold, my lords. Yes. One, there is only one sanctioned post insofar as this particular post is concerned. Second, the appointment had to be.
You are also appearing for the panchayat.
I'm appearing for the panchayat. Yes. I'm only appearing for the panchayat.
Yes.
Panchayat and the CEO also, my lords. Yes. Now, the appointment is in the year. The prior approval of the Zilla Panchayat had to be taken before this appointment has to be done. It's not been done, my lords. For that, I have produced annexure R1.
Whose appointment?
Prior to appointment of the petitioner. For that, I have produced annexure.
How you have approved then?
My lords, subsequently it has been approved, my lords, because what happened was there was a writ petition. The respondent number 3 was taken away from the job because of misconduct.
No, you forget about that.
Those aspects.
No, petitioner's proposal has been sent to you.
Yes, my lords.
How you have approved?
Based on the proposal which came to me subsequently, I have approved, my lord. There is no difficulty.
Approve all proposal, if you send it, you will not verify that whether.
That is because at that point in time, my lords, the order of the, this thing had not become final, my lords. That's the reason, the writ court order or the WA.
You forget about, I will come to that writ court. What the writ court said?
My lords,
by annexure E, you have approved the appointment of that petitioner.
Please.
Is it accordance with law or not?
That is, my lords, it was subject, because the appointment itself was subject to the outcome of the, my lords, what happened was.
Where is that, you said it is.
We have not stated so, my lords. What happened was the writ petition which was filed by the respondent.
No, before filing the writ petition, you have approved. How can you say subject to the writ petition?
My lords.
2014.
Writ petition filed by Pavitra, my lords.
Yes.
Pavitra was dismissed from the services. Pavitra comes to the court after a delayed process. She comes to the court, and because she does not approach the court within a particular point.
Have you recommended Pavitra's case also for approval?
Well, subsequently, after the order of this honorable court, where the revision petition was also heard and disposed of, the appointment of the petitioner herein was cancelled, and her name was shown in the seniority minutes. This is what happened in the whole chronology of events, because there was a delay in Pavitra approaching the High Court in the writ proceedings challenging her dismissal. The appointment of Netravati took place, who is the petitioner before this honorable court. I am proceeding on the assumption, my lords, that any appointment which is subject to a writ proceedings, which is challenged at a later date after the appointment, is only based on the outcome of the writ petition, my lords. In a writ petition, now, because why I say that, my lords, is because
your recommendation is on the ground that till that has to be decided, you have clearly sent in a recommendation.
We have not in specific terms said that, my lords. It has to be deemed as my submission.
No, that what is that process which has been adopted in appointing that Pavitra?
Pavitra, my lords, as my learned senior read it out, my lords, the appointment is by way of the annexure D, page number 16, my lords. This is the Kacheri Adesha of the Gram Panchayat. That is where the appointment happens. Prior to this, they had to take an approval of this thing. Technically, they have failed in that, my lords.
Whose case?
In the case of Netravati, my lords, the petitioner's case.
Where is that provision? They have
provision, my lords, annexure R1, page number 15, my lords, 14 onwards. R1, page number 14, my lords. This was sent to the government, and this reference is also made in the order of the DC.
Come to that. What is the difference between petitioner and Netravati?
My lords, I'll read only the para which is page number 14, my lords, 14 and 15.
Yes.
Commences at page number 14.
Yes.
The relevant portion. What is referred is on the first row, my lords, and the Spashtikarana is in the second row. Third row, rather. So I'm at page number 14, my lords. The relevant portion is this. What was referred to the government is this, my lords. Somarpete Taluku Panchayati Vyaptiyalli Belluru Grama Panchayatiyalli 2007 ರಲ್ಲಿ ಈ ಮಹಾತ್ಮ ಗಾಂಧಿ ಗ್ರಾಮೀಣ ಉದ್ಯೋಗ ಖಾತ್ರಿ ಯೋಜನೆಯ ಅಡಿಯಲ್ಲಿ ಶ್ರೀಮತಿ ಪವಿತ್ರ ಎಂಬುವರನ್ನು ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ ಆಗಿ ನೇಮಕಾತಿ ಮಾಡಿಕೊಳ್ಳಲಾಗಿತ್ತು. ಸದರಿ ನೌಕರರ ಮೇಲಿನ ಆರೋಪಗಳಿಂದ 2013ರಲ್ಲಿ ಸಾಮಾನ್ಯ ಸಭೆ ಸದರಿ ನೌಕರರನ್ನು ಅಮಾನತು ಮಾಡಲಾಗಿರುತ್ತದೆ. ಐ ಮೀನ್ ಪೇಜ್ 15 ಮೇಲೆ ಮಾಡಲಾಗಿರುತ್ತದೆ. ತದನಂತರ ತೆರವಾದ ಹುದ್ದೆಗೆ 2014ರಲ್ಲಿ ಕುಮಾರಿ ನೇತ್ರಾವತಿಯನ್ನು ಪಂಚಾಯಿತಿ ಸಾಮಾನ್ಯ ಸಭೆ ನಿರ್ಣಯದಂತೆ this is important, my lords. ನೇತ್ರಾವತಿಯನ್ನು ಪಂಚಾಯಿತಿ ಸಾಮಾನ್ಯ ಸಭೆಯ ನಿರ್ಣಯ ಕ್ಲಾರ್ಕ್ ಕಮ್ ಡೇಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ ಆಗಿ ನೇಮಕಾತಿ ಮಾಡಿಕೊಳ್ಳಲಾಗಿದ್ದು, ಜಿಲ್ಲಾ ಪಂಚಾಯಿತಿ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಹಣಾ ಅಧಿಕಾರಿಯವರಿಂದ ಸದರಿ ಹುದ್ದೆಗೆ ಅನುಮೋದನೆಯನ್ನು ಕೂಡ ಪಡೆದುಕೊಂಡಿರುತ್ತಾರೆ. ತಮ್ಮನ್ನು ಕರ್ತವ್ಯದಿಂದ ತೆಗೆದು ಹಾಕಿರುವುದರಿಂದ ವಿರುದ್ಧ ಶ್ರೀಮತಿ ಪವಿತ್ರರವರು ನ್ಯಾಯಾಲಯದ ಮೊಕದ್ದಮೆ ದಾಖಲಿಸಿದ್ದು, ನ್ಯಾಯಾಲಯದ ಅಂತಿಮ ತೀರ್ಪಿನಲ್ಲಿ ಮರು ನೇಮಕಾತಿ ಮಾಡಲು ಸೂಚಿಸಿರುವ ಮೇರೆಗೆ ಶ್ರೀಮತಿ ಪವಿತ್ರರವರನ್ನು ಬೆಳ್ಳೂರು ಗ್ರಾಮ ಪಂಚಾಯಿತಿಯಲ್ಲಿ ಕ್ಲಾರ್ಕ್ ಕಮ್ ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ ಎಂದು ಮರು ನೇಮಕ ಮಾಡಿರುತ್ತಾರೆ. ಆದರೆ ಇವರ ಹುದ್ದೆಗೆ ಜಿಲ್ಲಾ ಪಂಚಾಯಿತಿ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಹಣಾಧಿಕಾರಿ ಅನುಮೋದನೆ ಪಡೆಯದೆ ಅನುಮೋದನೆಗಾಗಿ ಪ್ರಸ್ತುತ ಸಾಲಿನಲ್ಲಿ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ಸಿಬ್ಬಂದಿ ಪ್ಯಾಟರ್ನ್ ನಲ್ಲಿ ಒಂದು ಕ್ಲಾರ್ಕ್ ಕಮ್ ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ ಹುದ್ದೆ ಮಂಜೂರಾಗಿರುವುದರಿಂದ ಪೇಜ್ ನಂಬರ್ 16 ಮೆಲೋಡ್ಸ್, ಈ ಪ್ರಕರಣದಲ್ಲಿ ಗೊಂದಲವಿರುವುದರಿಂದ ಸೂಕ್ತ ಮಾರ್ಗದರ್ಶನ ನೀಡುವ ಬಗ್ಗೆ is this thing ಮೆಲೋಡ್ಸ್. I'll again have to come to page 14 ಮೆಲೋಡ್ಸ್. ಶ್ರೀಮತಿ this is how ವಿಶ್ಲೇಷಣೆ is ಮೆಲೋಡ್ಸ್, the ಸ್ಪಷ್ಟೀಕರಣ. ಶ್ರೀಮತಿ ಪವಿತ್ರ ಇವರನ್ನು ಬೆಳ್ಳೂರು ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ಕ್ಲಾರ್ಕ್ ಕಮ್ ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ ಹುದ್ದೆಯಿಂದ ತೆಗೆದುಹಾಕಿರುವ ಬಗ್ಗೆ ಸದರಿ ಅವರು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಮೊಕದ್ದಮೆ ದಾಖಲಿಸಿರುವುದು. ಕುಮಾರಿ ನೇತ್ರಾವತಿರವರು
ಇವ್ರನ್ನ ಯಾರನ್ನ ನೇತ್ರಾವತಿ is the petitioner, no?
Yes.
How she was working earlier or she
No,
was?
my lord, she was not working earlier. What happened was after the dismissal of Pavitra, Netravati was appointed in 2014. Pavitra was dismissed in 2013. She came to the court much after. So during this period, there was no foresight to say she will come to the High Court and her order will be challenged because there was a delay. Subsequently, her appointment came in through as a regular appointment itself. And one mistake which happened, or the Panchayat did not look into, is they did not take the CEO's permission prior to her appointment, which is the requirement under the regulations.
Is that rule says
My lords, if I can just point out this, my lords, page 15 would be the relevant second paragraph, my lords.
Yes.
ಪ್ರತಿ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ಒಂದು ಕ್ಲಾರ್ಕ್ ಕಮ್ ಡೇಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ ಹುದ್ದೆಗೆ ಮಂಜೂರಾಗಿರುವುದು. ಸೊ ದಟ್ ಇಸ್ ಓನ್ಲಿ ಒನ್ ಸ್ಯಾಂಕ್ಷನ್ ಕ್ಲೋಸ್ಡ್. ಸರ್ಕಾರದ ಸುತ್ತೋಲೆ ಸಂಖ್ಯೆ 174 ಗ್ರಾಮ ಪಂಚಾಯಿತಿ 2018 ದಿನಾಂಕ ಸೋಯನ್ಸರಲ್ಲಿ ಜಿಲ್ಲಾ ಪಂಚಾಯಿತಿಯ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಹಣಾಧಿಕಾರಿಗಳ ಪೂರ್ವಾನುಮೋದನೆ ಪಡೆದು ಮಂಜೂರಾದ ಹುದ್ದೆಗಳಿಗೆ ಗ್ರಾಮ ಪಂಚಾಯಿತಿಗಳು ನೇಮಕಾತಿ ಮಾಡಿಕೊಂಡು ದಿನಾಂಕ 31/10/2017 ಪ್ರಸ್ತುತ ರಾಜ್ಯದ ಗ್ರಾಮ ಪಂಚಾಯಿತಿಗಳ ಸಿಬ್ಬಂದಿ ವರ್ಗದ ಮಾದರಿಯಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ನೌಕರರಿಗೆ ಜಿಲ್ಲಾ ಪಂಚಾಯಿತಿಯ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಹಣಾಧಿಕಾರಿಗಳ ಅನುಮೋದನೆ ನೀಡುವ ಬಗ್ಗೆ ಸ್ಪಷ್ಟವಾಗಿ ವಿವರಿಸಲಾಗಿದೆ. So they had to take a prior approval is what it says, my lords. This is where it is. But off the record, I would only submit this, my lords. There is a shortage of hands in the panchayat insofar as data operators are concerned. I am given to understand, my lords, that the petitioner is a good hand and she is a diligent worker. Yes. And there are three contentions that I have taken, which are the contentions which I had to place on record, my lords. I have placed it by way of objections before this honorable court. One, there is only one sanction post.
No, that how we will accommodate to the petitioner now?
Now, she'll have to be transferred, or Pavitra will have to be transferred. And the other information is, my lords, Pavitra is under suspension as of now, is my information.
Now she is under suspension.
Is what my information is, my lords. So
then you continue the petitioner there.
I'll only leave it to the court, my lord.
Earlier also for taking money, she was terminated, my lord. Even respondent, she was earlier terminated.
I can only place it off the record, my lords, not on the records.
Per month. After imposing the cost, courts has allowed that.
And even the petition, my lords,
for the respondent to recover the cost amount from the entering officer.
Netravati.
Petition is succeeded, dismissed the petitioner from service, set aside. Direction is issued to respondent to reinstated in service with the contrary. So 50% back wages with that there is a direction.
Yes, my lord.
But this will not bar you to initiate the inquiry by issuing that following the procedure of law. Court said only you are not following the
inquiry initiate madilla.
Now that inquiry, I don't think they are going back on that. They're treading that path, my lords, because she's continued.
Now she has been kept under suspension for what?
Some other reasons, my lords. There are complaints and things like that.
You taken a decision on that. Let it be pending. If she is again dismissed from the service, he can be continued. Now you can't take both.
I cannot take both, my lords. That's the reason I have placed the formal objections I have placed on record, my lords.
Yes,
I cannot support the case of Netravati because there are technical issues in this.
Now that let that inquiry be completed. You start
that can be completed, my lord. Question is, my lord, question is.
The only thing that I can look
at. What is the purpose of keeping suspension, Mr.?
I can only place it before the court, my lords. What is within my knowledge, I can place it before the court, and that too off the records.
No, if there is the allegation, you take an inquiry, and if it is proved and come to the conclusion, then petitioner. Otherwise,
and the other technical objections that I have taken is also, my lords, in the writ petition, they were respondent before the writ court in the petition that Pavitra had filed. They filed the appeal. After the review, it's not open. The review court only said you explore the possibilities under the under what is available under law. In my humble opinion, my lords, is the appeal which they had to file. They cannot choose to come before this court in a writ proceedings and challenge this process.
Let us say we'll have it after 3 weeks. If that, what is that, Pavitra? If she is out of job, then she will get it. Otherwise,
Then again, it becomes another round of litigation where she might challenge that order and those
no, but
aspects.
if you are doing in accordance with law, if she challenge also, it will go.
That's
But not do like that without giving in a notice and all. That's what that problem arises.
Many a times that's
My lord,
the, and I
my
don't
lord, my
stand
lord,
to, stand to.
my lord, as on today, my lord, as on today, my learned friend
Raise the
repeatedly
consent.
said they have not taken the approval anta. Annexure E page number 19 alli, Chief Executive
Prior
Officer
approval is
Jilla
what I'm saying, not post
approved my
approval.
appointment, declared my probation. Your termination order on the ground that he has made illegal
Prior approval is
entry.
not taken. You see, there is
But
one post.
taken,
No,
page number
even
19, Annexure E.
even assuming that there is one post. Now that any appointment, if you are made, if there is any case pending, it is subject to that. If she succeeded, then you have to go back. Where she will be placed now?
No,
There is a
no,
court
my
order to
when the
reinstate.
Supreme Court has time and again, Supreme Court has said even in cases of a selection being challenged belatedly, if selected candidate succeeds, the person who is appointed according to law in the absence of the person cannot be disturbed. My probation has been, because the government cannot eternally wait
No,
for a person to.
that would be the ground available for you to challenge in that appeal, saying that she cannot be directed to, reinstate.
Appeal is
You could have been taken
Reinstate
that
madle,
ground.
reinstated in the capacity in which she was terminated.
Yes.
She was
Where will be
terminated as a
reinstated?
temporary employer. She was terminated as a temporary employee. She can be put back as a temporary employee, whereas my appointment has been appointed, approved by the Chief Executive Officer and probation
No.
declared all these.
Where is that provision to take two, one for regular, one for temporary? They can take only one.
No. She was out of service. There was no stay order. She was out of service. The post was vacant. I have been appointed after due process and approved by the Chief Executive Officer.
You
Probation
produce that and
declared
you
as
have
early
to
as in
produce it saying
2017.
that it's all subject to the result of the writ petition if any action is taken.
My lords, my only submission is, my lords, my learned friend could have contended this in the earlier writ petition itself in the strength of it. They did not choose to
No,
do it.
let us see what is that law on that point.
I will
Yes.
make some effort.
Leave this matter after 2 weeks published.
Date may be fixed, madam.
32. Yes, interim order extended if yes.
Published.
Interim order, ಅದರಲ್ಲೂ ಕೂಡ interim order ಇದೆ. Interim order granted earlier is extended. Yes.
Cell number 48, Sandesh Shetty T for petitioner, connected matter, Ranjan Kumar K.
Cell number 48. Last year, this matter was fully heard and directed to take instruction in respect of 5(8) of the Education Act 1983. That is the issue.
Yes, let us see what is. You are ready?
Yes, I'm ready.
Yes. Yes, Mr. What is?
My petition is in respect of the candidates.
Yes.
And they have been appointed as the teachers in respect of the respondent school, respondent of the 6 school members. To the posts of Kannada, Science, Arts, and Maths. In fact, initially after the approval of the post and as per the permission accorded by the commissioner of the.
What is your matter? School also seeking for. No, what is that mandamus you are seeking? Annexure E.
The mandamus to direct the appropriate authority to approve the appointments. As far as my case is concerned, my lord, I am seeking for the mandamus to approve the appointments of the teachers.
What is that management seeking?
Management seeks that to scratch the endorsement given by the authorities.
ಅದು ಕೊಡಿ ಏನು ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
Annexure D,
Page number 20.
Page number 20. Annexure G in my petition. Page number 28.
Annexure G.
Annexure G.
What is that email ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ?
ಈ ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪರ್ಕಳ ಪ್ರೌಢಶಾಲೆ ಪರ್ಕಳ ಇಲ್ಲಿ ಕಾನೂನು ಉದ್ಯೋಗ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರದ ಅನುಮತಿ ಪಡೆದೇ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸುತ್ತೇವೆ. ಆದ್ದರಿಂದ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರದ ಹುದ್ದೆ ಭರ್ತಿಗೆ ಅನುಮತಿ ಪಡೆದು ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸುತ್ತಿದೆ. Sadarin Rasta on them, and I was in the side. But I relied on the judgment. Already I have given it.
Yes, have you seen that judgment?
Yeah, coordinate bench has passed the judgment. The similar circumstances with respect to appointment details, with respect to grant details.
Yes.
Yes, sir. Copy.
Read out paragraph 4. This statement, if this statement supports the petitioner's case on the first ground, this court must observe that this court issued on 8/12/2023 in WP number 11667 of 2022, the question of granting the approval for the petitioner's appointed by the institution must necessarily be considered in light of such decision. This court's conclusion in the aforesaid petition on the need of prior approval reads as under. 120. In view of the observation above, the repetition is allowed and it is hereby held that clause 2 annexure 1 of 1999 rules and rule 17 of the 2006 rules, which requires obtaining prior permission to fill up the vacancies, is held down to mean that the education institutions are required to only inform the competent authority that they are filling up the vacancies which have been arising due to retirement, resignation, promotion, and death.
No, this is arising out of what? Superannuation. Have you intimated?
Yes, we have.
Where is it?
In my petition, annexure C minutes in page number 16. Intimated and permission is accorded from the commissioner office also.
Where is it? Annexure?
Annexure C in page 16.
What is
ಸಂದರ್ಶಕ ತಮ್ಮ ಇಲಾಖಾ ಪ್ರತಿನಿಧಿ ಗಳಿಸಿರುವ ಬಗ್ಗೆ ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಮ್ಮ ಪ್ರೌಢಶಾಲೆ ತೆರವಾಗಲು 4 ಬೋಧಕ ಹುದ್ದೆಗಳು ತೆರವಾದ ಸಹಕಾರ ಸಚಿವಾದ ಪ್ರಧಾನ ಕಾರ್ಯದರ್ಶಿಗಳು ಶಾಲಾ ಶಿಕ್ಷಣ ಮತ್ತು ಸಾಕ್ಷರತಾ ಇಲಾಖೆ ಬಹುಮಾನ್ಯ ಕಲ್ಪಿದೆ ಬೆಂಗಳೂರು ಇವರ ಆದೇಶ ಸಂಖ್ಯೆ EP ನಂಬರ್ 106
Is there any vacancies which is related to that SC/ST? No, that you reconsider taking in view of that judgment of this court. Reconsider that this court.
Before that, the department permission should be obtained for filling up the vacancies in private aided schools, private high schools, which they have not.
No, that is the judgment of this court that has been read down saying that permission is not necessary, only information has to be given. That's all. That has been considered, validity has been challenged and court has said that no permission, if it is already existing post which has been vacant because of retirement, only they have to be intimated and you cannot reject that on financial ground. That's also court said. But it is an right.
In respect of vacant post is concerned, we have issued a circular on 6/9/2020 saying that ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಉಲ್ಲೇಖ 1ರ ಸರ್ಕಾರ ಆದೇಶಕ್ಕೆ ಪೂರಕವಾಗಿ ಈ ಕಚೇರಿಯಿಂದ ಸುತ್ತೋಲೆ ಹೊರಡಿಸುವವರೆಗೆ 1/1/16 31/12/20 ನಿವೃತ್ತ ವಿಧಾನ ರಾಜೀನಾಮೆ.
No, your endorsement says without taking prior permission. That has been certified by this court. Therefore, endorsement on this ground will not sustain. If there is any other grounds which is available in law, taking into the consideration of this judgment and you decide it.
Kindly appreciate the fact that your permission is also accorded in this case. Commissioner of this commission has.
Then why they have given this endorsement, that permission? ಎಲ್ಲಿದೆ ನಿಮ್ದು ಇದರಲ್ಲಿ?
Annexure H. In respect of this particular school, they have mentioned and permission is accorded.
ಜೊತೆಯು ಜಿಲ್ಲೆಯಲ್ಲಿ ಅನುದಾನಗೊಳಪಟ್ಟ ಖಾಲಿ ಇರುವ ಬೋಧಕ ಹುದ್ದೆಗಳನ್ನು ಭರ್ತಿ ಮಾಡುವ ಅನುಮತಿ ನೀಡುವ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಿ ತಮ್ಮ ಸ್ಪಷ್ಟ ಅಭಿಪ್ರಾಯಕ್ಕೆ ಸೂಕ್ತ ಪ್ರಸ್ತಾವನೆ ಸರ್ಕಾರ ಸಲ್ಲಿಸುವಂತೆ ತಮ್ಮಲ್ಲಿ ಎಲ್ಲಿ ಅನುಮತಿ ಇಲ್ಲ ಇದು.
ಇದನ್ನು ಕಳಿಸಿದಂತೆ ನಾವು ಅನುಮತಿ ಕೇಳಿದ್ದೇವೆ and it is also referred to the Parkala school.
ನೋ, ಷರತ್ತು ಮತ್ತು ಪ್ರಾಥಮಿಕ ಶಾಲಾ ನೇಮಕಾತಿ ಷರತ್ತು ಮತ್ತು ಪ್ರಸ್ತುತ ಸದರಿ ಶಾಲೆಯಲ್ಲಿ ನಿವೃತ್ತಿ ರಾಜೀನಾಮೆ ಮರಣದಿಂದ ಜಿನ ಹೆಚ್ಚ 20 ಎಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ? ಅದು ಬರೀ ಜಿನೇ ಲಾಸ್ಟ್ ಇದೆಯಲ್ಲ ಇಲ್ಲಿ. ಯಾವ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ರೆಫರ್ ಮಾಡ್ತಿದ್ದೀರಾ? ನಿಮ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಯಾವ್ದ್ರಿ? Chetty, in your petition I am referring, which is that question? Annexure? ನಿಮ್ದ್ರಲ್ಲಿ ಅನಕ್ಷರ ಹೆಚ್ಚೇ ಇಲ್ಲಲ್ರಿ?
Annexure G, my lords.
ಅದೇ ಜೀನೇ ಸದರಿ ಶಾಲೆಯ ನಿವೃತ್ತಿ ರಾಜೀನಾಮೆ ಮಾಡುವ ಸೂಕ್ತ ಅಭ್ಯರ್ಥಿಯಿಂದ ನೇಮಕ ಮಾಡಿಕೊಂಡು ವೇತನಕ್ಕೆ ಒಳಪಡಿಸುವ ಕುರಿತು ನಿಯಮಾನುಸಾರ ಪರಿಶೀಲಿಸಿ ತಮ್ಮ ಸ್ಪಷ್ಟ ಅಭಿಪ್ರಾಯದೊಂದಿಗೆ ವರದಿ ಸೂಕ್ತ ಪ್ರಸ್ತಾವನೆ ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸುವಂತೆ ತಮ್ಮಲ್ಲಿ ಕೋರಲಾಗಿದೆ ಅಂತ ಅಷ್ಟೇ. ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಿವಿ ಅಂತಿಲ್ಲ. ನಾಟ್ ಪರ್ಮಿಷನ್. ಪರ್ಮಿಷನ್ಗೆ ಏನೇನ್ ಬೇಕಂತ ಬಟ್ ಯು ಹ್ಯಾವ್ ಇಂಟಿಮೇಟೆಡ್. ಇಂಟಿಮೇಷನ್ ಇಸ್ ದೇರ್. ಎಸ್. ತಾಳಿ. ಈ ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಫಸ್ಟ್ ಹಾಕಳಿ. WP 27880 of 2024. And connected matter. In WP 27880 of 2024 has been filed by the management challenging the endorsement issued by BO respondent C5 wherein proposal sent by the management for approval of the appointment of the petitioners in WP number connected matter has been rejected on the ground that appointment has been made without taking prior approval from the authority. Annexure G, Nimda writ petition Annexure G 9/10/2023. The case of the petitioner that first petitioner is the society is running the education institution. It's running the education institution that is Verkala High School. Petitioner due to retirement, the post of, which are the posts, Mr. Due to that retirement of the teachers, the post of Kannada Science, Arts and Maths teacher post was vacant. All these posts were admitted to granting aid. The petitioner management has seek for approval of that authority for filling up that post. ಯಾವುದು annexure ನಿಮ್ದ್ರಲ್ಲಿ? From the authority as per annexure C. That Under Secretary, Department of Education also in communication wide annexure H dated 21/6/2022 to the commissioner to verify for issuing approval or for issuing permission to fill up that post. Thereafter, the management has conducted interview as per the rules and appointed the petitioner in writ petition so and so. Thereafter, send a proposal wide annexure F dated 4/10/2023 for approval of the 4 posts By impugn order annexure G, the proposal has been written on the ground that prior permission has been not obtained from the authority. Under rules, which is the rules?
Karnataka Education in 1983.
19?
Rule 58.
1983
na
1999 na?
1983 Rule 58.
Huh?
Next one, 1999 rule.
This is 1999 rules. He is saying that this is for which high school or college? High school. Which is that rule you are referring?
Rule 5 subclass 8 method. Based on the Karnataka Education Institution Rules, Rule 58 stipulates that the quorum for meeting of the regulating.
Already, rules are there. There are 2-3 rules are there, Mr.
Is referred annexure 1, 1999.
Yes, under that rules framed under that Education Act. Learned Counsel appearing for the petitioner has submitted that. This code in WP number 11667 of 2022 the education institution only required to inform the competent authority that they are filling that vacancy which have been arises due to the retirement, resignation, promotion or death in respect of the post which have been admitted to the granting aid. There need not be any approval from that authority. The operative portions of that order passed by this court in WP 11667 of 2022 disposed of on 8/12/2023 is extracted below. Adidu judgment alli para 116 extract madide adanna extract. He is also relied on judgment of this court in WP 17456 of 2024 disposed of on 22 July 2024, wherein following the judgment of this court in WP 11667 of 2022 as disposed of the writ petition. The relevant paragraph 5 of the judgment. In view of the above, the impugn endorsement which is issued, a impugn endorsement annexure G dated 9/10/2022 is required to be quashed, directing that who has to consider competent authority. Annexure E ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ? ನಿಮ್ದು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಯಾವ್ದು annexure? ಬಾಬು ಪೂಜಾರಿ, ಗಂಗದಗುಡಿ, ಪೆಡ ಅಂಚೆ, ಉಡುಪಿ ತಾಲೂಕು. ಅವಾಗ ಅನಕ್ಷರ್ಸ್ ಯಾವ್ದು ಹೇಳಿದ್ರಿ ನೀವು ರೆಪ್ರೆಸೆಂಟೇಷನ್? ಅನಕ್ಷರ್ ಎಫ್, ಅನಕ್ಷರ್ ಎಫ್ ಅಲ್ಲ? ಎಸ್. The competent authority is directed to reconsider that proposal sent by the management wide annexure F dated 4/10 7/10/2023 ಅಂತ ಹಾಕಿದಾರಲ್ಲ, ಅದು 7/10 ಗೆ ರಿಸೀವ್ ಮಾಡ್ಕೊಂಡಿದಾರ ಏನದು? ಸ್ವೀಕೃತಿ 7/10. ಎಸ್. ರೆಪ್ರೆಸೆಂಟೇಷನ್ a proposal dated 4/10/2023 in accordance with law, keeping in view of the order passed by this court in WP 11667 of 2022 disposed of on 8/12/2023 and WP 17456 of 2024 on connected matter disposed of on 22 July 2024 in accordance with law as expeditiously as possible, not later than 3 months from date of receipt of copy of this. Yes, elder no disposement.
Serial number 49, Sandesh Shetty for petitioner.
Same respect of granting here.
Hmm.
Ruling is minority institution. Committed to based on the fifth statement, connected matter.
Yes, leave this matter on 5th.
Serial number 50, Bola Vedavasa Shanai for petitioner. Ravindranath K.
ಅದು ರಿಸರ್ವ್ ಮೆಟಲ್ ಒಂದು ಕೊಟ್ಟರಲ್ಲ ಕಳ್ಸಿಕೊಟ್ಟಿಲ್ಲ.
I'm for respondent number 7. Please 1 week time. I represent K. Ravindra.
Yes, what is that?
Appointment. In 2022, the respondent number 2, this is a notification, this is an annex A. This is for the post of computer operator. Or for 4 posts. So it may not be serial number 2.
Page
A16.
16. Yes.
There are 2 posts under which I am to be considered. One is backlog post. There are 2 posts. So backlog 2A, backlog women's post, and 2A rural post. That is only these 2 posts are disputed in this rate petition. That is these 2 posts. So what happens when I write the exam? I am eligible under general merit and 2A rural merit.
No, this is backlog post.
One backlog post there, that is women's post, 2A women category, and fresh that current vacancy is 2A rural.
ಮೀಸಲಾತಿ ವರ್ಗೀಕರಣ ಎರಡನೇ ಹುದ್ದೆ. ಮೀಸಲಾತಿ ವರ್ಗೀಕರಣ ಅದು ಬ್ಯಾಕ್ಲಾಗ್. ನೋ, ಬ್ಯಾಕ್ಲಾಗ್ ಅಲ್ಲಿ 2 ಪೋಸ್ಟ್ ಇದೆ. ಒಂದು ಸಾಮಾನ್ಯ, ಒಂದು ಮಹಿಳೆ. You are not on backlog.
I am not on backlog.
Now that you are in that 2A rural. 2 ಪೋಸ್ಟ್ ಇದೆ, ಒಂದು 2A rural, ಒಂದು ಸಾಮಾನ್ಯ. Your concern is 2A rural. Yes, yes.
I write the exam methods. I am found in the provisional list, which is page number 36.
No, what is the criteria for selection? Merit or interview, anything? What is that?
Page number 17.
Yes. What are the qualifications? Computer operator. ಭಾರತೀಯ ಕಲ್ಯಾಣ ಕಂಪ್ಯೂಟರ್ ಚರ್ಚೆ ಪದವಿ ಅಕೌಂಟ್ಸ್ ಆಯ್ತು, ಅದು ಕ್ವಾಲಿಫಿಕೇಶನ್. Then
I write the exam. I give a written exam.
Written exam is there.
I found in the provision list, case number 36.
36. Yes.
I am serial number 2, my lord.
Yes, you are appearing for whom?
Respondent 7, K. Ravindranath, I am representing. K. Ravindranath, advocate, I am representing.
Yes, yes. Ready?
1 week time.
Why?
Senior is engaged in mediation case of High Court.
Yeah, what is that? Yes.
Only 2 posts, serial number 1. That is Harshita, and I am at serial number 2.
Page number?
36.
Yes, 36. 36 is that.
It is provisional merit list.
No, this is what 36. Not merit list. 36 is annexure D. Annexure E.
Annexure E, my lord. This is a provisional list.
Yes, you are in.
I am at serial number 2, my lord.
What is your name? Ajit.
Ajit
Kumar 2A.
2A, my lord.
57.75.
Yes. My lord, what happens is, my
Now,
lord,
where is that the respondent?
respondent is at serial number 8, my lord. What they have done is, my lord,
8.
what they have done actually, my lord, is that instead of first filling the backlog, they fill up rural first and then fill up women's quota, my lord. I am nowhere. I'm more meritorious than respondent number.
Now, out of this first, what they did?
What they have done is serial number 1. They should have given backlog with rural 2A women post to serial number 1. That is Harshita.
Harshita is claiming under 2A.
2A, my lord. So they should have given the women's backlog post to her.
It says that first backlog has to be filled, then the fresh vacancies in the reserve category. What they do is they first fill up the fresh and then to deny me my appointment, they give the post to Annapurna Badigan, which was at serial number 8 was less meritorious.
No, see, you are in Gramina.
Yes, sir.
You are rural.
Yes.
Then one is that only rural.
One is to a rural, one is to a woman backlog. They have to first fill up backlog, then they have to fill up to a rural. Means to deny me my selection, they select somebody who's got less marks than me in the women's quota. That is impermissible.
To a woman has been given to whom?
Annapurna Badigan.
Elide Annapurna Badigan. Harshita is the serial number 1. She is claimed under 2A.
She's been given to a rural.
She is to a rural.
She's been given to a rural. And to a woman has been given to serial number 8.
Wait. Let me understand. Harshita is 2A. She has claimed under 2A rural only.
To a rural and to a woman.
To a rural, to a woman. To a rural is general. To a rural Mahila Gramina. Oh, ಎರಡು 2A ನೇ ಬಂದಿದ್ಯಾ?
Yes, sir.
ಒಂದು 2A women and ಒಂದು 2A rural.
Yes.
She has claimed both.
Yes, she's entitled for both.
She is entitled for both. She has been given which post first?
She has been given to a rural, which is a fresh post.
Then they come to that
And they
backlog. They come later.
They will come later. First they have to give backlog. Then
Where is that? Where is that? If that is the case, it's end of the matter. Yes, Mr. Government Advocate, you have to stay. Which post has to be filled first? What is the law on that, Mister? Yes, which is that this thing?
My lords, I'll take you to the paragraph, relevant paragraph. My lords, page number 9, paragraph 28.
28. Yes.
Last 3 lines.
28 Vadi. 28 Vadi full.
Yes. We may also note the manner of filling up the sheets has been well enunciated in the judgment in K.R. Shanti's case, Supra, by the Madras High Court itself and appears to have consistently been followed. Maybe the peculiarity of the situation arising in chemistry subject, which is in question, gives rise to this problem in the current year, and such a problem has not apparently arisen earlier. In fact, there is no manner of doubt after the latest judgment of this court in Saurav Yadav and others case Supra, which again refers to the steps which have to be taken to fill in those vacancies. These steps are clear in the terms. In the given facts of the case, application of those principles or steps would imply A. The general merit list to be filled first. Backlog vacancies of the particular reserved category to be thereafter filled in first. And C.
General merit list to be filled in first.
Yes, that is not there. There is no
general merit. Yes.
Backlog vacancies of the particular reserved category, which in this case is 2A.
Yes.
To be filled up thereafter first.
Then remaining reserve vacancy.
Remaining reserve category. So they have to first fill up women category, then rural category. They have done the
general merit list to be filled in first. Then 2A backlog. Yes, backlog is second. Yes, Mister.
And in the Asian case, in place of petition, one Harshita has been selected. Her percentage now is 58.
No, therefore Harshita is top. Harshita has to be appointed. First Harshita case has to be considered.
Yes.
If you read this, her case has to be considered in backlog. If Harshita is posted to the backlog, then this will be that, this rural will be that vacant. Then second is the petitioner has to be filled. What you have done it, you have given this reservation second post to that Harshita. Then you have come to that backlog. Backlog is not entitled. Therefore, he has been denied.
Not only that, one more aspect is before releasing the final list also they have given appointments. Another thing
Appointment order has been given to her.
Even before the list is released, they have given appointment order.
Yes, Mister. What you say about this?
Take instruction will come back.
No, this is what that law is, that Mister. This is the this. Yes, what you say that? We'll stay your appointment order, Mister.
1 week time.
Not 1 week. We'll stay that. This is very clear how that government
Please, my
can do
lord.
it.
1 week time. Senior is
Unless,
engaged.
no, you are not. Government is that answerable. What is your instruction, Mister?
Next week, any rest. I will take instruction. I will come back.
We'll have it on 4th, please. Yes. Yes. Third. This is the only point. Yes. At the request of government advocate, read this matter on 3rd. Get an instruction how it has to be filled, situation like this, which is the law. He has given the judgment, it is clearly on the point. Unless this is there any subsequent judgment contrary to that, or it is overruled? This is the law as on today. According to that, he has in a case. Yes. This other lady. AR 2021 SC 1267. Letter note. I'll have to file it again.
Serial number 51. Subramanya R for petitioner. Vinayak S. Pandit.
Yes.
Pray for time.
Password.
I want to file reply in this matter.
Yes, at the request of government advocate, leave this matter after 2 weeks.
Serial number 52. Vishnu Hegde for petitioner. BL Sanjeev.
Here it is the case, my lord, the petitioners are working more than 10 years. In that particular, the second respondent is, third respondent is by the government. After this, they appointed as per the notification. Today they are working continuously. And we made the representation to regularize our services, but there is no order is passed. Hence we approach.
Where is that representation?
The annexed A.
Who has to consider?
The second, third respondent is. But we have made the representation to all the.
Karnataka Compounds Development Corporation Limited. Who is appearing for? Dear Sanjeev. Yes, will you consider in accordance with law? Yes.
That's my number 3 has to consider. Because he is a competent authority.
Is it a government undertaking corporation? Yes. Whom you have given a representation?
I given the representation all the 3 respondents.
The
annexed A Mandal page number 60.
Yes. This writ petition, petitioner sought following relief. Actually, A, B, C ಅಂತ ಏನು ಕೊಟ್ಟಿದ್ರು? ಎಲ್ಲ ಒಂದೇ. Yes. Case of the petitioner that ಯಾವಾಗ ಅಪಾಯಿಂಟ್ ಆಗಿದ್ದ?
The appointment, my lord, different dates, my lord. The first petitioner is appointed under 2013, during 2013, my lord.
ಬಾಕಿದಾರು?
ಬಾಕಿದು ವಾಪಸ್ 2016 and one is 17.
2016 ಆದ್ರೆ ಅವ್ರಿಗೆಲ್ರಿ 10 years ಆಯ್ತು.
But there is a decision approved by the this particular authority for regularization of that services. Already meeting was done.
Elli?
Board has passed the resolution.
Where is that?
I have stated that particular thing.
Have you producing? Have you produced?
I don't have that.
ಮತ್ತೆ ಅದಂಗೆ ಹೇಳ್ತೀರಾ? Yes.
So that it is not yet implemented by
the case of the petitioner that they are all working in second and third respondent corporation as a temporary employee from 2013. Since their service is not regularized, working as what, mister? All are working as what? Since their appointment was not regularized, they have submitted in a representation with annexure A, B and C. ಅಬ್ಸಾರ್ಪ್ಷನ್ ಕೇಳ್ತೀರಾ ರೆಗ್ಯುಲರೈಸೇಷನ್ ರೀ? ಏನ್ ಕೇಳ್ತಾ ಇದೀರಾ ನೀವು?
Regularization.
Hereby authorities to immediately regularize the service implementing the decision of the board meeting.
Board meeting was held.
ಎಲ್ಲಿದೆ ಅದು ಬೋರ್ಡ್ ಮೀಟಿಂಗ್?
ಅದನ್ನೇ para number 7 of the repetition also we mentioned.
Since their representation is not considered, the petitioner is before this court. Learned counsel appearing for the respondents submitted that if this court grants some reasonable time, representation submitted by the petitioner by the annexure A, B and C dated so and so will be considered in accordance with law.
Yes, ma'am.
In view of the above, without expressing any opinion on the merit of the case, the writ petition is disposed of, directing that respondent to consider that representation submitted by petitioner annexure A to C in accordance with law as expeditiously as possible, not later than 6 months from date of respect of.
Cell number 53, Vijay Kumar for petitioner. The Javaya.
Respondent number 4 matter. Draft reply is ready now. Send for approval.
Yes. At the request, none appear for the petitioner, leave this matter of 2 weeks.
Cell number 54 adjourned. Cell number 55 Kashinath JD for petitioner. Pradeep S. Saukar.
The
Yeah, for
request
the
of petitioner.
respondent. My lord, let my learned friend get instructions because now, my lord, the petitioner has applied for voluntary retirement and has been relieved also.
Is really, what is that he is challenging here?
Lord, he was an in-service candidate, applied for recruitment to the post of financial controller. On the ground that he is an in-service candidate. My lord, subsequently appointment was already made. And my lord, earlier round of, there were 2 other writ petitions that were filed. My lord, that got rejected on the ground that he is not eligible because of age criteria. Once again, fresh notification, he challenged it again in this writ petition. My lord, I filed objections to say he is not eligible because age is barred. Now, my lord, subsequently, he is applied for voluntary retirement and is retired also. He's been relieved also. Let my learned friend get his.
You want to, even
The only ground on which he's fighting is because he's an in-service candidate. Now, my lord, he's gotten a better job in elsewhere. Let my learned friend get.
Yes, you verify, Mr.
I have produced the relieving memo also. Only upon his voluntary retirement that too, not
yes,
any other purpose.
Yes. Yes, Mr. When do you want? Yes, at the request of counsel for the petitioner. Leave this matter on 11.
Very well.
Yes.
Cell number 56 Ranganatha S. Joyce for petitioner. Shailaja SV.
Yes.
56 Ranganatha S. Joyce.
Yes, none appear for petitioner. Leave this matter of 2 weeks.
57 Vaishali Agde for petitioner, government advocate.
Yes, Mr.
Petitioner, my lords. Lords, the petitioner has called into question, my lords, the order at annexure A at page 35, my lords, where the state government in exercise of its powers under review as my lords imposed a higher punishment than what was imposed earlier, my lords. The facts being, my lords, I'll just narrate the background facts, my lords.
Yes.
Lords, the petitioner, lords, was working as a special land acquisition officer in 2010. Lords, at that point of time, the petitioner had disbursed an amount of about 1.86 crore as compensation to a alleged landowner. Later, it came to be known, lords, he had done that based on the records put up by the officials.
Yes.
Lords, an inquiry was instituted because it came to be known that the amount was received by an imposter. Lords, and there were proceedings in a writ petition before this honorable court, directing an inquiry to be conducted. Based on that, my lords, an inquiry officer was appointed and an inquiry was conducted against the petitioner. Please come to annexure C, page 61, my lords.
Yes.
Lords, this is the report of the inquiry officer against the 61, my lords.
Yes.
It's dated 28th December 2013.
Yes.
Lords, after considering everything, your lordship kindly come to page 76, my lords.
Yes.
Para 24. It starts with the DO.
Yes.
Your lordship. The DO has produced the copies of the statements case by the by Chandrasekhar K, son of Kodanraman, and K Gopi, son of Kodanrama, recorded by CCB police during investigation of the complaint, and contended that they have not stated anything in the statement against the DO, but the statement so recorded in fact complained the lapse on the part of the subordinate officials, MS Ramchandrappa, who is the witness PW3 in this case. It is quite true that MS Ramchandrappa, against whom the allegations are made in these statements, may have committed some act of dereliction of or intentional dishonesty, which I cannot comment upon unless the said person has appeared before me as a delinquent, and without giving him any opportunity of meeting with the said allegations and being heard. Assuming there was some act of dishonesty or lapse on the part of the subordinate officials of the DO, which appears to be quite possible, that does not mean the DO can be exonerated of the lack of responsibility, though I do not have anything on record directly for establishing that the act of DO was intentionally dishonest. There is no allegation of moral turpitude against the DO in the articles of charge in this case on hand, but it is mainly of dereliction of duty. Therefore, even if it is presumed that it is unintentional, the lapse amounts to dereliction of duty, a misconduct, the act being unbecoming of a government servant.
Yes.
Then conclusion, the charge against DO is proved to the extent while DO was working as Special Land Acquisition Officer 2 in KIDB, paid a sum of 1 crore 86 lakhs by means of a check number so-and-so on 18/6/2010 to a person by name R. Kodandaraman, son of Ramaswamy, KR Puram, Bangalore, with K. Gopi, without confirming the identity of that person, R. Kodandaraman, ex-defense personnel, the respondent in the order of the Special Deputy Commissioner, Bangalore District, as being owner of the acquired land, and thus it amounted to dereliction of duty by acting in a manner unbecoming of a government servant, and thereby committed misconduct under Rule 3, 1, 2, and 3 of the Karnataka Civil Service Conduct Rules. But I hold that there is no evidence of intentional dishonest act done by the DO with an intention of causing loss to the government.
Yes.
This was accepted by me. Thereafter, please come to page 79.
Yes.
The government passed an order after considering the inquiry report, my lords. The order is on 29/3/2014. If your lordship kindly come, my lords, to page 81, my lords.
Yes.
Our last para in 81. Bottom para in 81, running page 81. It starts with Vicharane Adhikari avaru. Your lordships have that, my lords.
Yes.
ವಿಚಾರಣೆ ಅಧಿಕಾರಿಯವರು ನೀಡಿರುವ ಅಂತಿಮ ವಿಚಾರಣೆ ವರದಿಯನ್ನು ಹಾಗೂ ಆಪಾದಿತ ಅಧಿಕಾರಿಯವರು ನೀಡಿರುವ ಲಿಖಿತ ಹೇಳಿಕೆಯನ್ನು ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಿ ವಿಚಾರಣೆ ಅಧಿಕಾರಿಯವರ ವರದಿಯನ್ನು ಅಭಿಪ್ರಾಯದಂತೆ ಪ್ರಕರಣದಲ್ಲಿ ಆಪಾದಿತ ಅಧಿಕಾರಿಯಾದ ಶ್ರೀ ಆರ್ ನಾಗರಾಜ್ ಕೆಎಎಸ್ ಅಧಿಕಾರಿ ಇವರು ಎಸಗಿರುವ ಕರ್ತವ್ಯ ಉದ್ದೇಶಪೂರ್ವಕವಾಗಿ ಮಾಡಿದಂತ ಕರ್ತವ್ಯವಾಗಿರದೆ ನಿಜವಾದ ಭೂ ಮಾಲೀಕರನ್ನು ಗುರುತಿಸದೆ ಪಾವತಿಸಬೇಕಾಗಿರೋ ವಿಚಾರಿಸದೆ ಮಾಹಿತಿಯನ್ನು ಪಡೆಯದೆ ಭೂ ಮಾಲೀಕರೆಂದು ಹೇಳಿಕೊಂಡು ಬಂದಂತ ನಕಲಿ ವ್ಯಕ್ತಿ ಪರಿಹಾರ ವಿತರಿಸಿರುವ ಮೂಲಕ ಸದರಿ ಆಪಾದಿತ ಅಧಿಕಾರಿಯು ಕರ್ತವ್ಯ ವೆಚ್ಚ ಎಸಗಿರುವುದು ದೃಢಪಟ್ಟಿರುತ್ತದೆ. ಆದರೆ ಸದರಿ ಕರ್ತವ್ಯ ಲೋಪವು ಸರ್ಕಾರಕ್ಕೆ ಹಾನಿಯನ್ನು ಉಂಟು ಮಾಡುವ ದುರುದ್ದೇಶದಿಂದ ಕೂಡಿರುವುದಿಲ್ಲವೆಂಬ ನಿರ್ಣಯ ತಿಳಿಸಲಾಗಿದೆ. ಮುಂದುವರೆದು ವಿಚಾರಣಾಧಿಕಾರಿಯವರು ನೀಡಿರುವ ವರದಿಯ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಅಸಲಿ ವ್ಯಕ್ತಿಯು ಬದಲು ನಕಲಿ ವ್ಯಕ್ತಿಗೆ ಭೂ ಪರಿಹಾರ 1,86,00,000 ಚೆಕ್ ಅನ್ನು ಪಾವತಿ ಮಾಡುವ ಆಗಲು ಆಪಾದಿತ ಅಧಿಕಾರಿಯು ದಾರಿ ತಪ್ಪಿಸದಂತ ಕರ್ನಾಟಕ ಕೈಗಾರಿಕಾ ಪ್ರಾದೇಶಿಕ ಅಭಿವೃದ್ಧಿ ಮಂಡಳಿಯ ಸಂಬಂಧಿಸಿದ ಅಧಿಕಾರಿ ನೌಕರರ ವಿರುದ್ಧ ಶಿಸ್ತು ಕ್ರಮ ಕೈಗೊಳ್ಳುವುದು ಅವಶ್ಯವೆಂದು ಸರ್ಕಾರವು ಮನಗಂಡಿದೆ. Then, my lords, the order is at 29/3/2014. Please see one, my lords, at the bottom of page 82. The increment without cumulative effect punishment was ordered on me. Then please come to 83. Please see what it says. ಅಸಲಿ ವ್ಯಕ್ತಿಯು ಬದಲಾಗಿ ನಕಲಿ ವ್ಯಕ್ತಿಯು ಭೂ ಪರಿಹಾರದ ಮೊತ್ತ ಪಾವತಿಸಲು ಪೂರ್ವಕವಾಗಿ ಶ್ರೀ ಆರ್ ನಾಗರಾಜು ಕೆಎಎಸ್ ಅಧಿಕಾರಿ, ಇಂದಿನ ವಿಶೇಷ ಭೂ ಸ್ವಾಧೀನ ಅಧಿಕಾರಿ 2, ಕರ್ನಾಟಕ ಕೈಗಾರಿಕಾ ಪ್ರದೇಶಾಭಿವೃದ್ಧಿ ಮಂಡಳಿ KIDB ಬೆಂಗಳೂರು ಇವರನ್ನು ದಾರಿ ತಪ್ಪಿಸಿ ಸರ್ಕಾರಕ್ಕೆ ಆರ್ಥಿಕ ನಷ್ಟ ಉಂಟು ಮಾಡಲು ಕಾರಣದಂತಾದ ಕರ್ನಾಟಕ ಕೈಗಾರಿಕಾ ಪ್ರದೇಶಾಭಿವೃದ್ಧಿ ಮಂಡಳಿ ಸಂಬಂಧಿತ ಅಧಿಕಾರಿ ನೌಕರಿ ವಿರುದ್ಧ ನಿಯಮಗಳ ಅನ್ವಯ ವಾಣಿಜ್ಯ ಮತ್ತು ಕೈಗಾರಿಕಾ ಇಲಾಖೆಯು ಕರ್ನಾಟಕ ಕೈಗಾರಿಕೆ ಪ್ರದೇಶಾಭಿವೃದ್ಧಿ ಮಂಡಳಿಯ ಶಿಸ್ತು ಕ್ರಮ ಕೈಗೊಳ್ಳತಕ್ಕದ್ದು. I accepted this punishment. Thereafter I was transferred, my lords. I was working as the Under Secretary of the State Election Commission. Now, my lords, as the secretary. My lords, in 2016, what happened? Pursuant to orders in a writ petition, my lords, where the landowner had questioned, this honorable court had observed, action has to be taken. That your lordships should get at page 40, annexure B. It's an order dated 18th October 2012
Yes.
by the original landowner, my lords, who had complained.
No, this is in 2012.
Our court, because this court had directed, my lords, that the action has to be investigated, the inquiry was held.
No, that punishment has been imposed when?
In 2014, pursuant to the observations of this honorable court, my lords.
No, see, now that punishment you read,
Yes, 2014 adu.
2014,
ಹೌದು.
there, that you have no objection. You have.
I had no objection. ಅದು ಬಂದಿದ್ದು ಯಾಕೆ ಅಂದ್ರೆ ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ ಮಾಡ್ತು ಎನ್ಕ್ವೈರಿ ಹೋಲ್ಡ್ ಮಾಡಿ ಬಿಕಾಸ್ ಬೇರೆ ಯಾರಿಗೋ ಹೋಗಿದೆ ಅಂತ. Then, my lords, I accepted that there was a punishment was imposed. Then, my lords, strangely, what happened?
High Court direction.
My lords, please come to in that order, my lords. 18th October at page 40, your lordships would get.
Yes.
Annexure B anta.
Yes, yes.
Adralli, please come to the actual part, page 58. Page 58 ಅಲ್ಲಿ running para 21 ಅಲ್ಲಿ ಸಿಗುತ್ತೆ.
Yes, yes.
The action of NR Nagaraju, your lordships have.
Yes.
The then SLAO in the matter of decision taken and also the payment of compensation on so and so is prima facie suspect. Alleged actions of Nagaraju which require deeper consideration has not been examined since pursuant to the resolution of board in its 303rd meeting notice. Supra disciplinary action is stated to have been initiated, which is also clear from the statement of objections filed by the respondents. Disciplinary authority has to examine the allegations with expedition.
And after that only that.
ಇದೆಲ್ಲ ಮುಗಿಸಿದ್ರು. Lords, thereafter what happens, lords? No, that operative portion at page 59 also, Roman 5 is the same thing.
Yes.
Action, disciplinary action conclude ಮಾಡಿ ಅಂತ
ಆಯ್ತು,
ಅಷ್ಟೇ.
ಮಾಡೋದಾಯ್ತಲ್ಲ.
ಮಾಡಿ punishment ಕೊಟ್ರು. Lords, thereafter in 2016 at page 84, running page 84, my lords.
Yes.
After a period of 2 years,
Yes.
annexure E.
Yes.
At page 86, my lords, strangely the government passed another order on 21/4/2016,
Yes.
imposing my lords, a punishment in addition to what was imposed earlier to recover the entire amount of rupees 53 lakhs from me. ಅದು page 86, my lords.
Yes, read, read.
ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿದ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಶ್ರೀ ನಾಗರಾಜು ಕೆಎಸ್ ಕಿರಿಯ ಶ್ರೇಣಿ ಪ್ರಸ್ತುತ ಅಧೀನ ಕಾರ್ಯದರ್ಶಿ ರಾಜ್ಯ ಚುನಾವಣಾ ಆಯೋಗ ಬೆಂಗಳೂರು ಇವರು ಈ ಹಿಂದೆ ವಿಶೇಷ ಭೂ ಸ್ವಾಧೀನ ಅಧಿಕಾರಿ ಕರ್ನಾಟಕ ಕೈಗಾರಿಕಾ ಪ್ರದೇಶಾಭಿವೃದ್ಧಿ ಮಂಡಳಿ ಬೆಂಗಳೂರು ಈ ಹಾದಿಯಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸದ ಭೂ ಪರಿಹಾರ ಪಾವತಿಸುವಲ್ಲಿ ಸರ್ಕಾರಕ್ಕೆ ಉಂಟು ಮಾಡಿರುವ ನಷ್ಟದಲ್ಲಿ ಸದರಿಯವರಿಂದ ವಸೂಲು ಆಗಬೇಕಾಗಿರುವ ನಷ್ಟದ ಮೊತ್ತ 53,15,369 ರೂಪಾಯಿಗಳನ್ನು ವಸೂಲಾಗುವವರೆಗೆ ತಕ್ಷಣದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ಪ್ರತಿ ತಿಂಗಳು ಮಾಸಿಕ ವೇತನದಲ್ಲಿ 20,000 ರೂಪಾಯಿಗಳನ್ನು ಕಟಾಯಿಸಿ ಈ ಮೊತ್ತವನ್ನು ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಹಣಾಧಿಕಾರಿ ಹಾಗೂ ಕಾರ್ಯನಿರ್ವಹಣಾಧಿಕಾರಿ ಸದಸ್ಯರು ಕರ್ನಾಟಕ ಕೈಗಾರಿ ಅಭಿವೃದ್ಧಿ ಮಂಡಳಿ ಇವರ ಖಾತೆಗೆ ಜಮಾ ಮಾಡಲು ಆದೇಶಿಸಿದೆ. Now this order, lords, was questioned by the petitioner before the Karnataka Appellate Tribunal in the first instance, administrative tribunal, my lords. And by that time, they had recovered about 1 crore from the accused persons there, my lords.
Yes.
The imposters. When we went before the KAT, my lords, please come to 105 annexure H. Running page 105. Annexure H is an application which was decided on 20th March 2020. There, my lords, the administrative tribunal, the government appeared and filed detailed statement of objections. And if your lordship kindly come to page 112, I'm just showing the background, my lords.
Yes.
In 112, right in the middle, your lordships would get, my lords, as per the proposal of Commerce and Industries Department. As per the proposal of Commerce and Industries Department and oral directions of the Honorable High Court of Karnataka in WP 43/759 of 2011 and request of the Additional Advocate General 1 wide in its letter dated 18/4/2016, sum of rupees 2,000 deduction per month has been ordered up to recover of an amount of rupees 53,15,369. That was the loss caused by the applicant to the KIDB. So they say all that. Then, my lords, the administrative tribunal considered this aspect of the matter
Yes.
and held, my lords, they considered everything. Please come to para 13 at page 125.
Yes.
On perusal, your lordships have that, my lords.
Page 120.
125, running page 125, that's para 13 of the KAT order.
Yes.
On perusal of the entire annexure proceedings of the government of Karnataka dated 21/4/2016, it is crystal clear that the entire order has been passed on the basis of oral directions. Oral directions issued by the Honorable High Court of Karnataka in WP number 43759 of 2011 dated 22/2/2016, the two for recovery of loss causing to the government from the hands of the present applicant and another government official, namely MS Ramchandrappa. In other words, as per the oral directions and oral order of the High Court, both the government leaders addressed the letter to Chief Secretary and intimated the High Court order and request the Chief Secretary to recover the amount from the applicant. Then, my lords, the KAT observed ultimately at 127, page 127, my lords.
Yes.
It starts from 126, bottom 4 lines.
Yes.
Whether the oral directions, your lordships have that, my lords.
Yes.
126, bottom 4 lines.
Yes.
Whether the oral directions, oral orders issued by the Honorable High Court of Karnataka as stated in all the 3 letters addressed by the government leader to the government are contrary to law and against Articles 14, 16 and 21 of the Constitution. And the said order is passed without giving opportunity being heard, and the present applicant is not a party to the said writ petition to decide all these things. This court has no jurisdiction, as the remedy of the applicant is elsewhere if so advised. In other words, this court is not competent to debate such oral orders issued by the Honorable High Court. On perusal of the impugned order, entire order is passed based on oral directions of High Court and also on the 3 letters addressed by the learned government leaders and correspondence between the respondent and concerned department. Hence, remedy of the applicant is elsewhere, where if so advised, not before this court, in my opinion, application is not made.
Yes.
Then, my lords, I filed a writ petition before this honorable court. That was decided, my lords, by order dated 23rd at September 2022, page 131, by the division bench, my lords. Lordships have that 131.
Yes, yes.
In that, if your lordship kindly come, my lords. Para 10. At page 137. We have perused the same anta shuru.
Yes.
137 and para 9 alli they take the daily orders of that writ.
Yes.
Para 10, we have perused the same. On a reading of the same, it is seen that there is a reference to the petitioner and we do not see any direction by the court to initiate steps to recover the amounts from the petitioner. On the contrary, it would reflect a representation by the respondent state that efforts have been made to recover the amount. Be that as it may, admittedly, petitioner is not a party to the writ. We have also queried if there is any direction to initiate recovery proceedings against the petitioner, to which the learned High Court government leader would answer in the negative. Be that as it may, if any loss has occurred on account of any action that was not sanctioned by the state, then the petitioner is liable to be compensated the same. But the fact remains that the said process has to be commenced and concluded in a manner known to law. The state, being employer and the legislature, is required to act strictly in consonance with law and cannot resort to arbitrary and whimsical practices. The reliance on observations of single judge, in our opinion, appears to be an act which has to be frowned upon.
A single judge illa anta cost ಮಾಡಿ, if law permits you do it on.
ಮಾಡಿದ್ರು ಅಂದ್ರೆ procedurally law permits. ಇದನ್ನ ತಗೊಂಡು ಏನ್ ಮಾಡ್ತಾರೆ, annexure, lords, they issue a show cause notice to me at annexure L dated 3/6/2024 at page 141 by referring to rule 26 of the KCSR, my lords.
Yes. Yes.
Now, for which I give a reply saying that the High Court has not said you have to simply do it. If inquiry was held.
Now they have leave it of everything. Now they are invoking the 26.
26.
What the 26?
Let's please see rule 26 of Karnataka Civil Service CCA rules.
Yes, if they are not satisfied with that inquiry officer's report, they can, on the basis they can.
They could have done that, but they accepted the inquiry officer's report and imposed a punishment.
In my
Once
statement of objection, para number 11, it is.
There is that imposing that
punishment. That's the 2014 order which I pointed out to my lords. That's my lords, page 79.
Then they have no jurisdiction after that. That is what they have accepted that
They accepted and imposed the punishment
by the government. Yes.
Now 26, if your lordship kindly see, my lords.
Yes. Yes.
the power of review.
Yes. Yes.
The state government may at any time, either on its own motion or otherwise, after calling for records of the case, review any order passed under these rules when any new material or evidence which could not be produced or was not available at the time of passing the order under review and which has the effect of changing the nature of the case has come or has been brought to its notice, or if in its opinion an order imposing any penalty cannot be given effect to, or if an order imposing penalty is not legally valid, and confirm, modify or set aside the order. Now, my lords, this entire material was with the government. There is nothing new which has come about.
Now, that is what they have to be answered now.
That's the precise thing. Now, in the review, please see the order. They now put the entire blame on the division bench judgment.
Calling up records of the case, review any order passed under this rule when there are new materials evidence which would not be produced or was not available at the time of passing an order. Review. Yes.
And my lords, the original penalty order is dated 26/10/2014.
Yes.
I'm sorry, 29/3/2014. So it's 11 years.
But 26, no limitation.
No limit.
Let's our case is, even if there is no limitation, it should be within a reasonable period of time. Now, after 11 years, now in any statute, my lords, your lordship.
You have any judgment on that?
On 26, no. Per se, not on 26
Not 26,
limitation.
no. See, in any, so many.
Now, land reforms.
No. Under that service law, even central acts and so many acts, similar provision is there.
Yes.
After imposing, then government has kept that power to
Review it. And whether
that can be done it after this.
my lords, that, my lords, we search for directly either under the CCS or under KCSR, there is no such judgment.
Yes.
But the issue is, my lords, if the act is silent about the period within which you can take up the review proceedings, you can't take it up after 11 years.
No, but there is proceedings in between that.
That, my lords, 2016 they took it up.
Yes.
By pointing out that the High Court had orally directed imposition of recovery proceedings.
Yes.
Now, my lords, once you imposed a punishment of cutting the increment, and you also directed recovery proceedings against the other officials of KIDB who were responsible. I accepted the punishment. I underwent the punishment. Once I undergo the punishment, can you again impose one more punishment on me for the same without any inquiry?
No, 26 has given a power after imposing the penalty. Delay aspect is different.
Delay
but
is different.
26 is available
Now,
for them.
That, my lords, whether the question is this, please see how it works.
26, whether it's by that higher authority or the same.
State government.
State government. Now that penalty imposed by the two.
State government only.
Now,
It
is
was-
it available? Review. They can be
Review is
available.
available.
Review is available. My lords, I'm not saying review.
Government may at any time, either on its own motion or otherwise call for the records review by an order passed under this rule. The review.
The earlier order also.
They have to be, one is delay, second is that what is that new material?
New material.
and the
There
evidence.
should be a new material. Now, my lords, please see the order.
New material to show that petitioner was involved.
And they did not know about this.
But it has not been placed earlier. Why it is not placed earlier? All this explanation. has
Now,
to
my
be-
lords, that is why the inquiry report assumes importance. The inquiry report which I read to my lords, please come to the inquiry report at page 61.
Yes.
My charge against me, your lordship should get at page 62.
Now, what are the reason given on that impugn order? Let us see.
Yes, my lords. Now, please come to the inquiry report runs witnesses and other things.
Annexure.
My lords, annexure C at running page 61. That's the inquiry report.
No. That impugn order now.
Now, my lords, annexure A.
Yes.
ಅದು 2.5 ಪೇಜ್ ಇದೆ, ಓದೇ ಬಿಡ್ಬೋದು ನಾನು ಬೇಕು.
Yes. What are the reason given for
My lords,
the penalty?
they extract, my lords, they give the background facts.
Yes.
Then, my lords, at para 6 at page 36, they
Then
refer
again
to
the KIT, para 9 is that Prakarana Sambandhapatta Kanun.
8 High Court order, division bench order, ಅದೇ which I read to my lords.
Yes.
Then, my lords, 9.
You read
ಮೇಲೆ
from-
ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 10. ಪ್ರಕರಣದ ಸಂಬಂಧ ಕಾನೂನು ಇಲಾಖೆಯ ಅಭಿಪ್ರಾಯ ಕೋರಲಾಗಿ ಕಾನೂನು ಇಲಾಖೆಯು ಈ ಕೆಳಗಂತೆ ಅಭಿಪ್ರಾಯ ವ್ಯಕ್ತಪಡಿಸಿರುತ್ತದೆ. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ತನ್ನ ದಿನಾಂಕ 28/9/22 ಆದೇಶದಲ್ಲಿ ಸ್ಪಷ್ಟವಾಗಿ ಸರ್ಕಾರವು ನಿಯಮದಲ್ಲಿ ತಿಳಿಸಿದ ವಿಧಾನವನ್ನು ಅನುಸರಿಸಿ ನಷ್ಟವನ್ನು ವಸೂಲಿ ಮಾಡಬೇಕಾಗಿರುತ್ತದೆ. ಮನಬಂದಂತೆ ಅನಿಯಂತ್ರಿತವಾಗಿ ವಸೂಲಿ ಮಾಡಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ ಎಂದು ತಿಳಿಸಿರುತ್ತದೆ. ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವಾ ವರ್ಗೀಕರಣ ನಿಯಂತ್ರಣ ಮೇಲ್ಮನವಿ ನಿಯಮಾವಳಿ 1957 ನಿಯಮ 8ರಲ್ಲಿ ನಿರ್ದಿಷ್ಟಪಡಿಸಿದ್ದ ದಂಡನೆಯನ್ನು ಮಾತ್ರ ವಿಧಿಸಲು ಅವಕಾಶವಿರುತ್ತದೆ. ನಿಯಮ 8(6) ನಿರ್ಲಕ್ಷ್ಯದಿಂದ ಅಥವಾ ಆದೇಶಗಳ ಉಲ್ಲಂಘನೆಯಿಂದ ರಾಜ್ಯ ಸರ್ಕಾರ ಅಥವಾ ಕೇಂದ್ರ ಸರ್ಕಾರ ಅಥವಾ ಇತರ ರಾಜ್ಯ ಸರ್ಕಾರಕ್ಕೆ ಅಥವಾ ನಿಕಾಯಕ್ಕೆ ಅವುಗಳಿಗೆ ಉಂಟಾದ ಆರ್ಥಿಕ ನಷ್ಟವನ್ನು ಪೂರ್ಣವಾಗಿ ಅಥವಾ ಭಾಗಶಃ ವೇತನವನ್ನು ವಸೂಲಿ ಮಾಡಲು ಅವಕಾಶವನ್ನು ಕಲ್ಪಿಸಲಾಗಿದೆ ಮತ್ತು ಆರ್ಥಿಕ ನಷ್ಟ ಉಂಟಾಗಿ ಸಂದರ್ಭದಲ್ಲಿ ಆರ್ಥಿಕ ನಷ್ಟ ಉಂಟಾದ ದಿನಾಂಕದಿಂದ ಅದರ ಮೇಲೆ 8% ವಾರ್ಷಿಕ ಬಡ್ಡಿಯನ್ನು ವಿಧಿಸಲು ಅವಕಾಶ ಕಲ್ಪಿಸಲಾಗಿರುತ್ತದೆ. ನಿಯಮ 8ರಲ್ಲಿ ಸಮಾಜ ಹಾಗೂ ಸಾಕಷ್ಟು ಕಾರಣಗಳಿಗೆ ಮತ್ತು ಇನ್ನು ಮುಂದೆ ಉಪಬಂಧಿಸಿದಂತೆ ಸರ್ಕಾರಿ ನೌಕರರ ಮೇಲೆ ಈ ಕೆಳಗೆ ನಮೂದಿಸಿದ ಒಂದು ಅಥವಾ ಹೆಚ್ಚು ದಂಡವನ್ನು ವಿಧಿಸಬಹುದು ಎಂದು ತಿಳಿಸಿರುವುದರಿಂದ ನಿಯಮ 8ರಲ್ಲಿ ತಿಳಿಸಿದ ದಂಡನೆಯಲ್ಲಿ ನಿಯಮಾನುಸಾರ ಒಂದಕ್ಕಿಂತ ಹೆಚ್ಚು ದಂಡನೆಗಳನ್ನು ವಿಧಿಸಿ ವಸೂಲಾತಿ ಮಾಡಬಹುದಾಗಿರುತ್ತದೆ ಎಂಬುದು ಕಾನೂನು ಇಲಾಖೆಯ ಅಭಿಪ್ರಾಯವಾಗಿರುತ್ತದೆ. ಅಂದ್ರೆ ಪನಿಷ್ಮೆಂಟ್ 2 ಕೊಡಬಹುದು ಅಂತ ಹೇಳ್ತಾರೆ. ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 11 ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೋನ್ಸೋ ನಿಯಮಗಳ 1957 ನಿಯಮ 26ರಲ್ಲಿ ರಾಜ್ಯ ಸರ್ಕಾರವು ಹೊರಡಿಸಿದ್ದ ಯಾವುದೇ ಆದೇಶವನ್ನು ಯಾವುದೇ ಕಾಲದಲ್ಲಿ ತಾನಾಗಿಯೇ ಅಥವಾ ಅನ್ಯತಾ ಪುನರಾವಲೋಕನ ಮಾಡಬಹುದಾಗಿದೆ. ಕಾನೂನು ಅದು ಮಾಡಬಹುದು ಅಂತಾರೆ. ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 12ರಲ್ಲಿ ಅಧಿಕಾರಿಯನ್ನು ನಿಯಮ 26 ಜಾರಿಗೊಳಿಸಲಾದ ನೋಟಿಸಿಗೆ ಸಲ್ಲಿಸಿರುವ ಹೇಳಿಕೆಯಲ್ಲಿ ನಿಯಮ 26 ಅಡಿ ನೋಟಿಸು ಜಾರಿಗೊಳಿಸಲು ಪ್ರಕರಣದಲ್ಲಿ ಹೊಸ ದಾಖಲೆ ಸಾಕ್ಷಿಗಳು ಕಂಡು ಬಂದಲ್ಲಿ ಹಾಗೂ ಪ್ರಕರಣದಲ್ಲಿ ವಿಧಿಸಿದ ದಂಡವನ್ನು ಜಾರಿಗೊಳಿಸಲು ಸಾಧ್ಯವಿಲ್ಲದಿದ್ದಲ್ಲಿ ಮಾತ್ರ ಸದರಿ ನಿಯಮದಲ್ಲಿ ನೋಟಿಸು ಜಾರಿಗೊಳಿಸಲು ಅವಕಾಶವಿರುತ್ತದೆ. ಆದರೆ ತಮ್ಮ ವಿರುದ್ಧ ಪ್ರಕರಣದಲ್ಲಿ ಈ ರೀತಿ ಯಾವುದೇ ಅಂಶಗಳು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ. ಪ್ರಸ್ತುತ ಪ್ರಕರಣದಲ್ಲಿ ಅವರ ವಿರುದ್ಧ ಯಾವುದೇ ಹೊಸ ಸಾಕ್ಷಿಗಳು ಲಭ್ಯವಾಗಿರುವುದಿಲ್ಲ. ಅವರ ದಂಡನೆಯ ವಿಧಿಸಿರುವ ಆದೇಶ ಅನ್ವಯ ಈಗಾಗಲೇ ಕ್ರಮವಹಿಸಲಾಗಿರುವುದರಿಂದ ಮತ್ತೊಮ್ಮೆ ಸಿಸಿಎ ನಿಯಮಗಳು 1957 ನಿಯಮ 26
ರಿಪ್ಲೈ ಹೇಳ್ಬಿಟ್ಟಿದಾರ.
ನಮ್ ರಿಪ್ಲೈ ಅದೇ ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಜಜ್ಮೆಂಟ್ ಒಂದು ಕೋರ್ಟ್ ಮಾಡಿರೋದು. ಸೆಕೆಂಡ್ ಪೆನಾಲ್ಟಿ ಅಧಿಕಾರಿಯವರ ಲಿಖಿತ ಹೇಳಿಕೆಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟ್ ಸಂಖ್ಯೆ 43-759 of 2011 connected with 60-99 of 2024 ಮತ್ತು 78-68 of 2021 ಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ನ್ಯಾಯಾಲಯದ ನಿರ್ದೇಶನಗಳನ್ನು ಮತ್ತು ಕಾನೂನು ಇಲಾಖೆಯ ನೀಡಿರುವ ಅಭಿಪ್ರಾಯದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಪ್ರಕರಣವನ್ನು ಮರುಪರಿಶೀಲಿಸಿ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರಿಯವರು ಅನುಮೋದನೆಯೊಂದಿಗೆ ಅಧಿಕಾರಿಯವರಿಗೆ ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವೆ ಸೋನ್ಸೋ ನಿಯಮ 26 ಅನ್ವಯ ದಿನಾಂಕ 3/6/20 ಕಾರಣ ಕೇಳುವ ನೋಟಿಸ್ ಅನ್ನು ನೀಡಲಾಗಿದೆ. ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವೆ ಸೋನ್ಸೋ ನಿಯಮಗಳು 1957 ಅನ್ವಯ ಇಲಾಖೆ ವಿಚಾರಣೆಗೆ ಒಳಪಡಿಸಿ ಸದರಿ ನಿಯಮಾವಳಿ ನಿಯಮ 8(3) ಅಡಿ ಪ್ರದ್ಯತ್ತವಾದ ಅಧಿಕಾರಿಯನ್ನು ಚಲಾಯಿಸಿ ಸದರಿ ಅಧಿಕಾರಿಯನ್ನು ಕರ್ತವ್ಯ ಚೌತಿಗೆ 1 ವರ್ಷದ ಅವಧಿ ಸಂಚಿತ ಪರಿಣಾಮ ಬೀರದಂತೆ ತಡೆ ಹಿಡಿಯ ದಂಡನೆಯನ್ನು ದಿನಾಂಕ 29/3/2014 ವಿಧಿಸಲಾಗಿತ್ತು. ಅಧಿಕಾರಿಯವರು ವಿಶೇಷ ಭೂಸ್ವಾಧೀನ ಅಧಿಕಾರಿ ಕರ್ನಾಟಕ ಕೈಗಾರಿಕಾ ಪ್ರದೇಶಾಭಿವೃದ್ಧಿ ಮಂಡಳಿ ಇಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದಾಗ ಭೂ ಪರಿಹಾರದ ಮೊತ್ತದ ಚೆಕ್ ಅನಧಿಕೃತ ವ್ಯಕ್ತಿಗೆ ನೀಡಿರುವುದರಿಂದ ಸರ್ಕಾರಕ್ಕೆ 1,86,00,000 ತೀವ್ರ ಆರ್ಥಿಕ ನಷ್ಟ ಉಂಟಾಗಿರುತ್ತದೆ. ಈ ಮೊತ್ತದಲ್ಲಿ ಅಧಿಕಾರಿಯವರಿಂದ 53-15-369 ವಸೂಲು ಮಾಡುವಂತೆ ವಾಣಿಜ್ಯ ಮತ್ತು ಕೈಗಾರಿಕೆ ಇಲಾಖೆಯ ತಿಳಿಸಿರುತ್ತದೆ. ಸದರಿ ಮೊತ್ತಕ್ಕೆ ದಿನಾಂಕ 18/6/2010 8% ಬಡ್ಡಿ ದರದಂತೆ ಒಟ್ಟು ಮೊತ್ತ ರೂಪಾಯಿ 1,14,96,558 ಹಣವನ್ನು ವಸೂಲು ಮಾಡಬೇಕಾಗಿರುತ್ತದೆ. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ರಿಟ್ ಅರ್ಜಿ ಸಂಖ್ಯೆ ಅದನ್ನೇ ಹೇಳ್ಕೊಂಡು ಹೋಗ್ತೀರ ಅಷ್ಟೇ. ನ್ಯೂ ಮೆಟೀರಿಯಲ್ ಏನ್ ಬಂದಿದೆ ಏನು ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ ಫಾರ್ ಎವ್ರಿಥಿಂಗ್ ಇಸ್
on 2014 in 2014 my lord, the facts was this my lord, there is a incur of about 1,86,00,000 rupees was a loss my lord, which can be recovered from the alleged.
They said, inquiry officer said, it is not due to that negligence of the petitioner, loss is not by that other officer.
Yes.
Maybe he negligent. You have accepted. Now, what is that materials to show that petitioner has utilized that amount to
Yes, ma'am.
given a, subsequent punishment?
Yes, ma'am. In 2014.
All this says that petitioner was involved, this amount is misappropriated, it has given to some other person, has been discussed earlier, then penalty has been imposed. Now, what is that additional material to show
ma'am,
that?
I will come. In 2014, my lord, the loss was about 1.86 crores, my lord. For that, it is not a recovery of about the loss which is been incurred, which is only a penalty for the negligence what he has conducted, which was imposed in 2014. Thereafter, when KAT, in KAT, there is a special provision in the KADB where while dispersing the amount, we will enter into an indemnity bond. We will recover from the persons who have been wrongly received the compensation in name of in the alleging that they are the owners. Recovery has to be done. The recovery was probable in 2014. Recovery cannot be probable in 2022 by as the time of disposal of the division bench before this honorable court. When that recovery was only 1 crore 4 lakh rupees as order, which was admitted by the state governments in the KAT before in one of the proceedings by the petitioner itself. So the remaining amount has to be recovered from the officer itself, because he was negligent. So 26 was invoked. It is an additional.
There is that you have not stated anything.
Not stated, but it is.
Then how can that?
It is a
imagine,
fact,
Mister? How can I imagine and he can imagine that? See, what you have stated should be there in that notice, and he has to be explained. That is not there.
That is the facts.
To excise that 26, there should be an additional materials to prove that. And that has to be brought to his notice, and he have to be culminated in that order. Nothing is there. Now you can add other thing. After that, now you are adding that. Now you have lost that interest.
No, 26. Yeah, under 26, we will invoke. We have the powers to invoke only that portion of recovery what we were unable to recover from.
Now you have a power to invoke under certain circumstances.
Yes, ma'am. So that is the certain circumstances.
Where is that order? Doesn't speak that.
That they have filed, but in the written statement of objection we have filed.
No, it should be in that order.
Order should reflect that.
What is that? It should be in that order. See, you have to give in a notice. He will explain that whether who has misappropriated that amount. See, throughout all this said, he has been misled.
It is not misappropriation as such, my lord. In 2014, my lord, for his negligence, he was imposed with some of the penalties. Thereafter,
that has
closed. Now, after that landowner, original landowner,
that amount has to be recovered from that person who has committed the mistake.
Yes.
Now, that has been earlier held. He has not committed. He has been misled by so and so. You recover them. He says that that amount is recovered from that person.
No, it is not completely recovered. It is only 1 crore 4 lakh rupees is been recovered from the person who has received
whatever you want to give a notice and explanation asking me that whether these are all that amount, this has been recovered, this is the remaining amount, this is your responsible, then you will answer, then you can invoke that.
Well, that is the contention of in the writ petitions what the landowner have taken place.
No, in the order doesn't speak. In order is only earlier. No. You have to be examined that impugn order. Why do you want to keep it?
That is not there.
Yes.
But in the statement of objection, we have stated powers under 26, my lord, and also
if you have any additional materials under 22-6, you will be permitted to invoke and pass an order after giving in a notice to him.
Yes, my lord.
That can raise all that objection. Even limitation is also will kept open.
Yes, my lord. And
you do it. Yes.
This is the contention of
this entire thing has come about. I am the senior most KS officer in the state. I should have been promoted as IAS years ago. Only because I am super time scale, I am stuck because of this one order. My file is stuck. That's why, my lords, this court also had taken it out.
If you want to do it, we'll say that with it, because now inquiry is not necessary. Only notice and reply.
Yes.
We'll fix in a limited time. If you want to do it. Otherwise, leave it that.
Yes, ma'am.
Yes.
But the subsequent growth was like this, from 2014 till this, the recovery is only 1 crore 4 lakh rupees.
No,
Not-
1 crore 4 lakhs from the imposter. They never recovered from Ramchandrappa.
One thing, that you are not able to recover from somebody else, he cannot be punished unless he is involved.
Yeah, my lord, involvement when it is not a coded survey number, it is involvement
There is
itself. my lord.
two things.
Yes.
I have seen that. Enquiry officer. Who is that enquiry officer is also material. I don't think anything will be missed out from
That
that
is
enquiry
why I
officer.
point out, if it was somebody else,
Somebody else, it is different. The enquiry officer who has
My lord,
conducted.
that I will not speak, my lord. I will argue only in
Also
favor of the
materials.
government in
Yes.
in this respect. That amount which, the loss which has been incurred by the state, that has to be recovered. From
Yes.
whom, that we have to discuss.
In this writ petition, petitioner called in question order dated 28 to 2025 passed by state government by annexure A by invoking.
just seek leave.
Yes, yes.
Started matter is
Yes, you
taken up.
can. Yes. By invoking.
That's the only thing, if they are given liberty, that should not come in the way of my file being held up. Because our liberty quota and DPR, the kutkonide file.
We'll say if they want, do it within 3 months.
3 months.
Yes.
And my argument with respect to that may be.
No, where is that your written, we'll say that
that
what is
much-
not there in that order, it will be coming now under that statement.
Argument and statement of objections.
Yes, under invoking. Yes, yes. Under rule 26 of KCSR CCA rules and impose that penalty. The short facts for consideration of this writ petition that the petitioner was working as a special land acquisition officer 2 in KADB. The petitioner had disbursed a sum of rupees 1 crore 86 lakhs by means of check on 18/6/2010 to one person by name Sri Kodanda Rama, son of Ramaswamy, towards the compensation for acquisition of the land measuring an extent of 3 acres in survey number 6P12 of Singahalli village, Jala Hobli, Bangalore North Taluk. On the basis of that allegation, next, a writ petition bearing WP number 43759 of 2025 was filed before this court by a person claiming to be the real Sri or Kodanda Rama and seeking a direction to KDB and the state government to pay that compensation amount towards the land acquired by KDB. Matter was considered by this honorable court. In said writ petition number 43759 of 2011 was allowed in part under the order dated 18/10/2012. The honorable court specifically observed that disciplinary authority which is seized of the matter shall deal with that matter strictly on merit and in accordance with law. On the basis of the allegations of dispersion of sum of rupees 1 crore 86,000 to one Sri R. Kodanda Raman, the departmental inquiry has been initiated against the petitioner. The government has appointed Sri Kukchi Ramakrishna Bhatt, retired district and session judge as an inquiry officer, to hold an inquiry against the petitioner regarding the misconduct alleged against the petitioner as per government order dated 22/8/2013. The inquiry report dated 28/12/2013 was submitted as per annexure. Where is that report?
Annexure C, my lord, page 61.
As per annexure C,
Page 61.
page 61.
Operating portion, page 24 and at page 76.
Concluded that charge against the petitioner was proved to the extent of dereliction of duty and committing a misconduct. The inquiry officer categorically held that there was no evidence of intentional dishonesty act done by a petitioner, and that too with an intention of causing loss to the state government. Next paragraph. State government has passed an order on 29/3/2014 wide annexure.
Page 83, my lord, operating portion, annexure D, my lord.
Yes, annexure D, imposing upon the petitioner a penalty of withholding one annual increment without cumulative effect. The state government also directed the Department of Commerce and Industry and KADB to take necessary action against the staff and the servants of KADB who are responsible for misleading the petitioner herein to disperse the compensation amount to imposed instead of real person, and which resulted in causing loss to the state government. The penalty imposed by the state government via annexure D was accepted by the petitioner. When things stood that the respondent has unilaterally and without even issuing any show cause notice to the petitioner has passed an order on 21/4/2016 wide annexure E, unilaterally directed the recovery of sum of rupees 53,15,360 from monthly salary of the petitioner at a rate of 20,000 per month towards that alleged loss caused to the government because of disbursement of compensation amount by the petitioner when the petitioner was working as a special land acquisition officer in Karnataka Industrial Area Development Board. Said order has been passed based on the oral direction said to have been issued by the Honorable High Court of Karnataka in WP number 43759 of 2021 and the letter addressed by additional government advocate.
Which was
Said order was been challenged.
Page number 105, my lord. At annexure H, 105.
105. Before that, Karnataka Administrative Tribunal in application number 6108 of 2016, the tribunal by order dated 20th March 2020 has dismissed that application. The operative portions of the order page 13, para 13 extract. 13, yes. Para 13. Being agreed by Order passed by Karnataka Administrative Tribunal. Petitioner herein has filed a writ petition before this court in WP number 7868 of 2021. This court, by order dated 28 September 2022, has allowed that writ petition and made it clear that that order will not come in the way of the respondent to initiate any action strictly in accordance with law. The operative portions of the order 12 and 13 extract. Thereafter, government, by invoking power under Rule 26 of KCSR CCA Rules 1957, the impugn order has been passed. Next paragraph. The state can invoke that power by reviewing the order passed under this rule only when new materials are evidenced which could not produced or was not available at the time of passing that order under the review, and which has the effect of changing the nature of case has come or has been brought it is noticed. They can confirm, modify or set aside that order. Learned counsel appearing for the petitioner has submitted that the government has exercised that power under Rule 26 after lapse of 11 years. On the ground of delay itself, that impugn order has to set aside. Secondly, he has contended that entire order is reiterating what has happened in the earlier proceedings. There is no new materials has been produced. Government advocate appearing for the state has submitted that, has filed a statement of objection, which is the paragraph.
My lord, that is 4 we have relied, my lord. Thereafter, powers under section 26.
Para? Which is that?
Para number 11. 4 is the facts, my lord, what we have recovered.
Already, what is the ground? Which is that paragraph we want to say?
11, my lord, revision petition delay. In respect of delay, my lord, there is on 22 itself the direct this
delay. Why you said that amount which is not recorded, it is there. Therefore, what is that point you have urged?
That is on at above para number in page number 4, my lord. It is in mid. It's an extract from the response.
ಯಾವ para ರೀ?
5 my lord. Page number 2.
Yes, the fact said that improvement as follows. Instrument check towards also has placed the reliance on
it's lengthy, my lord.
That contention in paragraph 5 same has been extracted below. I have verified that, perused that impugn order annexure A. Entire order speaks about that earlier proceedings. Nowhere that order says What are the new materials or evidence which was not available earlier has been placed now before the authority for reviewing that order? What is stated in that statement of objection is also not forthcoming in the impugn order. The state government can invoke that power under Rule 26 only if the new materials or evidence which was not available at the time of passing that penalty order has been placed. No such finding in the impugn order annexure A. On that ground itself, the impugn order annexure A has to be quashed. Accordingly, the impugn order annexure A is quashed, reserving liberty to the petitioner to initiate any action, liberty the petitioner to reconsider that matter afresh, reserving liberty to the petitioner. If the petitioner wants to invoke
Section 26, Rule 26.
under Rule 26,
Fresh notice.
they have to exercise that power in compliance of that provision, strictly in compliance of that Rule 26, after giving proper notice to the petitioner.
Reasonable opportunity as per 26D, my lord.
After giving proper opportunity to the petitioner. Within, they have, if they want to invoke that power under Rule 26, they have to be invoked within 3 months from date of receipt of copy of this order. The respondent is, all the contentions of the parties are left open, including the limitation. Point
My lord, with respect to limitation, my lord, in 2014 we passed.
No, it is left open. You decide. Let them.
My lord, that my submission may be recorded, my lord. Thereafter it can be.
No, you when you are invoking that, if you see and given a reason, I am not giving it.
This honorable court
All
is asked.
contention has been left open, including that.
My lord, the limitation, one submission of mine may be recorded, my lord, with respect to
No,
2014.
I am not giving any. If you want to give finding, I will give it finding. I am left open.
With my finding, my submission.
If you have recorded, I have to give a reasoning. I will give that reasoning that. Yes,
As-
if I give
as
a
I-
reasoning, then I have to either say order is correct or not.
My lord, my as submitted, it may be left open.
No, if you are submitted, then I have to give a reasoning. Therefore, I said that.
Yes.
Yes. Otherwise, I have to decide that whether that
It
limitation.
is a continuation proceedings from 2014.
Therefore, I will kept open all the, yes, is kept open, including that ground of limitation. Yes.
Cell number 58 adjourned, cell number 59, Shrikant MP for
My lord, I have
petitioner.
got a request, my lord. My lord, I am sorry, my lord. I have got a request regarding serial number 56, my lord. I was held up in court on 5. I just want a date, my lord. Lordship urgent.
Yes. 2 weeks. 25th.
Date.
Yes. Yes, 25th. Yes.
Cell number
Obliged.
59, Shrikant MP for petitioner,
My lords,
government advocate.
matter pertains to my lords appointment on compassionate grounds. Now, my lord, it is said that only by outsourcing they have to, my lords, fill up. In fact, my lords, in the case of the petitioner, death was prior to the rules, my lords, her request was prior to the rules. In fact, her appointment is also, my lords, in pursuance of the, my lord, the directions of the department. But when it came to, my lords, releasing grantine, they invoked, my lord, the subsequent amendment.
No, you have been appointed.
My lords appointed, my lords, if lords kindly see, my lords, I made a request for my lords, the appointment, my lords, on compassionate grounds in the parent institution. As my lords, the posts were not available.
Appointment.
My lords, my husband, my lord, was working in one institution by name, my lords, Maruti Vidya Mandira at Kamakshi Palya.
Admitted to grant.
That was admitted to grant. My lords, he passed away, my lords, on 18/2/2017.
18 to
2017. Wife made a request on 1/4/2017.
yes.
My lords, the institution, my lords, gave no objection at Annexure E, my lords, on 30/10/17, saying that, my lords, they don't have a D group vacancy available, that she can be considered in some other institution. My lords, is the no objection. Then, my lords, BO.
ಶಿಕ್ಷಣಾಧಿಕಾರಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದು ಸೇವಾವಧಿಯಲ್ಲಿರುವಾಗಲೇ ನಿಧನ ಹೊಂದಿದ್ದು ಸತಿ ಪತ್ನಿ ಇವರಿಗೆ ಅನುಕಂಪದ ನೇಮಕಾತಿ ಮಾಡಬೇಕೆಂದು ಮನವಿ ಸಲ್ಲಿಸಿದ್ದು, ಸಂಸ್ಥೆಯ ಡಿ ದರ್ಜೆ ಹುದ್ದೆ ಇಲ್ಲ ಕಾರಣ ಯಾವುದಾದ್ರು ಅನುದಾನಿತ ಶಾಲೆ ಹುದ್ದೆಗೆ ನೇಮಕಾತಿ ಮಾಡಿದಲ್ಲಿ ನಮ್ಮ ಸಂಸ್ಥೆ ವತಿಯಿಂದ ಯಾವುದೇ ಆಕ್ಷೇಪ ಇರೋದಿಲ್ಲ ಅಂತ ಯಾರಿಗೆ ಕೊಡ್ತಾರೆ ಇದನ್ನ?
ಅಲ್ಲಿ ಬೇರೆ ಎಲ್ಲ ನಾ ಮಾಡ್ಬೋದು ಅಂತ ಹೇಳಿ ಕೊಡ್ತಾರೆ. My lord, I'm appointed, my lords, in Rajinagar Boys and Girls High School, a private institution. Annexure H, my lords, dated 11/12/2018. I was appointed and my name is recommended for, my lords, admission to granting it. My lords, in 2019, Annexure J, endorsement is issued, my lords, by the director, relying on, my lord, the amended rules, which came into force on 26/9/2017. That is subsequent to the death. Lords, our contention is, my lords, first, that we are not, my lords, the rules cannot be made applicable. The difficulty what I am facing is, my lord, the other private management has accommodated me, thinking that, my lords, I'll be admitted to granting it. Now the rule mandates that it should be by outsourcing. Now they'll not be in a position to, my lords, in the institution, because
that you are appointed.
Please.
By the management, my lord, that is not.
No,
granting it.
how you can be appointed in the compassionate appointment also?
My lords, that is in pursuance of, my lord, the if lords kindly come to, my lords,
The employee is dead.
yeah,
If
my
the
lord, the
vacancy is there or not, how that
my lord,
appointment
in
has
the
to be
other
made?
institution there is vacancy. Department only sent me. That's the reason Annexure F may be seen, page, my lord, page number 32. My lord, it was recommended. Then Annexure G.
ಓದಿ ಏನಿದೆ?
Annexure G ಓದ್ಬಿಡ್ತೀನಿ ತಾವು, that will be very clear. By the other institution. Page number 33, my lords. ಮೇಲ್ಕಂಡ ವಿಷಯ ಹಾಗೂ ಉಲ್ಲೇಖಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ದಿನಾಂಕ 20/11/2018 ತಾವು ಪತ್ರದ ಮುಖೇನ ಶ್ರೀಮತಿ ಸೋನ್ಸೋ ಎಂಬ ಬೋಧಕೇತರ ಸಿಬ್ಬಂದಿ ನಮ್ಮ ಶಾಲೆಗೆ ಅನುದಾನ ರಹಿತವಾಗಿ ಅನುಮೋದಿಸಿದ ಆದೇಶವನ್ನು ರವಾನಿಸಿರುವುದು ಸರಿಯಷ್ಟೇ. ಆದರೆ ನಮ್ಮ ಶಾಲೆಯು ಕೇವಲ ಸರ್ಕಾರ ನಿಗದಿಪಡಿಸಿದ ದಾಖಲಾತಿ ಶುಲ್ಕವನ್ನು ಮಾತ್ರ ಪಡೆಯುತ್ತಿರುವುದರಿಂದ ಶಾಲಾ ಆಡಳಿತ ಮಂಡಳಿಯು ಸದರಿಯನ್ನು ಅನುದಾನ ರಹಿತವಾಗಿ ಕೆಲಸಕ್ಕೆ ತೆಗೆದುಕೊಂಡು ಮಾಸಿಕ ವೇತನ ನೀಡುವ ಶಾಲಾ ಸ್ಥಿರ ನಿಧಿ ಕೊರತೆಯಿಂದ ತಾವು ದಯವಿಟ್ಟು ಸದರಿ ನೌಕರಿಗೆ ಅನುದಾನ ಸಹಿತವಾಗಿ ಅನುಮೋದನೆ ಮಾಡಿಕೊಡಬೇಕೆಂದು ವಿನಂತಿಸುತ್ತೇವೆ ಅಂತ ಬರೀತಾರೆ. The appointment is approved without aid by the, my lords, the block education officer.
How you have been appointed?
Lord, compassionate appointment.
How compassionate appointment can be made without the approval of that authority?
Authority ne ಕೊಟ್ಟಿರೋದು deputy director.
Where is that?
My lord, that is what, my lord, 2018.
No, that is not that. Read, that is not that. Management has given that.
ಅಲ್ಲಲ್ಲ, ತಾವು ಅವ್ರು ಮಾಡೋದು ಇವ್ರ ಲೆಟರ್ಗೆ ರೆಫರ್ ಮಾಡೋದವರು.
ಆಯ್ತು, ಎಲ್ಲಿದೆ
ಆಮೇಲೆ ತಾವು ನೆಕ್ಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್
ವಿಷಯಕ್ಕೆ ಉಲ್ಲೇಖ ಸಂಬಂಧಿಸಿದಂತೆ ದಿನಾಂಕ
ತಾವು ನೆಕ್ಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ Annexure H ತಾವು ನೋಡಿದ್ರೆ, where my appointment is, my lords, recommended for approval with aid.
No, I am asking that,
please,
not sending a recommendation. How you have to be appointed on compassionate ground?
Lords, in the
you have to be taken approval from that authority, then appoint, and you can be appointed and then send it to that approval.
Lord, that is what is done. ಅದಕ್ಕೆ ತಾವು Annexure H ಅಲ್ಲಿ ಸೀಕ್ವೆನ್ಸ್ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ.
I am asking that what is the law on that point? What done by that management is not the law.
Not the management. I am not on the management. Deputy director and BO, what they have done.
What they have done?
Annexure H ತಾವು ಬಂದ್ರೆ, if lords kindly have a look at.
Yes. Read.
ಮಾರುತಿ ವಿದ್ಯಾಮಂದಿರ ಕಾಮಾಕ್ಷಿಪಾಳ್ಯ ಬೆಂಗಳೂರು ಉತ್ತರಲ್ಲೇ ಒಂದು ಈ ಶಾಲೆಯ ಶಿಕ್ಷಕರಿಗೆ ಸೇವೆ ಸಲ್ಲಿಸಿದ ಸೋನ್ಸೋ ಅವರು ದಿನಾಂಕ 18/2/2017 ಸೇವೆಯಲ್ಲಿದ್ದಾಗ ಮರಣ ಹೊಂದಿರುತ್ತಾರೆ. ಶಾಲೆಯಲ್ಲಿ ಡಿ ದರ್ಜೆ ಹುದ್ದೆ ಖಾಲಿ ಇರುವುದಿಲ್ಲ. ಆದ್ರಿಂದ ಅವರ ಪತ್ನಿಯಾದ ಶ್ರೀಮತಿ ಛಾಯಾ ಅವರಿಗೆ ಅನುಕಂಪದ ಆಧಾರದ ಮೇಲೆ ಸೋನ್ಸೋ ಬೆಂಗಳೂರು ಈ ಆಡಳಿತ ಮಂಡಳಿ ನಡೆತಿರುವ ರಾಜನಗರ ಬಾಲಕ ಬಾಲಕಿಯರ ಪ್ರೌಢಶಾಲೆ 5ನೇ ಬ್ಲಾಕ್ ರಾಜನಗರ ಬೆಂಗಳೂರು ಈ ಶಾಲೆಯಲ್ಲಿ ಖಾಲಿ ಇರುವ ಡಿ ದರ್ಜೆ ಹುದ್ದೆಗೆ ನೇಮಕ ಮಾಡಿಕೊಳ್ಳಲು ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಸೋನ್ಸೋ ಈ ಆಡಳಿತ ಮಂಡಳಿಯಿಂದ ನಡೆಯುತ್ತಿರುವ ರಾಜನಗರ ಬಾಲಕ ಬಾಲಕಿಯರ ಪ್ರೌಢಶಾಲೆ 5ನೇ ಬ್ಲಾಕ್ ರಾಜನಗರ ಬೆಂಗಳೂರು ಈ ಶಾಲೆಯ ಸರ್ಕಾರದ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಪ್ರಕಾರ 77-78ನೇ ಸಾಲಿನಿಂದ ಪ್ರಾರಂಭವಾಗಿ ಈವರೆಗೆ ಯಾವುದೇ ವಿಚ್ಛಿನ್ನತೆ ಇಲ್ಲದೆ ನಿರಂತರವಾಗಿ ನಡೆಯುತ್ತಾ ಬಂದಿರುತ್ತದೆ. ಈ ಶಾಲೆಯನ್ನು ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ದಿನಾಂಕ 1/4/78ರಂತೆ 77-78ನೇ ಸಾಲಿನಿಂದ ಸಹಾಯಧನಕ್ಕೆ ಒಳಪಡಿಸಲಾಗಿರುತ್ತದೆ. ಶ್ರೀಮತಿ ಛಾಯಾ ಅವರನ್ನು ಅನುಕಂಪದ ಆಧಾರದ ಮೇಲೆ ಡಿ ದರ್ಜೆ ಹುದ್ದೆಗೆ ಅನುಮೋದಿಸಲು ಕ್ಷೇತ್ರ ಶಿಕ್ಷಣಾಧಿಕಾರಿಗಳು ಉತ್ತರವಿಲ್ಲ ಒಂದರ ಮೂಲಕ ಸಲ್ಲಿಸುವ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ರಚಿಸಲಾದ ಜಿಲ್ಲಾ ತ್ರಿಸದಸ್ಯ ಪರಿಶೀಲನಾ ಸಮಿತಿ ತೆಗೆದುಕೊಂಡ ನಿರ್ಣಯದಂತೆ ಈ ಕಚೇರಿ ಸಂಖ್ಯೆ ಉಲ್ಲೇಖ 5ರ ಜ್ಞಾಪನ ಸದರಿ ದಿನ ರಹಿತವಾಗಿ ಅನುಮೋದಿಸಲಾಗಿದೆ. ಈ ಹುದ್ದೆಯ ವಿವರ ಕೆಳಕಂಡಂತಿದೆ. They have given the table. ಶ್ರೀಮತಿ ಛಾಯಾ ಸೋನ್ಸೋ ಡಿ ದರ್ಜೆ 10ನೇ ತರಗತಿ ಅನುತ್ತೀರ್ಣ ಸೋನ್ಸೋ ರಾಜನಗರ ಬಾಲಕ ಬಾಲಕಿಯರ ಪ್ರೌಢಶಾಲೆ 5ನೇ ಬ್ಲಾಕ್ ರಾಜನಗರ ಬೆಂಗಳೂರು ಈ ಶಾಲೆಯ ದಾಖಲಾತಿ ಹಾಜರಾತಿ ಕೆಳಕಂಡಂತಿರುತ್ತದೆ. ಸೋನ್ಸೋ ಮೇಲ್ಕಂಡ ಅಂಶಗಳನ್ನು ತಮ್ಮಲ್ಲಿ ಗಮನಿಸಿ KSTV ಸಂಘ ಸೋನ್ಸೋ ಈ ಆಡಳಿತ ಮಂಡಳಿಯಿಂದ ವತಿಯಿಂದ ನಡೆಸುತ್ತಿರುವ ರಾಜನಗರ ಬಾಲಕ ಬಾಲಕಿಯರ ಪ್ರೌಢಶಾಲೆ 5ನೇ ಬ್ಲಾಕ್ ರಾಜನಗರ ಬೆಂಗಳೂರು ಅನುಕಂಪದ ಆಧಾರದ ಮೇಲೆ ನೇಮಕ ಮಾಡಿಕೊಂಡಿರುವ ಶ್ರೀಮತಿ ಛಾಯಾ ಡಿ ದರ್ಜೆ ಸಹಾಯಕರ ಹುದ್ದೆಯನ್ನು ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸಬೇಕೆಂಬ ಅಭಿಪ್ರಾಯದೊಂದಿಗೆ ಪೂರ್ಣ ಪ್ರಸ್ತಾವನೆ ಪತ್ರದಿಂದ ಅನುಮೋದಿಸಿ ತಮ್ಮಲ್ಲಿಗೆ ಸಲ್ಲಿಸಿದೆ. Annexure J is passed. They say there is a 3-man committee's report recommending my lord's admission to grant. But when it went to my lord's the director, he passes annexure J, my lord's page number 36. Relying on my lord's the 2017 rules. My lord's may have a look at my lord, the last paragraph. Reading starts with my lord Sadari at 36. Sadari ಪ್ರಸ್ತಾವನೆ ಪರಿಶೀಲಿಸಲಾಗಿ ಪ್ರಸ್ತುತ ಸರ್ಕಾರಿ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ದಿನಾಂಕ 26/8/17 ವೇತನಕ್ಕೆ ಒಳಪಡಿಸುವ ಸಂಬಂಧ ಅನುದಾನಿತ ಶಾಲೆಗಳಿಗೆ ಹೊರಗುತ್ತಿಗೆ ಆಧಾರದ ಮೇಲೆ ನೇಮಕಾತಿಗೆ ಅವಕಾಶ ನೀಡಿದೆ. Note auxiliary non-teaching services in aided high school, including services such as watch and ward, classroom arrangement, daily keep-up of premises, support in science labs, movement of teaching learning material may be obtained on outsourced basis. The government may provide suitable grants in aid for such outsourced services ಎಂಬುದಾಗಿದೆ. ಆದ್ದರಿಂದ ನಿಯಮದ ಪಾಲನೆ ಕುರಿತು ಸರ್ಕಾರದ ಸ್ಪಷ್ಟೀಕರಣ ಕೋರಲಾಗಿದೆ. ಸರ್ಕಾರದ ಸ್ಪಷ್ಟೀಕರಣ ಬಂದ ನಂತರ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಲು ತಿಳಿಸಿ ಮೂಲ ಸೇವಾ ವಹಿ ಮತ್ತು ಪೂರ್ಣ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಯಥಾವತ್ತಾಗಿ ಪತ್ರದೊಂದಿಗೆ ಅನುಮೋದಿಸಿ ಹಿಂದಿರುಗಿಸಿದೆ. They return the proposal. Rules, my lords, at annexure K 38, my lords, at 39, my lords, is note 2 is what is, my lords, hurting me. It says, my lords, auxiliary non-teaching services in an aided high school, including services such as watch and ward, classroom arrangement, daily upkeep of school premises, support in science labs, movement of teaching learning materials may be obtained on outsourced basis. The government may provide suitable grant in aid for such outsourced services. But the rules came into force, my lords, in September 2017. But that was prior to that. My application was prior to that.
Yes, madam.
My lord, the annexures, my lord, annexure J and H, or my lord, those are internal communications, my lord. However, my lord, annexure K is, my lord, there's a notification which is also under challenge.
No, internal communication, what that have been happened there, you have not denied that.
Yes, my lord.
His appointment has been made on compassionate appointment, Anudana Rahita. Now they wants to.
As per annexure K, my lord, there is a restriction, my lord, with regard.
No, restriction is that prospective. Can you say that it is applicable to that? What is your instruction on that?
My lord, the department people, my lord, have sought time for 1 week, my lord, to clarify, because, my lord, in the annexure K, my lord.
No, somewhere I have, there is a clarification order issued by the government.
My lord, only thing is, my lord, annexure K, my lord, 2017 notification, that has to be clarified whether this is prospective or retrospective. My lord.
No, see, if that vacancies which is arises, which was already admitted to the granting aid, I think that will be continued. In future, there cannot be any.
That is, my lords, in collegiate education rules. My lord, there is a proviso to the effect that, my lords, on non-teaching post will become permanently unaided subsequent to occurring of vacancy. But, my lords, insofar as ಇದ್ರಲ್ಲಿ ಆತರ ಇಲ್ಲ, ಔಟ್ಸೋರ್ಸಿಂಗ್ ಇಂದ ಮಾಡಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ.
Yes, automatically it will go.
ಅಂದ್ರೆ ವರ್ಚುವಲಿ ಇಲ್ಲ, ಔಟ್ಸೋರ್ಸಿಂಗ್ ಮಾಡಿ ಅದಕ್ಕೆ ಏನ್ ಬೇಕೋ ನಾವು ಗ್ರಾಂಟ್ಸ್ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಬಟ್ ಐ ವಿಲ್ ನಾಟ್ ಬಿ an employee.
I think there is a government clarification, even in case of compassionate appointment also.
ಅಲ್ಲ, ತಾವು ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಬಂದಾಗ ಇದೇ ತರದ್ದು ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಇಂಡಿಕೇಟೆಡ್ that
ಯಾರೋ ಒಬ್ರು ಪ್ರೊಡ್ಯೂಸ್
ಮೇಡಮ್ ಅವರು
This was the notification which was.
No, this notification has been clarified, saying that in case that it is already, admitted to the grantee aid. A person who is dead before this rule is coming to the force, their LRs can be accommodated without that provisions of the
Have
rule.
it checked.
You verify that,
Yes,
whether it is applicable to that also. The vacancies which is arises before that rule notification is coming, that too in compassionate appointment. Yes, when do you want? Last occasion also, that government advocate, everybody is
The other matter is coming up on 5th. You lots may have it notes on
yes,
that. date.
5th, you get that instruction. Yes, leave
Please.
this matter on 5th.
Cell number 60, Veerabhadraya M for petitioner.
For the petition.
Connected
Last
matter,
occasion on
Jaipur
12/1, your lordship directed the respondent to say which act is applicable. They, according to the 4th respondent, education is not applicable. So they have to satisfy.
It is Education Act itself which is applicable. Under that itself, we have sought the permission from the authorities, my lord. I have the lordship may kindly turn to page 203, my lord, may I request,
They just give that brief facts. What is this matter?
Lord, there were two institutions, my lord. One is an unaided autonomous institution. And other one is self-financed institution, which is affiliated to VTU, my lord. One institute is is governed by the AICTE and also VTU. Lord, under the new education policy, my lord, there was less intake in the child institute. I would say, my lord, the second institute is the child institute, my lord. The original institute is the parent institute. So an application was filed before the VTU and AICTE, my lord, to merge and the progressive closure of the child institute after merging with the parent institute, for which, my lord, permissions were granted in the year 2022, both by the AICTE and also by the VTU, and also the government.
Yes.
Under law, my lord, under section 98, my lord, I have to seek permission from the competent authority, that is the VTU, Government of Karnataka, and also the AICTE.
Under 92 of?
98 of the Karnataka Education Act.
This is a technical education institution.
Technical, it's a technical
Your
education.
lordship,
University.
12/6, your lordship directed.
Now you see that definition here of this thing. It is not applicable to that technical education institution.
No, this since
It
it
is
is a
Applicability
self-financed.
is of the act, you see section 2.
Yes.
2H.
Lord, we have sought permission from all the,
Whether it's applicable or not, they will give everything. Whether it's applicable or not has to be seen.
may I read that, my lord, education.
Yes, section
Section
1.
2, subclause 14, my lord, means any institution imparting education referred to in section 3 and includes the private educational institute, but does not include an institution under the direct management of the university or the central government or a tutorial institution. My lord, we are not under direct control, my lord, the unaided
See,
institution.
apply all the education institution, tutorial institution in all state except institution of the scientific and technical education financed by the central government. Higher education shall be deemed to be a university of central government. Institution established, maintained, administered by that affiliated or to recognized by the University of Agriculture Science. So and so. Education institution affiliated or recognized by the Council of India school certificate or central so and so. Insofar as the matter pertain to the college and the institutions are dealt with. Indian Medical Council Act, Dental Act, Pharmacy Act, Universities Act, All India Council for Technical Education Act, even All India Technical Education Act matter, insofar as the matter pertain to the college and institutions are dealt with. All India Council of Technical Education Act. See, you see that whether this subject has been covered under that AICTE Act. If it is covered, then you cannot, invoke this act. That is what that section.
Lord, even otherwise, my lord, AICTE has also granted me permission, my lord, saying that I can merge the institution with the parent institution, child institution with the parent institution. Thereafterwards, my lord, if I have to retrench them, my lord, I have followed section 99 of the Karnataka Education Act by paying them 15 days salary, my lord.
For a moment,
No,
kindly
I am,
peruse the
Mr. Council, we
division
are
and
examining
judgment.
that question of law, you have to be assessed whether it is applicable or not. What they have done, it is not taken over the act, Mr. What is that? See, what is that meaning? So far as the matter pertain to the college and institutions are dealt within All India Council of Technical Education. Your
Yes.
institution is dealt within that, then this act is not applicable. That's what that says. You have any judgment on that point?
I will, in that
But
event.
last occasion we said that.
No, there is no judgment, my lord. I will.
Or a judgment,
Technical
Mr.
education
Cannot
is
be. How
concerned, my lord, there is one judgment of division bench.
Division bench, my lord, which says that I have to follow section 98. That is what he had relied upon, my lord, on the last occasion. That is why I said, my lord, I mean, I submitted before my lords that saying that, my lord, section 98 itself is applicable.
Here is that. This is that which institution?
That is
Dental
Raja
college.
Raja
Dental college, my lord. It is a minority institution, my lord. It's a minority institution.
Kindly peruse para number 7, 6 from start, it starts from para number 6, my lord.
Yes.
The text of the section 98(1) of the 1983 Act employs the terms in employee. The word employee is defined under section 2(1), 2 subpart 15 means the person employed in an education institution. It obviously included in its sweep and every employer regardless of the designation and the nature of functions or kind of education institution, except those excluded under section 214, subclass 14, which define education institution. This becomes the text subsection 2 of the section 92, which implies the terms teaching staff and aided education institution. These terms are conspicuously absent in subsection 1. This is where the maxim expresso initius esto exclusive alters become invocable. In Maxwell, on the interpretation of statute at page number 293, it written as under. So it is extracted. If the legislature intend to exclude unaided education institution, it would have in so many words, it is said it as it has done in subclass 2, sections 98. The next contains learned counsel for the appellant that the provisions of 1983 Act do not apply to the education institution run by the linguistic minority, also does not merit acceptance. The term education institution defined under section 214 of the Act to mean any education institution imparting education referred to section 3 and includes the private education institution but does not include an institution or the direct management of university or the central government or the tutorial institution apart it is a meaning and includes the definition. It also excludes the definition of what exclude is specifically stated that a minority institutions as defined under section 2 subclass 21 is not enlisted in the excluded category. The above apart, it is relevant to reproduce section 97 extracted manner. The legislature in its wisdom has taken special care to protect the tenure of the employees of the private education institution by restricting the power of the management to cut short the same casually. Section 97 prescribes the modality of resignation, subsection 3, which began with negative terminology is apparently mandatory. It ensures the volunteer of the employee in the matter of resignation. Section 92 secure the tenure by restricting the management power to remove or retrench the employees. The underlying philosophy of these provisions is that an employee whose tenure is secured will be in a better position to discharge his duties efficiently, and that is necessary in public interest. It hardly need to be emphasized that education and education institutions play a pivotal role in the nation nation building. Therefore, a legislature rightly feels that needs a protected tenure of the service and its condition of these employees. In this sense, these provisions aim at socially security as well like the labor law do not for the workman. The next submission of the letter senior advocate appeared for the appellant institution that the apex court in TMA 5 supra as differentiated unaided minority education institution from the education institution, and therefore the provisions of section 92(1) of Act 1983 cannot be invoked. Again, it is a bit difficult to countenance. The reason for this is obvious. 1993 Act is a plenary legislature which enjoys very strong presumptions of the validity in the light of the RK Dalmia so and so. In the absence of successful challenge under striking down the provisions of the section 98 of the Act, their invocability cannot be hibernated and ground that arguable that they are represent to the observation of the apex court in some decision. Admittedly, the case of the appellant as sought said to be made out its a statement of objection filed in the retreat petition did not whisper about the arguable unconstitutionality of the section 98(1) of the 1983 Act. The above contention runner senior advocate appearing for the appellant institution is liable to reject for the yet another reason. Delhi High Court in Katuria Public School versus Director of Education has struck down the section 80, 8 subclass 2 of the Delhi School Education Act 1973, the parameter of section 98. The said provision is in a parameter with the provisions of section 98(1) of the Act. The ground for voiding the same was that a said provision is represented to the observation in TMI 5 Supra. However, the apex court in Rajkumar case, Director of Education overruled the said view, observed and as under. So, para 49, subsection 2 of the 8 of the Act ordained that subject to any rules that may be made in this behalf, no employee of the recognized private school shall be dismissed, removed, or reduced in rank, or shall his service be or otherwise terminated except with the prior approval of the Director of Education. 50. The judgment of the Delhi High Court thus error in striking down the section 8 subclass 2 of the DSA Act, the Katuria Public School, by placing reliance on the decision of this court in TMA Pi as the subject matter in the controversy therein was not the scrutiny of the tenure of the employee of the school. Rather, the question was the right education institution to the functions unfettered, while the functioning of both aided and unaided education must be free from unnecessary governmental influence. The same need to be reconciled with the conditions of the employment of the employee of this institution and provisions of the adequate precautions to safeguard their interests. Section 8 subclass 2 of the DSE Act is one such precautionary safeguard which need to be followed to ensure the employee of the education institution do not suffer unfair treatment at the hands of the management. The loss contention in this case
is only on the ground that minority education institution.
Illa, general discuss madida. Even Rajkumar case, I'll place the original judgment itself. It is not restricted to only minority case. Minority.
Give that Rajkumar case.
Stop. Because very recognitions granted under 36 of the Education Act. Now they cannot take a different stand. Education Act is not applicable. Thereafter, the subsequent approval was also given under section 36.
Yes. What is that section 36?
36 recognition.
It is given under this education.
Yes.
Yes. Now that they are not raising any objection on that.
No. What they are saying, we have passed the order. Yeah, your lordship 12.6, kindly peruse your lordship order 12.6.
Now what is that you are challenging?
I am challenging by
now we will
keeping our service outside the
main petition. Main petition. Now that
without passing any order.
Yes, we'll fix. You are appearing for whom, Mr.
Let's I appear for the AACT.
We have given a permission, my lords.
Education Act is applicable according to you.
It's applicable, my lords, but we have given a permission.
Yes,
The
yes.
Let's, may I submit,
Yes, madam.
Millards, I appear for the AACT. Millards, Education Act is not applicable, Millards, in case of mergers. Millards, the AACT Act, Millards, they specifically provides. Millards, the AACT, Millards.
No, what are the authorities you are placing? Is there any authority? And
Millards, each year, Millards will publish a approval process handbook, wherein Millards we prescribe a procedure as to how a merger has to happen. Millards, they cannot take a recourse under Education Act, Millards.
That only question, limited question, my lord. Without any order under the scheme of the act, whether the manager keep the employees, permanent employees outside the service without paying the. There's only question your lordship has this.
No, that you have given a recognition to that institution.
Millards, we have given an NOC, Millards. for the mergers.
You have given permission.
That
No,
has
yeah,
been
the
challenged.
recognition has been given by the state government.
Please, my lords,
But the one
they have challenged the
VTU
NOC.
is the one, my lord, which has recognized.
They
I
have
am
given the
affiliated-
approval, not recognition. They have given the
affiliated to
approval.
VTU, my lord. I am affiliated
I
to
have-
VTU.
What is that? Yes, what you want to argue, place that
Please, my
reliance on the judgment.
ಇಲ್ಲ
and,
ಒಂದು
argument.
ತಮಗೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಐ ಎ ಹಾಕಿದ್ದು ಡೈರೆಕ್ಟ್ them to pay the salary
Yes,
from June.
Lord,
For
salary,
that
my
it
lord,
was
for the
listed.
reason, my lord.
Meantime, the fourth assessment I said that the Education Act applicable. Your lordship directed them to say on that point.
Yes.
Now your lordship has to decide my application.
That IA.
Kindly peruse.
I have filed my objections also, my lord, saying that, my lord, 11/6/2025 itself, they have been issued with that retrenchment notice, payment of compensation, amounts were credited to their accounts. Your lordships passed an order on 12/6/2025, where, my lord, your lordships had very clearly stated that if there is no retrenchment as of that date, my lord, they should not be retrenched.
No, till that
According
date,
to-
have you paid?
According, on 11/6, till 11/6, I have paid, my lord, I have placed all those documents on record,
Then
my lord.
we'll consider that application.
Main
itself.
application has to be, I mean, this has to be considered along with the main application.
No,
But
my
they
lord.
cannot be directed.
Wait. IA,
Millard, even
sir, IA, mister.
IA 2 or 2025, Millard.
Is this matter in orders for consideration of IA 2 of 2025? Yes, we'll consider that. If they make out a case, otherwise we'll dismiss that. We cannot pending on that. Yes. On 16th.
16th.
Yes. Post this matter in
Or
orders.
11/6 notice na or order ಅಂತ ಹೇಳ್ತಾರೆ. No order is passed even till this day.
Yes, let
No
us
order.
say, yes, on 16th. Yes. We'll consider that. Yes.
Seal number 61. Krishna.
My lords, appearing for the petitioner, my lords. Respondent have not filed the objections, my lords.
My lord, I appear for the respondent, my lord. My lord, we are yet to receive complete papers in this matter, my lord, from the bank. Earlier, Mr. T.P. Mutanna had filed wakalat, my lord, but it was
Yes.
entrusted to us, my lord.
Yes, at the request of counsel for the respondent, 2 weeks time is granted to file
Please.
objection.
Serial number 62, Arjun. Serial number 63, Shrikant A for petitioner.
One submission, my
Government
lords,
advocate.
in suffer 62. Adjournment was taken, my lords, in my absence. They informed me later. Lordship may indicate a date, my lord, 2 weeks ಅಂತಿದೆ.
Yes, 2 weeks, 18th. Yes.
63, Shrikant A for petitioner, government advocate.
Yes.
Sorry. This matter is
Regarding the jurisdiction to.
Yes, that judgment is covered, mister.
My lord, may I pass on this
We'll permit you
judgment?
to go there. Yes.
Judgment, it's a reported judgment. by-
ಅಲ್ಲ ಅದೇ ನೀವು ಮನೆ ಕೊಟ್ಟಿರೋದೇ ಇಟ್ಸ್
ಅಲ್ಲ, ಇದು no. This clearly mentions regarding the recruitment.
Yes.
Another, this also
Para
reported,
19.
it's also reported.
Yes, reported.
The time spent here may be excluded in this.
Yes. In this petition, the government advocate outside has raised the objection regarding maintainability on the ground that matter in respect of that civil post, petitioner has to approach Karnataka Administrative Tribunal in view of the judgment of apex court so and so. The above writ petition is disposed of, reserving liberty to the petitioner to approach KAT in accordance with law. If petitioners filed an application before the KAT within 4 weeks, the KAT is directed to consider that matter on merit without going on the limitation aspect.
Great.
Any certificate copies?
Please, certificate copy. No,
Yes,
Pending application.
all pending applications are disposed of.
Serial number 64, Maulya Purna R for petitioner, connected
Appearing
matter.
for the petition.
Attorney Srinath.
Yes.
My lord, matter pertaining to where the petitioners, my lord, are the ITI, ITC graduates.
Yes.
My lord, they're seeking for mandamus, their prayer A, my lord, is for filling up of the backlog vacancy to the cadre of assistant linemen. So far as prayer B and C, my lord, they've sought for quashing of the recruit RNP regulations, my lord, wherein the qualification prescribed for the post of junior lineman and junior station attendant, and also the 2022 regulations, my lord.
Yes.
Lord, what has happened, the history of the case, Lord, so far as the cadre of assistant lineman is concerned,
Yes.
ITI and ITC graduates, Lord, were given weightage.
Yes.
50% we would recruit through ITI graduates,
Yes.
30% ITC graduates, and 20%, Lord, was promotional avenue from the cadre of junior linemen.
Yes.
This, Lord, was sought to be amended in the year 2012.
Yes.
Which few of the ITI and ITC graduates had challenged, and this honorable court allowed the writ petition. It went up in appeal, my lord, and a memo was filed by KPTCL. So far as direction number 1 to 4 therein were affirmed.
Yes.
Now, my lord, so far as cadre of assistant linemen is concerned,
Yes.
the fact that weightage is given to ITI and ITC graduates is not disputed.
Yes.
But now they're also seeking for the similar benefit in the cadre of junior linemen, junior station attendant.
No, earlier for which post?
Assistant lineman.
Assistant lineman.
Assistant.
What is the judgment of this court?
Lord, if I may pass on a memo of citation.
What is earlier judgment of this court on when they are challenging that?
My lord, in that.
They have not challenged that, my lord, but similar matter, my lord.
Yes.
I may refer the first petition.
Yes.
It's a recent decision of the Kalburgi bench. All of that history is referred, my lord.
Yes.
Page, para 11 onwards it starts at page.
These are all which posts they are seeking?
My lord, here that question the recruitment of the 2024, which is also sought to be challenged by way of interim prayer here.
Yes.
Which was called for the post of junior powerman and junior station attendant, my lord.
Yes.
There, para 5 at page 17, my lord.
Yes.
These are the facts therein. Before that, para 3, my lord, what I just mentioned,
yes,
with regard to assistant lineman cadre.
Yes.
For the post of assistant lineman by direct recruitment, following method of recruitment was provided.
Yes.
That is 50% of sanction post by direct recruitment of ITI qualified candidates. 30% was through ITC, my lord. 20% is promotional avenue from the cadre of junior linemen.
Yes. Yes.
Thereafter, my lord, para 5, with regard to the earlier writ petition filed.
Yes.
If I may read out, my lord.
Yes.
Petitioners who had completed their apprenticeship had no opportunity of appointment, as there was no regulation providing any scope of appointment to the post of assistant lineman. Petitioners had approached this court by filing writ petition in writ petition number so and so connected with other matters. This court allowed the said writ petition declaring ITC certificate holder from the respondent institute would be eligible to apply for the post of assistant lineman as per the notification dated 12/12/2011, and consequently directed the respondents to issue corrigendum inviting application from both male and female candidates possessing ITC and ITI post to the post of assistant lineman within 2 weeks from the date of corrigendum. As against the said order, KPTCL preferred writ appeal in writ appeal number so and so, in which a memo dated 8/11/2013 came to be filed, undertaking to consider the case of the petitioner. Recording the statement made in the said memo dated 8/11/2013, the division bench disposed of the said writ appeals, setting aside the direction number 5 to 7 issued in the order passed in writ petition number 1249 of 2012 and connected matter. However, confirmed the direction number 2 to 4. It also directed to provide age relaxation from 12/11/2011 to the petitioners as and when employment notification was issued for filling up of post of assistant lineman. I'll pause here, my lord. This is only for the post of assistant lineman. The weightage which was given was affirmed, and that has been followed even now.
Yes.
In the light of memo filed by the respondent corporation, and further directed the corporation to refund the amount collected towards filling up of the post as per notification dated 12/12/2011.
Yes.
Thereafter, my lord, para 7. No. In spite of the direction issued by this court, respondent KPTCL has not considered the claim of candidates having completed apprenticeship based on 10th standard with 3 years of training, but have also failed to consider the claim of petitioners who have completed apprenticeship of 1 year program after ITI and have processed to change the nomenclature of the post from assistant lineman to junior lineman and junior station attendant, prescribing the minimum qualification for the post of junior station attendant as 10 standard wired notification dated 31/12/2014. But even here I'll pause. This 31/12/2014 is what is challenged by way of prayer B in the present writ petition.
Yes.
So even in this batch of writ petition, what was argued is that though assistant lineman post weightage was given, KPTCL came up with recruitment wherein they've tried to change the nomenclature. They've
Yes.
called for junior lineman and junior station attendant.
Yes.
So considering this, my lord, so this arguments canvassed or what is contended by the petitioner
Yes.
was also urged in these batch of writ petitions.
What is the finding?
Please, my lord, I'll take your lordships through that. Para 13 onwards, my lord, the respondent contentions is considered. Then finding, my lord, is at para 18. And
Yes.
page 33, my lord. Para 18.
Yes.
That petitioners not having participated in the recruitment process in filling any applications are not entitled to question the same. As regards the reliance placed on the order passed in writ petition number 1249 of 2012 and order passed in writ appeal number 3074 of 2012, which is relied upon by the petitioner. Then again contentions are considered.
Yes.
Para 19, my lord, heard peruse the records.
Yes.
Para 20, my lord, the recruitment notification dated 14/10/2024
Yes.
issued by respondent KPTCL calling for the post of junior station attendant and junior powerman.
Yes.
The qualification prescribed for the said posts are as under. Now for junior station attendant and junior powerman, 10 standard is the qualification.
Yes.
The petitioners, my lord, who are ITI or ITC graduates, in case they've completed 10 standard, even they are very much eligible to participate. But they want a separate class so that only ITI, ITC graduates are to be considered. This benefits
They are seeking for which post?
for this post as well, junior station attendant and junior powerman post.
Junior station.
Attendant and junior powerman, my lord.
Now that junior lineman
Please.
and the junior station attender.
Please.
Junior station attender earlier called was what?
Lord, earlier the same cadre. From juniors lineman,
No, no,
the
no.
promotion
Assistant-
is assistant lineman.
No, assistant lineman has been called now junior lineman.
No, my lord. Assistant lineman is very much available. Junior lineman is below that of assistant lineman.
No, one more post has been created.
It has been created.
Created,
It is maintenance level feeder post has been created.
Petitioners are claiming which post?
Now they are stating even in case of junior lineman, junior powerman, junior station attendant, you give weightage to us. Because we are ITI and ITC graduates.
No, what is this court said?
My lord, I'll take your lordships through.
And that could, my lord, we have no locus standi in that case. That's the reason it was been dismissed.
Para
Apart from that,
23.
there is no other
Let
observation.
us see that. Is there any finding regarding?
With regard to the post, my lord, para 23, my lord, your lordship will find this with regard to question of the
Yes.
nature of post. The post of junior station attendant and junior powerman with minimum qualification of SSLC, as noted above, cannot be equated to the post of assistant lineman, requiring pass certificate of 3 years in lineman trade, electrician trade, imparted by Industrial Training Institute of KB, KPTCL. The post of assistant lineman being different and distinct from that of the post of junior station attendant and junior powerman cannot be compared. So the fact that these two posts are different and distinct, my lord, the coordinate bench was pleased to consider that. Thereafter, my lord,
No, even junior station attender,
please,
then ITI qualification cannot be fixed. It is an higher post.
because it is, we have
Junior powerman can be fixed. You are not-
SSLC.
No, that-
SSLC is the
No,
qualification.
they are seeking that ITI qualification.
For those posts also.
ITI is there.
My lord, the ITI is for junior station attendant, junior powerman, 10 standard, my lord.
No, which post now you have been provided for ITI students? What post?
Assistant lineman, assistant lineman. A para 23 for lordship sees that
Assistant lineman.
assistant lineman.
Assistant lineman is senior to that junior
Please,
station.
senior to the junior station attendant, junior powerman. By way of promotion also 20% is there, my lord. From junior powerman, 20% promotion they.
No, that when they are not eligible to be that lower post, what they will use in taking that ITI in that higher post?
Well, at ITI in the higher post, there it is direct recruitment. Only we recruit ITI and ITC graduates.
No, that junior station attender, your direct recruitment is there.
Direct recruitment
Well,
is there.
now that they're saying the percentage. What is the
Percentage, my lord.
Now, what is the percentage you have fixed?
That
No,
2020.
last occasion they have argued that you have reduced that percentage.
We have reduced.
They have reduced
We
the
have
percentage.
reduced.
For that their case is.
We have reduced. That is.
Earlier it was 50-50.
No, my
No,
lord, it
my
was
lord.
50, 30, 20 minutes.
Now?
Now ITI is 20, now 30 is for the ITC and 50 is for
No,
the.
that one more writ petition where they have challenged and it is allowed by the writ petition and it is modified in the writ appeal. Where is that writ petition order?
That order.
That will see what is the reason given by that.
That is, my lord, the writ appeal, my lord.
Not appeal. Appeal ಅಲ್ಲಿ our memo ಹಾಕಿದ್ರು.
Even memo it has been.
But reasoning has been given in that writ petition. I want to see.
2012 orders.
But in that case, my lord, the ITC student, they have approached the court stating that they have reduced the reservation. That was again, we went up to the writ appeal where they have.
Court has allowed and.
Allowed. Writ petition was allowed.
What are the reason which is given under that?
That
Same is applicable for you also. That
Yes,
But
Whether-
that is only for post of assistant lineman.
No, I'm not on that. What are the reason
We-
which is
I'll
given
place
court?
that.
See,
That I will also place.
you are that employer, you can fix what are the qualification you want. But court has come to the conclusion that that can be set aside. There should be some legal
Please,
ground.
But
We'll see
but
that
there
legal.
what my instructions are, there also there were apprenticeship training was given by KPTC, but that benefit was not being given to them. So court stuck down telling no, you have to consider that.
Because
But I placed
here
that-
they are not given a training by that.
Here
They
They're not
they are
being
only
called
a
as-
fresh students.
They have not
Direct
even
from
called us.
ITI.
my lord. They have not been
Then
called us.
therefore I will see that ground.
I produced that
But is-
position.
but however, I will just point out on the statement of objection filed by them. That's on the page number
No,
37.
what is your right to see that employer you
My
don't
lord,
amend that?
they themselves stated that what is the reason that we have not recruiting the ITI students? Their own statement of objections.
Whatever may be the reason, they are the employer, they know that what is the qualification required for their
No,
post. What is your
they
right
are
to see?
saying, however, I'll just read out the paragraph. They are due to academic reason, administrative reasons, my lord.
Whatever may be the reason, show me what is your right to seek direction to the employer to see that this should be your rules.
No,
And
it
you
was-
should be, show me that, what is that reason you are seeking that?
My lord,
The second decision.
See, you
PU
can
Joshi-
seek anything against the government seeking that
Yes, my
policy
lord.
making because
Yes, my
you are all that, you have to be given an opportunity for employment.
yes, my lord.
What about that corporation?
My lords, they are taking the SSLC students, my lords, they are paying them every month, they will pay some amount. Lords, here I have passed.
Let us see that judgment and we'll see that. You produce the judgment of.
Also, since it's the domain of the employer on that also I've produced, but I'll produce the
judgment we'll see.
2012
Yes.
judgment and also try to
Yes.
convince your
Yes.
lordship.
At the request of respondent, leave this matter next week.
Shortest.
My lord, let it be after 5th, my lord, any date after 5th,
17th, yes.
please.
Cell number
Grateful.
65 adjourned, cell number 66 adjourned, cell number 67. Yes, Vishwanatha for petitioner, N.N. Naresh.
For the respondents in this matter.
Yes, for the petitioner, yes, my lord. This is
This matter was taken up and heard in part.
Yes.
And then this honorable court had raised a query, which I'm supposed to answer.
Yes.
Even if, to recollect, the
What are the,
petition.
issues
My lord,
involved?
here, my lord,
The
matter for,
petitioner was not
promotion.
promoted.
Yes.
The petitioner was not promoted and then therefore he has sought for a direction that his name should be included in the list of, in the promotion list.
Yes.
So that is the prayer.
Yes.
And then I had pointed out that there are three things involved. One is the minimum service in the feeder cadre, that is 5 years, which he has.
Yes.
Then the last 3 years prior to the promotion,
Yes.
his appraisal should be satisfactory.
Yes.
And then the third was the result in either a written or oral test.
Yes.
So instead of written test, an oral test was
That is
conducted.
what we have asked.
And
What
then
is
this honorable court wanted to know
Yes.
whether BMRCL has power to conduct the oral
Yes.
examination. What my learned friend has produced as Annexure P, I'll just take this honorable court through that first.
Annexure?
Annexure P, page number 37.
Yes.
This is the office order.
Yes.
Dated January 12, 2017.
Hmm.
And then it says notifying post-wise rules for according promotions to O&M employees. O&M is operation and maintenance.
Yes.
Video office order number 10 dated 21/1/2015.
Yes.
The bank BMRCL employees cadre and recruitment rule 2014 as approved by the board of directors in the 74th meeting held on 5th December 2014 were notified. Further to this, for implementation of the policy laid down in the BMRCL employees cadre and recruitment rules, guidelines and instructions for promotion of employees working in the operation and maintenance wing is being notified herewith. This shall come into force with immediate effect. And then after that, the guidelines are given. And at page number 53, this is what I had pointed out on the.
Yes, these are all the requirement for promotion.
These are all the requirements. So what is required to be noticed
Yes.
is that these are the guidelines issued in furtherance of the rules.
Yes.
So I'm producing the rules itself, the cadre and recruitment rules of 2014. In Annexure P, there was a reference to the very same
Yes.
office order
Yes.
dated 21/1/2015.
Yes.
That can be found at page number 2 of the
Yes.
compilation that now I have.
Yes. 3 is the rules.
Yes.
Yes. Under the rules, where is that criteria for promotion?
Yes. I'll just take this honorable code through rule 3J, which is at page number 4.
Yes.
Promotion
Yes.
means the appointment of a BMRCL employee from an existing post to the next higher post. So
Yes.
promotion under ಏನು ಅಂತ that is
Yes.
page number 4, rule 3J. Then rule 5 speaks about procedure for appointment.
Yes.
In that, the relevant portion is in the next page. By promotion of the employees as provided under these rules.
Yes.
Then 5.2.
Yes.
In the case of appointment by promotion, the post shall be filled by selection from the list of employees who are in the zone of consideration and are found eligible for such promotion on the basis of the marks secured by the employees in a test and or interview conducted and satisfactory performance and completion of qualifying service as prescribed in Schedule 1 and 2 of these rules. The details of the test interview shall be prescribed by the
What is
appointing
this he has
authority.
produced in page 53?
So those are the guidelines which are made under the rules.
Yes.
So
Now the rule will prevail.
now kindly turn to page number 43. In page 43, internal page number 29.
Yes.
Adರಲ್ಲಿ serial number 33.
Yes.
It says manager,
Manager.
11 technical and 2 general posts.
Yes.
The pay scale is given. Method of recruitment is promotion.
Yes.
Then qualification experience. To be eligible for promotion,
Yes.
the employee should have put in at least 5 years of service as assistant manager. Selection criteria for promotion is merit in the written and or oral examination conducted for the purpose. So the rules specifically prescribe for either a written test and or a oral test.
Yes.
So oral test, there are no guidelines prescribed. Only for the written test, guidelines are prescribed under the under Annexure P.
Yes. Yes, Mr.
So therefore, the conduct of an oral examination is provided for under the rules itself.
Now, why he is not eligible?
He is not eligible because among the 3 years prior to the date of promotion, in 2 of his APRs,
Yes.
his performance is not found to be satisfactory.
Where is that ACR report?
Yes, I had filed it along with a memo on the last occasion.
Yes.
I filed the minutes of the meeting and then also the
Yes.
APRs for 5 years.
Yes.
So the minutes of the meeting is at page number 2. This is dated 20th May 2025.
Yes. Yes.
Minutes of meeting of Departmental Promotion Committee for promotion of assistant manager to manager.
File ಹೆಂಗ್ open ಮಾಡೋದು? Page ಕಟ್ಟಿದ್ರೆ page open ಮಾಡೋದು. Yes.
Additionally,
Yes.
The above Departmental Promotion Committee members met at the office on so and so and noted that the DPC committee met on 16/5 to conduct the personal interview of the 15 candidates. 14 candidates out of 15 candidates attend the DPC interview. The DPC interview was conducted based on the notification issued by the corporate office, and interview was conducted for 100 marks. Service in feeder cadre, APAR of 5 years, experience in feeder cadre, education criteria, and interview marks. Further, it is noted that all 14 candidates attended the interview except one candidate. And based on the interview performance along with so and so, the merit list enclosed is as follows.
Yes.
His name is found at serial number 5.
Yes.
Employee number 20509, Muralidhar M. Different marks have been given, and then at the end,
Yes.
it says not suitable, comma, earlier disciplinary action initiated. Then I'll take this honorable court.
Now, there is DEA is also there.
No.
Departmental inquiry is initiated against him.
Departmental inquiry was initiated against him in the year 2020-21.
Yes. It's pending or it's over?
No, I think a penalty was also imposed, which he has produced as I think Annexure J. And then kindly see the APR for the year 1st April 2022 to 31st March 23. This is at page number 13.
Yes.
22 to March 23.
Yes.
Additionally, kindly come to page number 16. On top of page number 16,
Yes.
appraisal by the reporting officer. There is still scope for improvement in the working of this officer. He has been counseled repeatedly. Remarks by reviewing officer. For the sake of improvement, one opportunity is given at the time and his APAR rating is reviewed as good. So in the previous years, it was very good.
Yes.
But is good ಮಾಡಿದ್ದಾರೆ, just to give him one more opportunity. Although he was not entitled to that, they have given this.
Yes.
Then the next APR, in that there are no adverse remarks for 2023 and 24. And for the next year, that is at page number 21, 1st April 2024 to 31st March 2025.
There are also no remark.
Additionally, even in page number 22, if this honorable court were to take,
Yes.
Initiative nulli, it is number 4.
Certain areas in his.
Not much initiative taken.
Yes.
Then social interaction satisfactory. Then in number 4, needs to be frequently reminded to get the work completed by the target date.
Yes.
Then in number 7, it says an indifferent organizer. Then field work efficiency in number 10 is average.
Yes.
So ultimately, in the star ratings, overall grading, that is at the end of page number 23, the star rating given is average. And then there's a remark that he is an average performer.
Yes.
And in page number 24, the accepting authority says that accepted as average as per attributes ratings given by the reporting officer. So considering all these aspects and also the fact that there was a departmental inquiry and then he has suffered punishment, the DPC has considered it fit not to promote him to the next.
Yes.
Yes, ma'am. I clarified, ma'am. Here, my lord, first of all, related to the document now they have produced in page number 2. Today, what they have produced. You may kindly go through that, the date, January 21, 2015. May kindly come to the my petition annexure P, my lord. That is subsequent of 2017 order, annexure P. That is January 12, 2017. Yes. Yes.
See,
I clarified, my lord.
by exercising the power under the rule that has been issued.
Yes. May kindly go through that, my lord, as page number
The
53.
guidelines for implementing that rules.
Yes, page number 53, my lord. Here, my lord, it's very clear that, my lord, number 1, my lord, BMRCL Employee Cadre Requirement Rule 2014 provides the promotion to employees working in cadre of assistant manager, technical assistant manager to the post of manager if the employee has put in at least 5 years service as assistant manager, is completed 5 years, my lord, and secured satisfactory performance assessment in the last 3 years. May I kindly noted, my lord, last 3 years. The service count from the date of reporting the post of assistant manager BMRCL. The last 3-year performance assessment means performance appraisal report to respect of employee for the 3 years proceeding for the year of promotion. Selection criteria for promotion is merit in the written examination conducted for the purpose. Here, my lord, there is no written examination is conducted, my lord. Last only for the 3 years appraisal report here mandatory. So now, my lord, related to
now that written examination is not necessary because there is an option under that C&R.
Right, my lord. But
Either
criteria for rejected, the reason it is that in last 3 appraisal report, one is for good, that is in 2024, and 2025 is average. Average means it is not a unsatisfactory. Average, it is not a poor. So it is a satisfactory. What is the criteria considered for rejecting my promotion? There is no answer from their side, my lord. My lord, and now they are related to mentioned in that DPC in page number 3 mentioned that not suitable of earlier disciplinary action.
I have made it that provision.
Yes.
That on reviewing of your merit, they can be considered. Now, their consideration is that since you are in average, you are not suitable unless you show any other candidate who has average also promoted. Then you have any case. Otherwise, their discretion, Mr. We can't say.
That is not a discretion. What is it? Is it the criteria? Is it the average? Is not a.
Now, show me any law or judgment showing that even if it is an average.
Well, it is defect on their part, my lord. As per guidelines, it's very clear that consider
guidelines. You forget about the now he has
not guidelines. It is a bylaw of the respondent. It's how what is the procedures and the measurements for consider for promotion.
Whether now, this will prevail or that C&R rules will prevail.
My lord, that is the C&R. What I am produced that it is a subsequent 2017. The same.
This is not in a C&R. This is issued, guidelines as issued in terms of.
It is not the.
Yes, you are.
See, page number 38.
Yes.
Wise rules for according promotion to the employees in the operation of maintenance wing. Promotion to the post of manager from assistant manager. It is clear. Promotion to the post of manager. This is the rule.
Yes. Yes.
The criteria of rule they are not considered.
Yes.
First of all, written examination is here. Last 3 years appraisal report is criteria for consideration. Kindly in further it is mentioned in that melody in page number in the page number 54 and 55. The test will be conducted BMR training institution, bioptical department. Duration of written test will be 3 hours. Question paper will be consist part A and part B and part C.
Yes.
So these are the and page rule 12. Employee in respect of all disciplinary proceedings are in pendency. So I have no any pendency. There is no any disciplinary proceedings.
See, there your case is only rejected on that on merit on appraisal report saying that you are an average. That is what is case. That is all.
That is average is not unsatisfactory.
Yes, we'll consider.
That is what they have taken consideration, and whether it is that criteria is, it is not unsatisfactory. So now it is not a poor.
Now, which law says only unsatisfactory is not to be considered in other category? It can be considered. You show me that.
Let them. They produce Millard.
See, there are category good,
Millard.
very good, excellent.
Let them. They
which
what
are
they
the
have
categories
produced.
has to be considered for promotion, which cannot be considered. You
Millard,
show me any other.
What they have produced? What they have produced, that appraisal report of last 3 years. The last 3 years of appraisal report. In 2000, as per their report, Millard, in 2022, in page number 12, Millard.
Yes.
In rating, Millard, that is 8, 11, 12, 8. The outstanding, very good, good, average. The consider as a very good. And next in 2023,
yes,
that is good. And in 2023, 25, 24, that is his appraisal rating is reviewed as a good. So now it is good. The last it is for mentioned as average. In another one column is there, Millard, poor. Not considered as a poor. It is considered as average.
No, that is there are different mechanism is made.
Right,
Even ACR which is accepted, if it is not satisfied, you can also seek for a review and reconsideration. Now we cannot do it, miss. It is not that they have done it in a final.
Millard.
There is then also that there is a mechanism you can seek for a review on the ground that report which is given is not correct. There is also a mechanism, but as on now that is final. That it shows
Millard,
that one is
Millard,
good, one is average.
What they consider criteria for rejecting my promotion,
Yes.
it is not improper. It is not in accordance. It is not based on what they are rejecting only the
Yes.
other than marks list, Millard. May kindly go through that, Millard. What is the produced? May kindly page number 3, Millard.
Now
May kindly,
you
please, Millard. Kindly
go and challenge that seniority list. Now you are consider that only your this thing as per the suitable ranking, consider seniority promotion to the post.
Yes.
Eligibility candidate for a promotion to the post. Of
Yes, I am
manager.
eligibility. In that list, I am in my. It is in serial number 3, Millard.
Yes, that's all. Yes, we'll consider. Yes, tell.
Millard.
We'll pass an order, Mister. It's over.
Millard. Once may kindly go to the page number 3, Millard.
Page number 3 of.
They have produced that in document, today's document, in earlier document, Millard. That is in 5.
Yes.
Muralidhar M. APR of 5 years, 22 marks. Experience in field, Millard.
Which one you are relying on?
The DPC committee.
DPC committee.
No, the documents produced earlier.
Yes, Millard.
On the last occasion.
Yes. Page
number 3, Millard. Millard. In serial number 5, the name of the petitioner it's mentioned, Millard. APR of 3 years, Millard, 22. Experience feeder cadre 15. Education criteria 20. And interview mark 5 and total mark 62. Suitable, not suitable earlier disciplinary action initiated. Millard. Here, Millard, I have no any disciplinary and related issues are
all
pending.
other who are above you, their marks has been scored more than that, Mister. You cannot be placed above them. They are all 80, 78, 80, 83. You are in 62. Can you say that you have to be placed above them?
Millard, that criteria, Millard, what is the mentioned in here? Everything, my lord, education criteria is all are equal. Experience cadre also same, and APR of 5 years also in same. You know. Only that, my lord, total marks differentiation only related to the interview marks. In that, my lord, interview marks, my lord, in my kindly in page number 53 of that rule 12, my lord, there is no interview related issues, my lord. Only that criteria for considering the written test examination.
What about that C&R, Mr.? It's a rule which is applicable.
C&R, I'm go through that C&R, my lord.
What is that he has produced?
It is in that is in earlier, what I am produced, it is subsequent, my lord.
No, where is that? It is shows that it is C&R, Mr.
Yes.
These are guidelines which are prepared under the C&R to enable implementation.
Yes.
But it does not contemplate.
First of all, what
are
they have
the-
produced, my lord, what they have produced in the same, kind in page, go through that in page number 24. It is reflected that, my lord, that is in the direct recruitment. It is mentioned. In that page number 29.
Yes.
In that column, my lord, column serial number 15, manager, direct recruitment, maximum age of 40 years, graduate from recognized university, so and so. Knowledge, so deputation, graduate with overall experience 5 years, of which experience 3 in personal administration government.
Yes.
So now this is not applicable. What now they are produced, that is in earlier. Now, so what is the what I am produced in 2017? The same post, manager.
Rules may be called Bangalore Metro Railway Corporation Limited Cadre and Recruitment Rules 2014. That is
Yes,
what he has
2014.
produced.
Yes.
What you have produced, that is in a.
It is subsequent to 2017.
That is not in a rule, Mr. That is not a rule, Mr.
My lord.
Annexure P itself is clarificatory.
Yes, annexure.
Annexure P itself, page number 37. That's what I read out.
Yes.
It says in the second paragraph, further to this, for implementation of the policy laid down in the C&R rules,
Yes. Yes.
guidelines and instructions for promotion of employees working in the operation and management wing is being notified herewith.
Yes,
Therefore, these are guidelines, and if there's any ambiguity, then the rules obviously will have to prevail.
What are the two difference?
No,
I
it
get
is
and
not a
clarify.
rule, Mr. I will give that finding. It is not a rule in terms of that.
My lord.
Rules 24, this has been issued. It is in the first paragraph. It is also mentioned.
There is a reference to the very.
May I kindly go through that? What is the page? Page number 47, my lord.
You have argued, Mr. I will consider if my order is wrong, you challenge it. I can't give go on timing, Mr. Half an hour.
My lord, just only the average. Average, it is not a criteria.
No, Mr. Counsel, you have argued. Or you want to write in a judgment. It's the end of the matter for me to decide. Is it not? I have heard you last occasion also, it's half an hour I heard you. Now also that. Now when it is comes to that against you say that I want to take if there is any doubt, last occasion doubt, I ask him to clarify. Now there is no doubt on that. It is not there cannot be a two C&R, Mr. You see that C&R should be like this, Mr. All the categories, chart should be there, promotion criteria, pay scale. This is what that C&R. First see that how the C&R will be there. Yes, at the request of let him take time. Petitioner leave this matter of 4 weeks.
Bill number 68, Srinivasa K for petitioner.
Tomorrow you will bring one letter saying that it will C&R. Yes.
Short accommodation. Petitioner will give the petition.
Serial number?
On copy of petition. Short accommodation.
Lord, this is not the second round of litigation. The petitioner is a retired employee, Lord. An amount of rupees 2,72,000 has been recovered from out of his discharge amount.
Why?
And it is covered by the Lord.
Now, how you can recover, Mr.
So far as the instructions that I have, it is an amount that is given for career advancement. That amount is not entitled for, that is what is being deducted.
No, even then that you cannot recover.
Okay, I'll file my formal objections. Pray for 2 weeks.
Because it is covered, you cannot recover that what Supreme Court said.
Yes.
Even then, if he is not entitled also, it cannot be. You are Group D.
Group C employee.
Group C employee also.
I'll file my formal objection.
Yes, let him file objection. Yes.
Short date.
Yes. 10th. The problem is that these are all small matter. If it is reached, I have to close it. Otherwise, see that I have wasted half an hour. I don't know whether next day it will reach or not. Yes.
Serial number 69, Shrikant MP for petitioner, government
Issue. The compassionate appointment, my lords, 2003 is the appointment.
Yes.
Not approved, my lords, saying that application was not filed within 1 year. Matter, my lords, I approached this honorable court because in 95 the application was made. Vacancy was not available in an aided institution. Subsequently, when available, I was taken. Not writ petition held in my favor. Not writ appeal also confirmed the order of the not the single judge. Approved in 2011. They say from 2011 will pay salary. Not compassionate appointment. 2003, my lords, the appointment is made. Salary, my lords, they say will pay from 2011, which we say, my lord, is not proper. In fact, my lord, it is covered by decision of this honorable court, division bench, my lord, which your lordships also consider, my lords, in one of the cases. If there is an administrative delay, my lords, that cannot be held against, my lord, the person. My lord, ultimately, compassionate appointment is to overcome, my lord, the necessities, my lords. It is made. Para 13, my lords. Para 11, I'm sorry, my lord, page number 11.
No, now that latest division bench,
My lord,
Darwad said it has to be done it within 6 months.
No, the single judge. My lord, that is one part of it. My lord, what I'm saying is,
No, at least from filing an application within 6 months, it has to be
my
considered.
lord, 2003, my lords made, they don't do it. I approached this honorable court, writ appeal also in my favor. 2011, they approve and say we'll pay from them.
Madam.
My lord, I would like to refer one judgment, my lord, for
Yes.
because the granting aid, my lord, was passed subsequently to the petitioner, my lord.
Granting aid?
Was passed subsequent to the appointment, my lord. Kindly refer to page para 5, my lord.
Yes.
Government AGF for respondent submitted the matter with regard to continuing service from the date of appointment till the date of approval or admission to the granting aid is pending before the division bench on WP number so and so, and he submits that the petitioner prayer would depend upon the outcome of the writ appeal, my lord. On hearing the learned counsel for the parties and on perusal of the entire writ petition paper, I deem it appropriate to dispose the writ petition with a direction to the petitioners to make appropriate representation depending on the outcome of the writ appeal.
No, that is not applicable to
My
this
lord.
case.
My lord,
Seeking for an benefits, my lord, which was much before the appointment.
No,
Oh.
see, he is entitled for the appointment the day his father has died or day he has filed an application.
Yes, my lord.
Now the division bench said it is a mandatory that you have to be consider that application within 6 months. You are not considered for in 5 years. Can it be said that?
10 years, my lords. 2003 and 2011 is the approval.
See here, what they say that it is not admitted to the granting aid. It is a post which has been admitted to the granting aid. In that post, he sought for this thing.
Para 11, if you lords kindly
Can you
similar.
look at the endorsement, my lord, which is at annexure K, page 63. my lord. Adaritavu, may I read, my lord?
Yes,
Page 64, please.
yes.
ಆಡಳಿತವು ಮೇಲ್ಕಂಡಂತೆ ತಿಳಿಸುವ ಅವಧಿಯಲ್ಲಿ ಸಲ್ಲಿಸಿದ ಸೇವೆಯು ಅನುದಾನರಹಿತವಾಗುತ್ತದೆ.
ನೀವು
ಆಡಳಿತ ಮಂಡಳಿಯು ಮಾಡಿಕೊಂಡಿರುವ ನಿಮ್ಮ ನೇಮಕಾತಿಯನ್ನು ಉಪನಿರ್ದೇಶಕರ ಪ್ರಸ್ತಾವನೆ ಹಾಗೂ ಶಿಫಾರಸ್ಸಿನನ್ವಯ
No, this is that, where is that appointment order?
Lords, the appointment order, my lords, fortunately I have not produced, but it's a fact, my lords, your lords may kindly see.
No,
my
in the
lords.
appointment order, what they stated.
No, 2000, that my lords is available to my lords, your lordships.
You have not challenged that order.
Lords, I was appointed in 2003.
No, that 2003 you are appointed,
Yes.
but you are entitled for the benefit from.
That is my lord under challenge in this.
No, have they stated in that?
My lord, now in the endorsement they say, if lords kindly see, my lord, the impugned endorsement.
When that appointment order has been issued?
This is, my lord, the order after I approached this honorable court, saying that I am entitled from the initial date of my appointment. And though I made a representation, they are not considered. This honorable court directed them to consider. Then they issue annexure K, page number 63.
No, where is that earlier order of this court?
My lords may have a look at, my lords, annexure.
Why you have approached this court earlier?
Annexure C, my lords, page number 34, is the order of the learned single judge. My lords, I sought to challenge, my lords, your lordship may kindly see the first application made by me, Annexure A, my lords, page number 31.
Yes.
On 5/12/1995, my lords, I preferred an application for appointment on compassionate growth, 31, my lord.
Hmm.
Management issued an endorsement, so and so Supinakiri Hanuriವರೆಗೆ ಹಿಂತಿರುಗಿಸುತ್ತಾ ಕೊಳ್ಳೇಗಾಲ ತಾಲೂಕು so and so ನಡೆಸುವ ಪ್ರೌಢಶಾಲೆಗೆ ದ್ವಿತೀಯ ದರ್ಜೆ ಸಹಾಯಕರ ಹುದ್ದೆ ಖಾಲಿ ಇರುವುದಿಲ್ಲ. ಹುದ್ದೆ ಖಾಲಿಯಾದ ನಂತರ ನಿಮ್ಮ ಅರ್ಜಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದೆ ತಿಳಿಸುತ್ತಾ ಹಿಂಬರಹ ನೀಡಲಾಗಿದೆ. My lord, the vacancy arose in 2003. My lord, they rejected saying that within 1 year you did not apply. Annexure C, my lord, was filed.
It is arises in 2003.
Actually, I was appointed in 2003.
Yes, it should be.
My lord, this honorable court, para 3, my lords, page number 38. Having regard to the totality of the circumstances, I am of the view that the communication endorsement at Annexure F is liable to be quashed, accordingly quashed. Petition is allowed. The matter stands remitted to respondent to reconsider the case of the petitioner afresh by taking second of the application for consideration, taking it as filed within time. Respondents are also directed to take note of the subsequent amendments to the rules. Then, my lords, the matter was tested before division bench, Annexure D, my lord. Page number 43, my lord. Para 5. Accordingly, we are satisfied that the impugned orders dated so and so passed by the appellant rejecting the claim of the respondent number 1 for appointment on compassionate grounds under Rule 5 of 96 rules are wholly untenable. Therefore, the determination rendered by the learned single judge to the effect that the application moved by the respondent number 1 for seeking employment on compassionate grounds should be treated as having been filed within the period of limitation cannot be faulted with. For the reasons recorded here above, we find no merit in
Even
the
at least from the directions from the date of that 2008 issued by the single judge, you could have been considered. Till then that there is an ambiguity, then the court has cleared that. Now that when that appointment order is issued?
My lords, 2003, my lords, I was appointed 5/9/2003.
Appointment order.
5/9/2003.
No. That approval of that.
Approval, my lords, Annexure E, page number 45.
2012.
12 ಅಲ್ಲಿ what they say, that is subsequent to, my lord, the communication of the commissioner. What they say, ಉಲ್ಲೇಖ 1ರ ಮಾನ್ಯ ಆಯುಕ್ತರು ಸಾಹಿತ್ಯ ಇಲಾಖೆ ಬೆಂಗಳೂರು ಅವರು ಅನುದಾನ ಸಹಿತವಾಗಿ ಅನುಮೋದನೆ ಮಾಡಿರುವುದರಿಂದ ಆದೇಶದಲ್ಲಿ ಸೂಚಿಸಿರುವಂತೆ ಈ ಕೆಳಕಂಡ ನೌಕರಿಗೆ 21/10/2011 ಜಾರಿಗೆ ಬರುವಂತೆ ಹುದ್ದೆಯ ವೇತನ ಶ್ರೇಣಿಯ ಕನಿಷ್ಠ ವೇತನಕ್ಕೆ ನಿಗದಿಗೊಳಿಸಿ ಆರ್ಥಿಕ ಸೌಲಭ್ಯವನ್ನು ದಿನಾಂಕ 9/11/2011 ಪೂರ್ವಾಹ್ನ ಕರ್ತವ್ಯಕ್ಕೆ ಹಾಜರಾದ ದಿನಾಂಕ ಜಾರಿಗೆ ಬರುತ್ತೆ ಪ್ರಥಮ ವೇತನ ಡ್ರಾ ಮಾಡಲು ಅನುಮತಿ ನೀಡಲಾಗಿದೆ. Subsequent to, my lords, the approval, they say from 2011 you are entitled.
Then there you have given retrospective effect on 2011.
ಅಲ್ಲ, ಪ್ರಾಸ್ಪೆಕ್ಟ್ 11ನೇ ಇಸ್ವಿಯಿಂದ ಕೊಟ್ಟಿದ್ದಾರೆ, 2003 ಸೇರ್ಕೊಂಡಿದ್ದಾರೆ.
ಅಲ್ಲ 2012 you said 2011 you can give it. Why can't that 2003? Before his appointment, he cannot be given that salary, but you have said that 2012 it can be 2011.
ಅಲ್ಲ, ಅಪ್ರೂವಲ್ ಆಗಿದ್ದ ಡೇಟ್ ಮತ್ತೆ ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೊಂಡು ನಂಗೆ ತೋರಿಸಿ ಅಪ್ರೂವಲ್ ಆದ್ಮೇಲೆ then they have
when that it was become vacant on 2003.
Lords, 2003, 5/9/2003.
Where is that judgment?
Lords, para 11, which I writ appeal 1390 of 2017. Para 11.
Yes.
The learned government advocate contended that the first respondent cannot claim the financial benefits of the post of headmaster even from 21/11/99, as the promotion of the first respondent was approved by the competent authority only on 6/9/2001. According to the learned government advocate, consequent on approval of appointment, financial benefits will be available only from the date of the order approving the appointment promotion. Reliance is based on a government letter dated 29/10/97, a copy of which is not placed on record. Even assuming that the said government letter provides the financial benefits will be available only from the date of approval, we are of the view that such a stipulation or condition is unjust and unreasonable. If an eligible and qualified person has been appointed to an existing vacancy in accordance with the rules and he actually discharged the functions of that post, the mere administrative delay on the part of the department to issue orders granting approval to the appointment cannot result in.
Find fault with this appointment. It is in accordance with law. The vacancy is also not disputed.
But that is not even decided, my lord. Only issue, my lord, in the endorsement, my lord, stated that, my lord, as on that date, my lord, granting aid was not given, my lord. Based on that point, my lord, an endorsement has.
No,
been-
is it your case that his appointment is not in terms of the law?
Not at all.
Huh?
Not at all.
Then he is entitled.
In fact, your
This is
lordships
what-
also, my lords, consider and followed this, my lords, para 5 onwards. Sorry. Where, my lords, his appointment was not approved because of claim and qualification.
Yes.
Matter went to Honorable Supreme Court, confirmed that he has qualification. Para 5 onwards.
Yes. Yes, the similar line this, there, since case has not been decided, therefore there, yes.
Approval was made subsequent, my lord, subsequently, then it was limited.
Yes, that's all. Tali. This writ petition, petitioner called in question, endorsement annexure K dated 28/3/2025, issued by respondent number 3, stating that petitioner entitled for all service benefit from the date of appointment order has been issued. Case of the petitioner that his father, late Sundra, was an employee of that sixth respondent. He was working as a craft teacher in the institution run by sixth respondent in the aided post. Petitioner father died on 15/2/1993 while he was in service. Immediately thereafter, petitioner has filed an application on 5/2/1993, 1995, seeking appointment on compassionate ground as per annexure.
Annexure
Yeah.
A.
Endorsement is what? Typed copy.
Vacancy ಇಲ್ಲ ಅಂತ vacancy ಆದ್ಮೇಲೆ ಕೊಟ್ಟು.
No, how can you typed copy of annexure A ಅಂತ ಬರೆದಿದಿರಲ್ಲ endorsement ಗೆ? It should be annexure B or A1.
ಅಲ್ಲ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಪೋರ್ಷನ್ ಮಾತ್ರ ಟೈಪ್ಡ್ ಇದು ಹಾಕಿದೆ ಅಷ್ಟೇ. ಐ ಮೀನ್
ಕೆಳಗಡೆ ಮಾಡಿದ್ದಾರೆ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಅದರಲ್ಲೇ.
ಅದರಲ್ಲೇ 32 ಕೆಳಗಡೆ ಬರೆದಿದ್ದಾರೆ, ಅದನ್ನೇ ಟೈಪ್ ಪೋರ್ಷನ್.
His application dated 5/12/1995 annexure A has been kept in abeyance ground that there was no any vacant post. Same will be considered if the vacancies arises. Then where is that your appointment order?
I was taken to duty notes at that time. That was moved and notes. The
Then
records
all
are
that
not.
contention left open. If the appointment is in proper and all, you have to verify and yes, because he has not produced that.
ಅಲ್ಲ, they have verified and that's why they admitted me to the grantinate. Annexure E
Yes.
ಎಲ್ಲ issue ಆಗಿದೆ ಅದಾದ್ಮೇಲೆನೆ.
Yes.
Unfortunately, some of the documents are not available.
Further
with
case
them.
of the petitioner that in the year 2003, the vacancy was arises and he was been appointed by which management?
It is with
Sixth respondent
Sixth respondent.
management. As a what?
STA. Second
STA.
divisionist. Second divisionist.
Yes, as a STA. Then why you have approached this court?
It was not approved, my lords. An endorsement was issued. on 6/5/2006, challenging, saying that application was not made within 1 year from.
Thereafter, petitioner has approached that authority for approval his appointment.
Para 3 have stated.
Request of the petitioner was rejected. By endorsement dated
6/5/2006.
ಎಲ್ಲಿದೆ?
ಅದು para 3 ನಲ್ಲಿ ಹೇಳ್ತೀನಿ ನಾನು. Second line, page number 11.
ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಏನು ಚಾಲೆಂಜ್ ಮಾಡ್ದಂಗೆ ಕಾಣಿಸಲ್ಲ.
ಅಲ್ಲ, ಅದು ಮುಂಚೆ ಚಾಲೆಂಜ್ ಆಗಿತ್ತು ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ. ಅದಕ್ಕೇನೆ ವಿತಿನ್ ಟೈಮ್ ಅಂತ ಟ್ರೀಟ್ ಮಾಡಿ ಕೊಡಿ ಅಂತ.
Yes. His request was rejected that application was filed belatedly. Petitioner has approached this court filing in a writ petition on 17330 of 2006. This court by order dated 24th June 2008 wide annexure C remitted the matter back to the respondent to consider the case of the petitioner. After taking second application for consideration, treating it as an filed within the time. Thereafter, state has filed an appeal in writ appeal number 3566 of 2009 wide annexure D. The appeal is dismissed by order dated 25th September 2010. Thereafter, by impugn order, thereafter, by order dated 28/1/2012, the respondent has issued an appointment order.
Permitted to draw for the salary from granting it.
That means you have been approved.
It was approved by letter dated 21/10/11 of Commissioner.
By approved his appointment from.
Permitted to draw the salary.
21/10/2011 and permitted to draw salary.
On 28/1/2012.
By wide annexure E. ಆಮೇಲೆ ಏನ್ ಮಾಡಿದ್ರಿ ನೀವು?
Representation ಕೊಟ್ಟೆ.
When?
That is annexure F, page number 46.
Thereafter, petitioner has submitted a representation, annexure F.
Has not considered approach this court again.
Seeking all service benefit from the date he was appointed in the year 2003. Since his representation wide annexure F is not considered, he has approached this court by filing in a writ petition WP number 55647 of 2016. This court by order dated 12th April 2023 has directed the respondent to consider that representation. Pursuant to the directions of this court, the impugn endorsement has been issued, rejected the request of the petitioner. Learned counsel appearing for the petitioner has submitted that the vacancy was arises in the year 2003. Sixth respondent has appointed the petitioner in a existing vacancy. Even thereafter, his appointment has not been approved. Then he has approached this court filing in a writ petition on 17330 of 2006. This court has disposed of on 24 June 2008. Thereafter, they have filed an appeal in writ appeal number 3566 of 2009. even though this court has directed on 24 June 2008 to consider that application for the petitioner, approve that appointment of the petitioner. The respondent has passed an order wide annexure E only in the year 2012. Because of that administrative reason, there is a delay in issuing that approval order. Cannot be held against the petitioner for granting in a service benefit. In support of his contention, he is also relied on division bench of this court in writ appeal number 1390 of 2007. The paragraph 11 extract ಮಾಡಿ. Learned government advocate appearing for the state has contended that since petitioner appointment has been approved in the year 2012, he is entitled for all monetary benefit from the date it has been approved. She further contended that the appointment made by that management in the year 2003 was not examined whether it was in accordance with that.
And
provisions of law.
If I'm permitted,
Even-
the date of reporting to duty is 24/2005. 20 April 2005. ಅವ್ರ ಎಂಡಾಸ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ 64.
ಅದೊಂದು ಬರ್ಕೊಂಡ್ಬಿಡಿ ಡೇಟ್ ಆಫ್ ಎಂಟ್ರಿ. Even this court has directed to consider that application of the petitioner in WP number 17330 of 2006 disposed of on 24 June 2008. ಅದು compassionate appointment rules ಪಡಿ. ಅದೊಂದು ಡಿವಿಷನ್ ಬೆಂಚ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ ಮನೆಯಲ್ಲಿ ಒಂದು
ಪೇಜ್ ನಂಬರ್ 41 ಅಲ್ಲಿ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಇಶ್ಯೂ ಮಾಡಿದಾರಲ್ಲ ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಕಂಪಾಸ್ನೇಟ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಹೌ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಮೇಡ್ ಅಂತ ನಿಮ್ಲೇಖ ಮತ್ತೆ
ಪೇಜ್ 41 ನಲ್ಲಿ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. Provision rule 5.
6 months ಅಲ್ಲೆಲ್ಲ ಮಾಡ್ಬೇಕಂತ
ಅದು ಈಗ ಆಗಿದೆ. That is
earlier it was not there.
At that time it was not.
Yes. Even thereafter, immediately thereafter also they have not approved that appointment of the petitioner. Because of administrative delay, petitioner cannot be denied for the benefit if he has appointed in accordance with law and he was appointed and he was discharging his function without considering this aspect of the matter. The impugn endorsement has been issued. In view of the above, the impugn endorsement annexure K dated 28/3/2025 required to be quashed. Accordingly, quashed, directing the respondent to reconsider that matter afresh, taking into the consideration of judgment of this court in writ appeal number 1390 of 2007. And also consider that whether petitioner appointment has been made in terms of the law and he was working, discharging his function.
That is concerned, they don't have any endorsement ಅಲ್ಲಿ.
No, they have to verify whether when that really vacancies has
ಅಲ್ಲ
been
ಪೇಜ್
arised.
ನಂಬರ್ 64 ಅಲ್ಲಿ ತಾವು ನೋಡಿದ್ರೆ ಇನ್ಫ್ಯಾಕ್ಟ್ ಫಸ್ಟ್ ಈಸ್ ಅಪ್ರೂವ್ಡ್ ಆಲ್ರೆಡಿ. ಈಗ ಇಂಪ್ಯೂನ್ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಪ್ರಯುಕ್ತ ಶ್ರೀ ಮಹದೇಶ್ವರ ಪ್ರೌಢಶಾಲೆ ಸೋನ್ಸೋ ಇಲ್ಲಿ ಕರ್ತವ್ಯಕ್ಕೆ ವರದಿ ಮಾಡಿಕೊಂಡ ದಿನಾಂಕ
Stated anything.
ಅಲ್ಲ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಅವರೇ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಪೇಜ್ ನಂಬರ್ 64 ತಾವು ಬಂದ್ರೆ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್, ಪ್ರಯುಕ್ತ ಶ್ರೀ ಮಹದೇಶ್ವರ ಪ್ರೌಢಶಾಲೆ ಕೌದಳ್ಳಿ ಕೊಳ್ಳೇಗಾಲ ತಾಲೂಕಿನಲ್ಲಿ ಕರ್ತವ್ಯಕ್ಕೆ ವರದಿ ಮಾಡಿಕೊಂಡ ದಿನಾಂಕ 24/2005ರಿಂದ 20/10/2011 ಅನುದಾನ ರಹಿತ ಅವಧಿಯಲ್ಲಿ ನೀವು ಸಲ್ಲಿಸಿದ ಸೇವೆಗೆ ವೇತನ ಮತ್ತು ಭತ್ಯೆಗಳನ್ನು ನೀಡಲು ಸದರಿ ನಿಯಮಗಳಲ್ಲಿ
ಆಯ್ತು. That period
ಅಲ್ಲ ಅದಕ್ಕೆ ಅಪ್ರೂವ್ ಮಾಡಿದ್ರು ಅವರು. ಬಿಕಾಸ್ ಇಟ್ ವಾಸ್ ಇನ್ ಆರ್ಡರ್, ದೇ ಅಪ್ರೂವ್ಡ್ ಇನ್ 2011.
No, that they have to be examined whether on that period vacancies was there, whether that
can I make
and whether you are working, you can get that information. Suppose if you are not working, you are not entitled.
That is the reason they approved my appointment in 2011.
I will not let them consider.
Anyway,
even after appointment, whether you are not working, if the workload is not there, then you can't claim that.
ಅವರು ಅಪ್ರೂವ್ ಮಾಡಿರೋದಿದ್ರೆ 2011
ಮಾಡಿರೋ 2012 ಇಂದ. Before that, working strength, you are working, then only you are entitled for the salary.
Yes. Please.
We don't know, management can be issued an order and you keep it in that house. We don't know that. Let him examine.
Please.
Yes. Other matter. Just the serial number again.
70. Serial number 70. This is my lord. This is a simple meeting. We are seeking for a mandamus to consider the representation. We are the Gram Sevaks, watermen. We have retired from service. Our DCRJ and arrears of salary bill is prepared. We have given a representation, but Gram Panchayat has not released it. This was heard by my lords in the last adjournment date, my lords.
Why it is urgent?
Gram Panchayat advocate had submitted that they have not received the petition copy. We had served them through post, and also on the last date of hearing before this honorable court, we had served it to the Gram Panchayat advocate.
Yes, who is appearing for that? Yes.
My lord, I am appearing for R3 in 7071. R3.
Which matter? 70.
Now just called me.
Yes, yes. You are appearing for, you consider that representation. Yes. Petitioner has sought following relief. Where is your representation, Mr.?
Annexure B, page 11, my lords.
The case of the petitioner that. The petitioners. Now you are working or you was working?
I was working, my lords. I have retired.
Petitioner was working in 5th and 6th respondent Gram Panchayat as a waterman. Now they have retired from the service.
I'm sorry.
The respondent has not paid the arrears of the salary to the petitioner. Only arrears of salary, Mr.
My lords, Annexure A, page Annexure A, page 10 is the bill which is prepared by the PDO and the Gram Sachiv.
Yes. Even though bill has been prepared by that Gram Panchayat, the salary is not paid. Therefore, they are submitted in a representation with Annexure B dated 12/6/2023. Since the representation is not the petitioner is before this court. Appearing for executive, yes. Appearing for respondent number 3. Still appearing for the Panchayat, I submitted that. If this court grants some reasonable time, representation submitted by the petitioner will be considered in accordance with law. In view of the above, without expressing any opinion on the merit of the case, the petition is disposed of directing that respondent number 3 to 6 to consider the representation of the petitioner vide annexure B dated 12/6/2025 in accordance with law as expected not later than 3 months from date of register of application.
Highly obliged.
Same,
Number 87.
same 71.
One
Lord.
by one will come.
71 also same lordship.
71, what is that?
Same
Same,
lordship.
same by another waterman, my lords.
Another, yes, same order.
Same order, same responsibility.
Yes, Karithi,
72,
serial wise we will.
72 Veeraya Hiremat.
Yes,
72, my lord, I am for the petitioner, my lord.
yes.
My lord, it is a disparity of pay scale, my lord. The state has to file the objection. It's a second round litigation, but short date.
Yes, at the request of, you want to file objection?
72.
Yes, 2 weeks time is granted to file.
A date may be fixed, my lord. It's
Matter on 25th, yes.
grateful.
73, 74 urgent. Still number 75
Yeah,
urgent.
okay, get that as well, check out.
ಇಲ್ಲಿಂದ ಕೆಂಗೇರಿ 1 hour. Pension, 77 years pay. We had on Monday, please. 76. Monday, please.
Which department?
It's a Canara Bank. It's a bank. He was an officer of the bank. He had completed 20 years. And that, it's the second round of litigation.
No, that serial number
76. 76.
You are the petitioner.
First petition. Monday, my lord.
Who is that other side? Central government. Central government.
I think
is
central
there,
government is not a necessary party. It's only the bank.
right? Who is appearing for the bank?
Santosh Nagral.
Where is that Santosh Nagar?
Alanko Magda is for CG, central government.
Yes. We is this matter on 9th.
Serial number 77 Janardhan G.
Yes, we is this number matter of 4 weeks.
78 Vijay Kumar.
78, I appear for the petitioner. It's a matter of dismissal from service, my lord, without holding inquiry, my lord. Matter is covered by judgment of the Sita Lakshmi judgment, my lord, in 99. Agide. Now, my lord, it could be disposed of, my lords, in view of, my lord, the judgments rendered by the coordinate benches of this honorable court.
What is that?
The dismissal without holding any inquiry, my lord. And he is a Grama Sahayaka. Deputy Commissioner is the competent authority to pass an order of dismissal from. Tahsildar has passed an order of dismissal.
Where is Then, which is that law which is applicable for Grams?
Lord,
No, who has passed this order?
Tahsildar, my lord.
Who is the competent authority? Where is that impugn order?
No, my lord. It is this Deputy Commissioner, my lord.
Which is that? Where is that rule?
My lord,
Which is that rule?
let us not go into that also, my lord. In view of, my lord, without holding any inquiry, they could not have passed it or such a major penalty, my lord.
Let me see which is which is that law for the Gram Sevaka.
The district wise cadre, my lord. Therefore, my lord, the commissioner.
Gram Sevakar appointment in rules cell idhar.
Please, my lord. That I have not placed before your lordship.
Yes, madam, we'll have it on 3rd. You get that, which is the regulations which is applicable?
I will place it before your lordship.
No, government advocate. Not it. ಇದನ್ನೆಲ್ಲ ನೀವು ಒಂದು ಕಾಪಿ ಇಟ್ಕೊಳ್ಳಿ ಈ ಕೇಸ್ ಬಂದಿರೋದಕ್ಕೆ ವಿಚಾರದ see this is all that KCSR CCA rules apply ಆಗಲ್ಲ ಇದೆಲ್ಲ ಬೇರೆ
The judgments of this honorable court, my lords, I may be permitted to place on record.
What is this?
Without holding any inquiry, my lord, they could not have passed an order of major penalty, my lords, of dismissal from service.
Yes, madam. It is in respect of whom? Gram Sevaka.
No, it's not with regard to Gram Sahib. It was accountant, my lord, in town municipal council.
It cannot be dismissed without holding an inquiry.
Yes, my lord. A detailed judgment, my lord, following the, my lord, Sita Lakshmi and all, my lord, that is referred in the judgment.
You ask them to get that. What are the procedure for Gram Sevak appointment?
Yes, I will also place it.
You also place it.
Please, my lord.
Yes. If that place that, I can even without seeing that rules and all, I will.
Please, my lord, let it come in the preliminary hearing, my lord. It is not reaching it.
Even
Coming
in
in the
this
B
B
group.
group, if it is not reached, these are all the small matters. You give
Please,
that law,
Lord.
then I will dismiss. Yes.
Grateful to you, lord.
79 Maitreyi Krishnan.
Serial number 79, my lord. These are the employees of the Dharwad and Gulbarga bench of this honorable court, my lord. D group workers, and the arrears that are to be paid from 2009 to 2011 to 2019, my lord. That has been rejected. D group, no, my lord, the daily wage workers. There is a letter that has been sent by the register, which were, my lords may just see page 56.
Now you are working where?
In the Dharwad and the Gulbarga bench of this honorable court.
Or that High Court
Yes.
contract employee?
Yes, yes.
What is that you are seeking now?
My lord, page 56, this is a letter written by the registrar. This
the
is
government?
the arrears, please, my lord, to the government. Government rejects this.
No, arrears.
Objections, we have communicated, my lord, we are yet to receive the details.
No, you are not paying that arrears, madam. What is that salary they are paying?
My lord, right now they're paying 19,900. Page 56, my lords may just see.
Yes. When will you get back, madam? Who is that? Who has to give?
Acknowledgement, my lord, there is a serious contention has been taken to reject the claim, my lord.
Have you rejected?
My lord, the rejection is at page 58. I've challenged that. They merely say,
What is the reason for rejection?
they only say that we are now paying this amount and therefore we don't have to. In fact, in the public interest litigation, division bench had directed them to look into the arrears. Rejection is at page 58, my lord. Page 59 may just be seen.
Where is the recommendation of High Court?
Page 56, my lord. It starts at page 53.
Yes.
Page 56 mentions what is the payment made.
What to that rate is, yes. Earlier they have, now the difference amount they have to be paid.
Please, my lord. Difference amount, and that's calculated also at page 56.
Yes.
The difference between.
When do you want, madam?
My lord, on 4th, my lord.
4th. Yes, leave this matter on 4th at the request of. Objection hakidira? Yes, you haki astrolgade.
80 Vinay Kirti.
Grateful.
Yes.
Serial number 80 Vinay Kirti.
None appear, release this matter of 2 weeks.
81 Manjunath Prasad.
21. When do you want, mister?
Monday.
Huh?
Monday.
What is that matter?
Monday, they have not considered the representation suspended by the court, saying that she is not eligible for the post regarding age and age.
Who has to answer?
The government has to answer.
Yes, we'll have it on 10th. Yes.
82 Balraj AC.
Yes.
Consider my representation and came my lord, page 41.
For what?
Promotion, my lord, from post of junior engineer to the post of assistant engineer.
Who has to consider?
Second respondent need to consider, my lords. If he gives up his prayer, B, my lords, for consideration of the representation, I have no objection. It will be considered in accordance with law.
Yes. Where is your representation?
Election K, page 41.
ENL vacancy idea, you are entitled
Promotion
for
to the
that.
AEE post.
Promotion, how can you seek, mister?
Hyderabad, Karnataka postal 8%.
I have been overlooked without any reason.
Annexure?
Annexure K, my
Page 41.
What is your representation?
And it's to extend the benefit of Article 371J and to consider my.
Yes. In which department?
Urban development, urban drainage,
Yes.
Karnataka.
In this writ petition, petitioner sought following relief. The case of the petitioner that. No, you are claimed under the 371J region.
Please, madam. 371J.
Case of the petitioner that petitioners are native of Hyderabad, Karnataka region. They were appointed as a junior engineer on 8/6/2021, working in second respondent board. The petitioner are entitled for promotion to which post, mister?
Assistant executive engineer, my lord.
From which cadre?
From the care of junior engineer. 20% is
Working
reserved.
as an assistant executive engineer, they are required to, they are eligible to be promoted as. No, now you are working as
Junior engineer, my lord.
junior engineer. Promotion, no?
Promotion assistant executive engineer, my lord.
Yes, working as a junior engineer. They are, where is that C&R rules that you are entitled to promotion to that junior engineer to assistant executive engineer?
It's not that he will reject it.
Where is that C&R? First show me that.
I explained my petition.
Since he has claimed under Hyderabad, Karnataka, RPC.
No, first
for
whether
RPC.
this is the feeder cadre I have to say.
Can't be.
Yes. Promotion from that cadre of junior engineer.
No, it will be rejected.
ಯಾವ ಪೋಸ್ಟಿಗೆ? ಅಸಿಸ್ಟೆಂಟ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರ್. ಎಸ್. They are entitled for promotion to assistant executive engineer under Hyderabad, Karnataka region. Since their case has not been considered, petitioner has submitted a representation, annexure K, dated 23rd September 2025. Since the respondent has not considered the representation submitted by the petitioner is before this court. Learned counsel appearing for respondent number 2 submitted that if this court grants some reasonable time, representation submitted by the petitioner via annexure K do consider in accordance with law. In view of the above, without expressing any opinion on the merit of the case, respondent number 2 is directed to consider the representation within 3 months from date of first. Yes.
Serial number 83, Bola Vedavasa Shanai.
Yes, none appear.
That's one observation in that. He has given up his prayer to my lords. That may be noted it out because he has specifically asked for the direct mandate. That may
Yes,
be noted.
sought for following relief only prayer A akade.
Much obliged.
Yes.
84, Basavaraja Patel GK.
84.
For mandamus,
For what?
representation.
83.
83. Yes, read this matter on 9th. Yes.
84, Basavaraja Patel.
None appear, leave this matter of 4 weeks.
85, Vadavadagi Yuvaraj.
Withholding? Now, what is that matter, mister? Substitution challenge. Yes, you are getting a salary. Yes. Leave this matter on 25th. Yes.
86, M. Nagarajan.
Last B group, 88 last B group.
Yes, what?
88 last B group, in final hearing.
ನಾವೇ ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀನಿ ಬಿಡಿ ಅವ್ರು ಮಾಡೋದು.
ಇದು ಕೊಟ್ಬಿಡ್ತೀನಿ ನಾನು ಕೋರ್ಟ್ ಕಾಪಿಗೆ ನೋಡೋದಕ್ಕೆ ಅವರು.
ಆಯ್ತು, ಕನ್ಸಿಡರ್ ಮಾಡಿ. ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿ ಅಷ್ಟೇ. ಆಮೇಲೆ ನಾವು ರಿಜೆಕ್ಟ್ ಮಾಡಾದ್ಮೇಲೆ ವಿಲ್ ಎಕ್ಸಾಮಿನ್ ವೆದರ್ ದಟ್ ರಿಜೆಕ್ಷನ್ ಇಸ್ ಕರೆಕ್ಟ್ ಆರ್. Who has to consider? Mangalore University served unrepresented. What to do? Which is that? ಅವರಿಗೆ ಗೊತ್ತು ಯಾಕೆ ಸುಮ್ಮನೆ ಎಂಗೇಜ್ ಮಾಡಿ ಲಾಯರ್ ದುಡ್ಡು ಕೊಡೋದು ಕನ್ಸಿಡರ್ ಮಾಡ್ಕೊಂಡ್ಲಿ. Then why you have to keep this pending? Even they are not interested. Annexure J. Yes, this petitioner has sought following relief. The case of the petitioner that you are all appointed as what, mister?
Typist or office assistant. Job typist and office assistant on.
When?
Since 20 to 28.
Petitioner was appointed as a job typist in respondent university in the year 1998 to 2005. Between 98 to 2005 on temporary basis. Even after they have completed 10 years, their service has not been regularized. They have submitted a representation annexure 164 wide annexure J. Annexure J series dated 3/9/2025. Since their representation is not considered, they are before this court. The respondent to university is served unrepresented. Since the representation submitted by the petitioner has not been considered, it is suffice for this court to direct the respondent to consider that representation submitted by the petitioner in accordance with law as expeditiously as possible, not later than 6 months from date of first of copy of this. ಆಯ್ತು, ಅವ್ರು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಅವ್ರು ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರೆ ಯಾಕೆ ಬೇಕು ನಿಮಗೆ? ಅವ್ರು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ದೆನ್ ವಿಲ್ ಎಕ್ಸಾಮಿನ್. ಎಸ್ Yes, in addition, petitioner is also permitted to submit additional representation enclosing all the documents.
87,
With-
Pawan Kumar.
Wait. The respondent is directed to consider that representation along with that additional representation within 3 months from the date of submitting additional representation. If you are not submitted, then limitation, yes.
87, Pawan Kumar.
What is that interim order? Till you are working? Yes, till consideration of that representation, the interim order granted by this court will continue.
87,
Yes, Mr. Ready? Yes. 4th, 5th ಆಗಲ್ಲ 18th. ಹಿಂಗೆ ನನಗೇನಿಲ್ಲ ಡೇಟ್ ಕೊಡೋದಕ್ಕೆ, ಸುಮ್ಮನೆ 6:30 ನೀವು ಕಾಯ್ಬೇಕು, ನಾನು ಕಾಯ್ಬೇಕು. ಅವ್ರೇನು ಕೇಳ್ತಾ ಇಲ್ಲಲ್ಲ, 18 ಅಂದ್ರೆ ಸುಮ್ಮನೆ ನಿಂತಿದ್ದಾರೆ, ಹಂಗಾಗಿ ನೀವ್ ಯಾಕೆ? See, even Govind Raj knows, even though he has an urgent, he knows the problem of the court, therefore he is, yes, that's why that they are all service lawyers. Yes, 16. ಅದಿದೆಯಲ್ಲ. Then we'll see that we'll have it on 9th. Let us. 9th, 10th, yes.
88, Panduranga Nayak.
This case appear for a respondent, second respondent, please, my lord. It may be taken on 9th, please, 9th or 10th, please.
Wait. Yes. Yes, Mr. Giri Kumar, ready?
My lord, 9th or 10th, my lord, 9th or 10th, I am getting instructions.
9th. Dismissal ಅಲ್ಲ ಎಲ್ರಿ, ಬೇರೆ ಮ್ಯಾಟರ್ ಮುಟ್ಟಾಗ dismissal. ಆಯ್ತು ನೋಡೋಣ. 9th is that next week? Yes.
Please, sir, therefore.
Yes. Fast over.
That's 24.
9th.
Fast over matter, serial number 11, Ingalaki Kotappa.
My lord, I am for 2232 petitioner. I was attending court in Mysore. Just I came. Pardon me for not wearing.
No, ಏನ್ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ನೀವು?
Pardon?
ಏನ್ ಕೆಲಸ?
My lord, ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅವರು ನಾವು KAT ನಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ವಿ, ಅದು ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. My submission is KAT or the respondent number 1 who has to give the appointment order didn't consider for 2 years. During
ಯಾವ ಪೋಸ್ಟಿಗೆ?
motor vehicle inspector.
ಮೋಟರ್ ವೆಹಿಕಲ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ನೀವು ಕೇಟಿಗೆ ಹೋಗ್ಬೇಕಲ್ಲ?
KAT ಹೋಗಿ ಆಯ್ತು ಮೈ ಲಾರ್ಡ್. ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರೆ ಅಲ್ಲಿ 2 ವರ್ಷ ತನ ಇವ್ರು ಎಂಡಾರ್ಮೆಂಟ್ ಕೊಡ್ಲಿಲ್ಲ, ಅದಕ್ಕಿಂತ ಪೂರ್ವದಲ್ಲೇ ಹೋಗಿದ್ದು. 2023ರಲ್ಲಿ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದು ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಕಮಿಷನರ್ ಹತ್ರ ಇದೆ, ಆರ್ಡರ್ ಕೊಡಿ ಅಂತ ಹೋಗಿದ್ದೆ ವಿನಃ, ಬಟ್ ವಿ ಹ್ಯಾವ್ ನಾಟ್ ಚಾಲೆಂಜ್ ದಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಇಶ್ಯೂಡ್ ಇನ್ ದ 2025.
ಒಂದ್ಸರಿ ನೀವು ಅಲ್ಲಿ ಹೋದ್ಮೇಲೆ ಕೇಟಿನೇ ನಿಮ್ ಜುಡಿಶಿಕ್ಷನ್ ಇಲ್ಲಿ
ಇಲ್ಲ ಮೇಡಮ್, ದಿಸ್ ಮೈ ಲಾರ್ಡ್, ದಿಸ್ರಲ್ಲಿ ನಾವು ಅವ್ರ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿದೀವಿ.
ಯಾನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು ಕೂಡ ಪೋಸ್ಟ್ ವಿಚ್ ಯು ಆರ್ ಸೀಕಿಂಗ್ ಇಟ್ಸ್ ಎನ್ ಸಿವಿಲ್ ಪೋಸ್ಟ್, ಯು ಹ್ಯಾವ್ ಟು ಗೋ ಟು ದ KT.
KAT ಹೋಗಿದ್ದಾಗಿದೆ.
ಅದು ಒಂದ್ಸರಿ ಹೋದ್ಮೇಲೆ ಈ ಮಾಡಿದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಡೈರೆಕ್ಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟಿಗೆ ಹೋಗ್ತೀರಾ. ಆ ಕೇಸೇ ಬೇರೆ, ಈ ಕೇಸೇ ಬೇರೆ. ಯು ಗೋ ಟು ದ KT. ನಿಮ್ಮ ಆಲ್ ಗ್ರೀವೆನ್ಸ್ ಒರಿಜಿನಲ್ ಜುಡಿಶಿಕ್ಷನ್ ಇಸ್ KT. ಫಸ್ಟ್ ಇನ್ಸ್ಟೆನ್ಸ್ ಇಸ್ KT. ದೆನ್ ಇಟ್ ವಿಲ್ ಕಮ್ ಟು ದ ಹೈ ಕೋರ್ಟ್.
Okay.
Government, I will be permitted you to go to that KT. Yes. Government advocate at outside submits that the matter is related to that civil post, petitioner has to approach Karnataka Administrative Tribunal in view of the judgment of apex court. The above writ petition is disposed of, reserving liberty to that petitioner to approach KT in accordance with law.
19, Anusha L.
Case for compassionate appointment.
Yes. What is this? Complaint. Yes. Issue notice. Government either
Except
government
R3.
advocate to director take notice for 1.
Except
2.
R3, my lord.
No, that 3 and 4 on executive
government.
officer rural drinking yarada.
Government is. Except
Yes.
3, except
Yes,
R3.
government advocate is directed to take notice. Chief engineer, Panchayat Raj, I think Panchayat Raj, they are not taking. 1, 2, and 4. Nodi, the executive engineer, rural drinking water supply,
ಅದೆಲ್ಲ government
4, 5, 6. Director to serve 2 sets of copies, issue emergent notice to 3 and 7. Yes.
Cell number 23, Abhishek K for petitioner.
24. Yes, what is this, Mr. Abhishek? In which department? Annexure? Where is that appointment order? 23, yes. ಆಯ್ತು, ಮುಂದಿನ ಆದೇಶದವರೆಗೆ ಕೂಡಲೇ 3 ವರ್ಷದಲ್ಲಿ ಮೀರಿದ ಅವಧಿಗಾಗಿ ಅಥವಾ ಮುಂದಿನ ಆದೇಶ. ಇಟ್ ಇಸ್ ಎನ್ ಪ್ಲೆಜರ್ ಡಾಕ್ಟ್ರಿನ್. That it is a pleasure.
That is not what I am using. I don't have any vested right not to but they are pointing out, donating, not any reason.
No, it is until further orders. See, we said pleasure doctrine cannot be invoked without any reason. My judgment has been set aside by the division bench. What to do that? We cannot be. I have referred that and it is set aside. Now that pleasure can be invoked, it cannot be. Don't want to make my judgment again set aside by the division bench. Yes, now that your appointment says that until further orders, now they have been replaced. We'll take notice. Which is that impugn order now? Yes. ಬೆಂಗಳೂರಿನ ಉತ್ತರ ತಾಲೂಕು ವಿದ್ಯಾರ್ಥಿ ಪರಿಷತ್ ಹಿಂದೆ ನಾಮನಿರ್ದೇಶನಗೊಂಡಿದ್ದ ಕಾರಣ ರಾಜ್ಯ ವಿಚಾರಣೆಯಂತೆ ನಿಮ್ಮ ನಾಮನಿರ್ದೇಶನ ಆದೇಶ ತಕ್ಷಣ ಜಾರಿಗೆ ಬರುವಂತೆ ರದ್ದುಗೊಳಿಸಿದೆ. That power is there when you have been appointed. I will have it tomorrow. We'll examine tomorrow. Yes.
Serial number 24, Vardhan Chennai K for petitioner.
Office objection is not complete.
Yes, I already copy, my lords. Yes.
ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಿ ಇಲ್ಲಿ? ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಾರೆ ಮಿಸ್ಟರ್ ಪ್ರಭಾಕರ್? ಆಯ್ತು, ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು ಇಲ್ಲಿ?
ರಿಟೈರ್ಮೆಂಟ್.
It is under scheme. It is appeal remedy is there.
Yes. In this petition, petitioner sought following relief. Challenging the compulsory retirement order. In what is this C&R or regulation, Mr.?
It is under regulation. It is under the scheme.
Under the respondent regulation, petitioner has in a remedy of appeal. Learned counsel appearing for respondent number
1 and 2.
1 and 2 has submitted that petitioner by invoking that appellate remedy, he has filed an appeal. Please. Yes, he has filed an appeal. In view of the above, the relief sought by the petitioner will not survive for consideration. If the petitioner has filed an appeal, the appellate authority is directed to consider the same in accordance with law. Wait, let him. Yes. No, that you have to be sought in that appellate court. When appeal is pending, I can't grant interim order, Mr. You see. No, Mr. Always there, Mr. Why do you want to repeat? It is. No, I will say, yes.
It is a civil employee.
Yes, he has filed an appeal, therefore he is withdrawing this writ petition, pursuing his remedy before the appellate authority. Accordingly, writ petition is disposed of. The appellate authority is directed to consider the same in accordance. After that, you have a remedy, don't worry. Yes. Yes,
Serial number 41, Srinivasa K for petitioner, Nagaya.
41, yes, after 3 weeks. 44, any other? Sir, 44 ಏನಾಯ್ತು?
4 weeks ಅಂತ
Interim order ಇದ್ರೆ ಕೊಡಿ. Yes, interim order if any is extended till next date of hearing. Hearing matters of 2 weeks ಮೇಲೆ date ಕೊಡಿ. Yes.
Serial number 31, my lord, where the transfer was sought by the petitioner, my lord, sir has appeared before for the petitioner.
Tomorrow
Now,
it can be.
it can be taken tomorrow itself, my lord. A letter has been received where the post of that college is still vacant, it seems, my lord. 2 posts are vacant. So D group, he can be
Can
accounted.
be given permission.
And I will give the copy of that letter by the.
ಅದೇನಾಗಿತ್ರಿ ಅದು?
ಅದು next week ಅಂತ ಹೇಳಿದ್ರು ಸರ್.
ನಾಳೆ
31.
Affidavit ಹಾಕಿ ಅಂತ ಹೇಳಿದ್ರು.
ಯಾವಾಗ?
Tomorrow it can be.
Day after tomorrow. ಅದು ಸೈನ್ ಆಗಿ ಹೋಗ್ಬಿಟ್ಟಿದೆ ಅಂತ. ಅದನ್ನ day after tomorrow ಮಾಡಿಸ್ಬೇಕು.
My lord, serial.
ಆಯ್ತು, ಒಂದು ಡೇಟ್ ಕೊಡ್ತಾರೆ. Saturday, if you want, I will give it. I think this bench is not sitting. Yes. This bench is not sitting, madam. Why do you want to trouble other court? I'm not sitting on Saturday. It will be there next week. Next week, one date. Which serial number?
92 or 94.
92 and 94. 12th.
My lord, serial number 95, regular second appeal.
I will give a date in Friday.
My lord, your lordship may call it on Friday because.
Not this Friday, 6th or 13th.
Lord, only additional question of law has to be framed. I made a proposition of law.
No, we'll have it on 6th Friday. 6th Friday, yes.
My lord, for orders, your lordship.
No, on that day is only an RSA. You can mention that, please. 90. Yes, D matters. 23rd. Yes.
Final hearing, 89, adjourn. 91, 23, 91, adjourn. 93, adjourn.
Sir, 92 date ಕೊಟ್ರಾ? Sorry, sir.
ಮಧ್ಯೆ ಕೇಳಬೇಡಿ ಮೇಡಮ್ ಅಲ್ಲಿ.
Sorry, sir. Sorry.
92, 12, 96, adjourn. 97.
ಸರ್ 13th ಹಾಕ್ತೀರಾ ಸರ್?
adjourn.
97 13th ಹಾಕ್ತೀರಾ?
98 ಯಾರು ಹೇಳಿ? 27 of February ಯಾವುದು? 99 adjourn. 100 adjourn. ಹೇಳಿ VCL ಯಾರು?
ಸರ್ 97 ಸರ್.
ಹೇಳಿ ಮೇಡಮ್. 13th ಅಲ್ಲ, 27.
20. ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
20.
92 ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಸರ್?
ಹೇಳದ್ನಲ್ಲಮ್ಮ 12/2 ಅಂತ ಅವಾಗ್ಲೇ. 6/2 ಸಾಹೇಬ್ರೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಯಾವ್ದಾದ್ರು ಶೀಟರ್ ಡೇಟ್ ಕೊಡಮ್ಮ. ಎಲ್ಲ ನೋಡ್ತೀನಿ. ಹೇಮಲೇಖ ಮೇಡಮ್ ಅಂದ್ರು ಅದಿದೆ, ನೋಡ್ತೀನಮ್ಮ. ಇವಾಗ ನಾನು ಕೇಳ್ಬಿಡಿ, ನನಗೆ ಯಾರು ಮಾಡಿಲ್ಲ, ನಾನು ಯಾರು ಹೇಳಲ್ಲ. ನಾಳೆ ನಾನೆಲ್ಲ ನಾನು ಬೋರ್ಡ್ ಕೆಲಸ ಬೋರ್ಡ್ ಮಾಡ್ತೀನಿ. ನನ್ನ ಕೆಲಸನೇ ಇನ್ನೂ ಅರ್ಧ ಗಂಟೆ ಇದೆ. ನನ್ಗೆ ಅದೇ ರೀ ನನ್ಗೆ ಯಾಕೆ ನಾನು ಸಾಹೇಬ್ರಿಗೆ ಅಸಿಸ್ಟ್ ಮಾಡ್ಲಾ ಬೋರ್ಡ್ ಅವ್ರಿಗೆ ಅಸಿಸ್ಟ್ ಮಾಡ್ತಾ ಕೂತ್ಕೊಳ್ಳ ಅವನೇ ಹೇಳ್ತಾರೆ ನೀವು ಕೇಳ್ತೀರ ನನ್ ಕಷ್ಟ ನಾನು ಇನ್ನ ಸಾಹೇಬ್ರಿಗೆ ಅಸಿಸ್ಟ್ ಮಾಡ್ಬೇಕಲ್ಲ ಪೇಪರ್ ಸಿಗ್ತದೆ ನನಗೆ ಯಾಕೆ ಎಷ್ಟು ಡೇಟ್ ಮಾಡಿ ಶ್ರೀಧರ್ ಈಗ ಒಂದೇನಾ ಅದೊಂದೇ ಅಲ್ಲ ಸರ್ ಶ್ರೀಧರ್ ಕೊಡಿ ವಿಶ್ವ ಸೀರಿಯಲ್ ನಂಬರ್ 23 WC2280 WC2280 of 26 Abhishek K. Abhishek K for petitioner. Office objection post ಮಾಡಿದೆ preliminary hearing post ಮಾಡಿ ಪಾರ್ಟಿ ಮಾಡ್ತಾರೆ ಸಬ್ಜೆಕ್ಟ್ ಹೇಳು ಇನ್ಯಾವುದು ಯಾವ ಸೈಡ್ ಬರ್ತದೆ ಹೋಗಿ ಕೇಳ್ಕೋಬೇಕಲ್ಲ ಟೈಪಿಂಗ್ ಗೆಟ್ಟಿದ್ದಾರೆ ನಮಗೆಲ್ಲ ಬೇರೆ ಕೆಲಸ ಇದೆ ಏನಂತ ಅಷ್ಟೇ ಬಿಟ್ಟ ಓಕೆ ನನಗೆ ಕೊಟ್ಟು ಬರ್ತೀನಿ ನಾನು ಅರ್ಜೆಂಟ್ ಅಂದ್ರೆ